With your lordship's kind permission. But this impugned order is issued.
Just give all the memos. Come on,
My lord,
security list.
tomorrow, my lord, there is an urgency in the matter.
For 2:30, my lords.
Next week.
See, I'm getting around 80 matters listed every day.
My lords.
Okay, beyond that, I can't help it.
My lords, what happened is, my lords, notice has been issued for disposition, my lords. Date is fixed for tomorrow, my lords. Notice has been issued on 16th, my lords.
KLR, LR matter adre day after tomorrow.
My lords, for 2:30, my lords. 2:30, because my lords, tomorrow is a date fixed for disposition, my lords. Because the notice has been issued on 16th of this month
Disposition ಇದ್ರೆ ಕೊಡಿ, ತಗೊಳ್ಳಿ ಮತ್ತೆ.
for 2:30, my lords.
End of the list.
Much obliged.
End of list.
ಕೊಡಿ ಬರುತ್ತೆ, seniority wise ಬರುತ್ತೆ.
Could
It's one matter for being.
Members
Members,
ಎಲ್ಲ
my lords.
My lord,
There is a bank attachment, my
my
lord.
honorable court minutes on 11/9/2024. Land acquisition KDB, my lords.
There is a bank.
Was disposed on, this matter was disposed on 11/9/2024. My lords, we have challenged the notifications, my lords, issued by the KDB 28/3 and 28/4, my lords. That has been, your lordships are dismissed. In the due course, my lords, we have filed a writ petition, amendment of writ petition, wherein we have sought for alternative remedy to consider our claim under 2013 Act. My lords,
Being spoken to ಬರಲ್ಲಪ್ಪ, ನೀವು ರಿವ್ಯೂ ಹಾಕೋಬೇಕು, ಇದಲ್ಲದ್ರೆ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ. ಸೈನ್ ಆಗಿ ಹೋಗಿದೆ ಅಲ್ವಾ?
on that day, lordships, the judgment was dictated in the office. My lords, your lordships has said that the observation would be made to that effect.
No, I have never, last roster, I have never dictated even a single judgment in the chambers. All judgments have been open court.
No, my lords, on 11/9, there are series of matters. First matters, your lordship dictated the order here itself. Second, connected matter, my lords. In that matter, my lords, your lordship says
That one.
that one.
No, I told you it will be dismissed. See,
No, it was dismissed, my lords. My alternative prayer to consider our claim under 2013 Act.
review ಹಾಕ್ಬೇಕಾಗತ್ತೆ. Because judgment is released ಆದ್ಮೇಲೆ being spoken to ಹಾಕ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Judgment is there, my lords.
Judgment release ಆದ್ಮೇಲೆ ಬರಲ್ಲ.
I'll just file a review.
ನೀವು ಐದರ್ ಅಪೀಲ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ ಅಥವಾ ರಿವ್ಯೂ ಹಾಕ್ಬೇಕಾಗತ್ತೆ. ನಿಮ್ಮ ಇಷ್ಟ ಅದು. ನಾವು we are not suggesting anything to you.
I'll do the review.
My lord.
Tax ಎಲ್ಲ ಬರುತ್ತೆ ಕುಡಿ.
Good.
My lord.
See, I'll get 80 matters posted. Reference will be given to preliminary hearing. Yes, give it.
Kodi memo.
Kodi. Tax ಆದ್ರೆ ನಾಳೆ ಬರುತ್ತೆ ಸರ್. See, on seniority list ಬರುತ್ತೆ ಸರ್. I can't promise anything. ಕೊಡಿ, memos ಕೊಡಿ.
Members ಎಲ್ಲ ಕುಡಿ.
Memos ಕೊಡಿ.
My lord, they have sought an attachment of property.
Memos ಕೊಡಿ ಅಪ್ಪ.
But my lords, tomorrow.
Sir, seniority ಮೇಲೆ ಬರುತ್ತೆ ಸರ್. We can't really promise you anything. I'm getting 80 matters posted every day. I can't handle more than that.
ಕುಡಿ ಸರ್.
My lord, it is a
ಬೇಡ ಬಿಡಿ ಅವ್ರು.
assessment of the respondent has issued.
ಕೊಡ್ರಿ ಮೆಮೋನ, seniority wise ಬರುತ್ತೆ.
ಕುಡಿ ಸರ್.
ನಾಳೆ copy, sir.
Matter involves extreme urgency, my lord. Though there is a stay order, they have been putting.
You file contempt then. You file a contempt if the interim order is violated. Yes, kariri. Adjournment kariri.
My lord, there are two connected matters listed on 24th.
Re ಕೊಡ್ರಿ.
Listed on 24th of October.
Adjournments, B group matters, 44, 45.
Not 45.
Yes,
Not in a connected matter, two petitioners have died, my lord, which they informed.
yes, 2 weeks.
Petitioner 6 and 7. I will take steps. my lord. 45.
2 weeks, 46 to 52. 46 to 52 adjournments. 53 to 59.
58, my lord, serial number 58.
Yes, 2 weeks.
Obliged.
2 weeks.
50? 53 to weeks.
53 na? ಆಯ್ತು, 2 weeks.
60 to 64.
Serial number
61 ready.
60?
Serial number 62. My lord, pleadings are completed. You know, the income tax. Lordships may kindly have it on Thursday, my lord.
2 weeks.
61 ready. Urgency.
ಯಾವ್ದ್ರಲ್ಲಿ?
61.
61 ಅಲ್ಲ? ಅವ್ರು
ಅಲ್ಲ, ಯಾರು
62 ಹೇಳಿರೋದು.
ಯಾರು ಕೇಳ್ತಾರೆ?
We have the commission ದಯವಿಟ್ಟು ಕೊಡ್ಬೇಡಿ, ಅವ್ರು time ತಗೊಂತಾರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿ?
53.
53 ಅವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ತೀಯಾರಮ್ಮ, ಟೈಮ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Sorry. They are taking time, your honor.
The other side is objecting, we are not granting time. That's all. Yes. 53 ಬೇಡ.
53 no adjournments. 60 to 64. 62 ಆಗಿದೆ. 65 to 72.
Well, 68 minutes.
ಹಾ,
My lords, 3 weeks time, my lords.
Yes, 2 weeks.
My lords, interim order may be extended.
Interim order ಇದೆ extend ಮಾಡಿ ನೋಡ್ಬಿಟ್ಟು.
68.
68.
Serial number 71, my lord.
Hmm,
Appearing for petitioner, 2 weeks time.
2 weeks.
Interim order, my lord.
ಇದ್ರೆ extend ಮಾಡಿ.
My lord, 71,
ಹಾ,
it become infractions because
ಬರ್ರಿ
Ashray-
71 ಯಾರು?
71.
Prakash Reddy.
it become infractions, my lord. Already we have given endorsements. Ashray Yojana, already the Ashray Yojana order has not
The
been
matter is
challenged.
called, you make a mention because government advocate is stating that the matter has become infructuous. We'll examine it. 71 no adjournment. Yes.
Please.
51, man. 51.
ಹಾ,
This is also, my lord.
Hearing ಎಲ್ಲಾರ application.
51.
51. ಕೊಡ್ಬೋದಾ ಗೌರ್ಮೆಂಟ್?
51, my lord, it is appeal provision, my lord. Mutation challenge before this honorable court, my lord. The appeal provision is there
You are for whom?
Petitioner, respondent death ಆಗಿದೆ.
before the AC.
You will examine it when the matter is called.
73 to 77. 78 to 80.
Yes, ಮುಂದೆ challenge ಮಾಡ್ತಾರೆ.
Jersey number 59. 59 ಯಾರು ಮೆಮೊ ಹೋಗ್ಬಿಟ್ರು.
59 ಆ?
Serial number ಒಂದು ಎಲ್ಲರೂ ನೋಡಿ. Serial number 59.
Who is
Please,
this?
my lord.
Mubarak Begum, ah?
Already we have issued a Sagodi chit, my lord. Mandamus they are seeking, my
Right,
lord.
dismissed as withdrawn. Withdrawn, ah?
Yes, sir.
Dismissed as withdrawn. They have filed application,
Oh,
sorry, memo for withdrawal.
dismissed as withdrawn.
Serial number 4, my lord.
Hmm.
The person in to senior, my lord. Any 1 make day may grant, my
So
lord.
withdrawn ಬರೆಯಕ ಗೊತ್ತಾಗತ್ತಲ್ಲ ಮೇಡಮ್?
Wait.
The
Serial-
advocate for the petitioner, ಬರ್ಕೊಳ್ಳಿ, the advocate for the petitioner has filed a memo dated so and so with a request to withdraw the writ petition. Full stop. Memo is taken on record. Writ petition is dismissed as withdrawn. ನಿಮ್ದು ಸುಮಾರು ತಪ್ಪಾಗ್ತದೆ, ನಿಮ್ಗೆ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದು ಗೊತ್ತಾಗ್ತಲ್ಲ ಇದ್ರೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ, ರೆಕಾರ್ಡ್ ಆಗಿರುತ್ತೆ. ನೋಡ್ಕೊಂಡ್ ಮಾಡಿ. ಏನಾದ್ರು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಬೇಕಿದ್ರೆ ಡಿಕ್ಟೇಷನ್ ಕೊಡ್ಬೇಕಾದ್ರೆ ಕೇಳಿ. ಗೊತ್ತಾಯ್ತಾ? Yes.
Serial number 4, my lord. Person in-
Four mention when it is called.
One submission, my lord. Warning list is serial number 6 ನಲ್ಲಿ NOC ಬಂದಿದೆ ಸಮ.
Warning list ಅಲ್ಲಿ we are not taking it up now.
Yes.
Warning list regular list ಅಲ್ಲಿ ಬಂದ. It is, warning list is given to you so that you are prepared in the matter and don't seek any adjournment.
Serial number 30, my lord.
30 mention when it is called. Only B group and above adjournments are given. Yes.
Serial number 1, Chandrasekhar HB, being spoken.
I'm appearing on behalf of petitioner, my lords.
Hmm.
Lords, village name, my lords, by oversight, my lords, has been mistaken.
Judgment ಆಗಿದೆಲ್ಲನ್ರಿ?
Please, my lords.
Review ಹಾಕೊಳ್ಳಿ. Being spoken to ಹಾಕುತ್ತಾ ಅಥವಾ correction ಗಾಯೇ ಹಾಕೊಳ್ಳಿ.
Hmm.
Clerical error ಏನಾದ್ರು ಇದ್ರೆ being spoken to ಬರೋದಿಲ್ಲ.
150.
The judgments having been, the judgment in the instant writ petition has already been passed.
Also issued. And
And
also issued.
certified copy has been issued, and certified copy has been issued, has already been passed and certified copy has been issued. Full stop. The question of entertaining the writ petition once again for being spoken to in single inverted comma for being spoken to does not arise. Yes.
Number 2, Mohan Kumar D.
Appearing for petitioner, my lords.
Hmm.
Lords, in this matter, my lords, my lords, last time also they have sought for the same thing, my lords. This is a matter for remind, my lords. The district commissioner has passed the 2 orders, my lords. In this matter. In 2.1, my lords, first order pass ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ DC. After that, they have appealed before this honorable court. During the pendency of the matter,
Respondent number 2, is it?
respond number 5.
ಯಾವ್ದ್ರಲ್ಲಿ? ಯಾವ್ದ್ರಲ್ಲಿ respondent number 5?
Respond number 2, my lords, they are representing.
ನೋಡ್ರಿ, your other writ petition itself is an objection for this, the first writ petition.
ಅಲ್ಲ ಸ್ವಾಮಿ ಎಲ್ಲಾ ಕೊಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡಿದೀವಿ
Let
ಅವ್ರು
me see
ಕೊಟ್ಟಿರೋದು
what the writ petition is about. What is the writ petition about?
ಮಲಾಡ್ಸ್ The writ petition is challenging the order passed by the district commissioner, my lords, regarding Kata transfer, my lords. My lords, in the year 2019, my lords, the DC has passed an order. My lords, kindly come to page number 20, my lords. In revision petition number 81 of
Look
81
the
bar
page.
16.
One
sir.
second, please. The procedure, petition has been gone to enough terms. Comment?
Yes, madam. On the ground of
Now,
delay.
respondent one, once he passes an order,
Yes, madam.
can he recall his own order?
No, only under extraordinary.
One nimsha, I'll hear you. Without hearing you, I won't pass any orders. I'm asking the government specifically.
Madam.
Because respondent number one is deputy commissioner.
Yes, madam. Deputy
Does he
Commissioner
have the
has-
power to recall his own order?
No,
Huh?
no. But thing is, here the AC has passed without passing any order on delay aspects. That is the observation made by the DC. After lapse of 17 years, they want to cancel the mutation entry. The delay aspect has not been answered by the AC. That's why.
Okay, once he has passed an order, can he recall the said order? Has he passed the earlier order?
No, this is. Yes, madam.
See, did he pass an order in RA number 22 of 2015-16?
No, this is the order under 136(3) agreed by the AC's order, madam. Not the. Challenging the order passed by the AC, DC has the reject the AC's order because AC has failed to pass an order on delay aspect. This is not the review, madam. Agreed by the AC's order, appeal as review petition is preferred by the DC.
Once an order has been passed, my lords, it has become factus officio, my lords.
Now,
Yes.
which was the first order?
AC order, madam.
Yes. My lords, first order is
Page 19,
at page 20, my lords.
operative portion is at 19.
First DC has passed an order in 19 January 2019, my lords. It is in page
Okay,
20.
who was the owner of the property first?
My lords, petitioner Lagumaka is the owner of the property.
Huh?
Lagumaka.
No, not Lagumaka. Her father-in-law was the owner of the
Yeah, yes,
property,
my
right?
lords. Our father-in-law was owner of the property.
What is the name of the father-in-law?
Siddhappa, my lords.
Correct, Andre?
But I've produced the sale deed also, which is at
She is the second, she is the wife of so and so. She is not a resident of this village also at all. She is not the wife of the late so Siddhappa, mentioned Tata is
Okay, originally,
pending between the parties in the civil court also.
originally the property stood in whose name?
The petitioner's, second petition,
Come.
you can see. It is, Chikka Sallurappa.
Huh?
Chikka Sallurappa.
husband of Akkamam,
Property stood in the name of Chikka.
Sallura.
And subsequently, it was transferred in the name of legal heirs.
Property stood in the name of Chikka Sallurappa, is it?
Let's kindly see the say, I have produced the sale deed. It is at page number 12, my lords.
RTC ತೋರಿಸ್ರಿ. Okay, we'll call it next week. No further adjournment.
Let's see, my lords, one submission. Let's, if this is the case, my lord, this is a matter of remand, my lords.
Hey, show your bona fides, I say, both of you. Government, get the records and make your submission. I'll call it on Monday. At the request of respondent, call on Monday. Monday date put.
Kumar, Jesse?
Petitioner is challenging the order passed by the respondent number 3 and 4. Sorry, 2 and 3, my lord. My lord, the father.
What is it? ಏನಂತಾಗಿದೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಎಂಟ್ರಿ ಮಾಡಿರಲಿಲ್ಲ ಸರ್. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ಗೆ ಇದಾಗಿತ್ತು, ರೆಸ್ಟೋರ್ ಆಯ್ತು ಡಿಸ್ಮಿಸ್.
Yes, AG access notice for respondents 1 to 4, issue emergency notice for other respondents 5 and 6.
ಎಂಟ್ರಿ ಮಾಡೋ ಸ್ಟೇ ಮೇಲೆ.
Yes, next case.
Oh, P. Ramesh.
Personal, personal inquest to senior, kindly have it next week, my lord. Already informed to other side, the Ramesh.
My lords, a date may fix, my lord.
Right, at the request of respondent number,
Respondent number 5, Rama.
respondent number 5, call on Monday date put.
7, you connected matters also Monday, sir. 28 petition, you connected matters.
My lords, interim order is there in first.
The interim order, if any, is extended till next date of hearing.
Much of.
28-10.
First matter matra na interim order. Right, first matter matra interim order. Second
Right.
matter lila.
Number 5. Madi Narayan.
Kindly have it on Wednesday, my lord.
Huh?
Kindly have it on Wednesday, day after tomorrow.
Monday, next Monday barutta. The request of petitioner call on Monday.
28-10. 6. D. Balakrishna Shastri.
Lord, seek an adjournment. Seek an adjournment in this meeting.
The request of petitioner call after 4 weeks.
7. Girish B. Baladare.
ನೋಡ್ರಿ 4 weeks ಅಲ್ಲ ಈ ತರ ಹೋಗುತ್ತಲ್ಲ, ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಯಾರು ಕೇಳ್ತಾರ, ಅವ್ರು ಬಂದ್ ಮೆಮೋ ಕೊಟ್ರೆ ಮೆಮೋ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ಬಿಡಿ, ನೋಟ್ ಡೌನ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ರಿ ಯಾರ್ಯಾರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂತಾರ, ಈಗ ನಾನೀಗ ಇದನ್ನ 4 weeks ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದೆ. See, there are so many memos being moved, we don't have the time to see. We are getting around 80 to 100 memos every day, and we are not able to post the cases. Now, after getting it posted, everybody start taking adjournment. ಯಾರ್ಯಾರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳ್ತಾರೆ ಎಲ್ಲ 4 ವಾರ ಮುಂದೆ ಹಾಕ್ತೀನಿ. ಪಟಿಷನರ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಇನ್ನು ಮೇಲೆ ಅದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. 4 ವಾರದ ಮುಂಚೆ ಅದನ್ನ ಆ ಮೆಮೋ ಎಂಟರ್ಟೈನ್ ಮಾಡಂಗಿಲ್ಲ. ಮೆಮೋ ಮೂವ್ ಮಾಡಿದ್ರೆ ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ ಆಮೇಲೆ. ಓಕೆ ಮೇಡಮ್, ಯು ಹ್ಯಾವ್ ಸಾರ್ಟ್ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್, ಐ ಅಡ್ಜಸ್ಟೆಡ್ ಬೈ 4 weeks. ಎಸ್, ಈ 4 weeks ಗಿಂತ ಮುಂಚೆ ಇವ್ರೇನಾದ್ರು ನೋಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 6. ಅವ್ರೇನಾದ್ರು ಮೆಮೋ ಮಾಡಿದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾಗತ್ತೆ. 4 weeks ಆದ್ಮೇಲೆ ಬರ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ಯಾರಿಗೆ ಕೇಸ್ ನಡೆಸ್ಬೇಕು ಅನ್ನೋದಿದೆ ಅವ್ರ ಕೇಸ್ ತಗೊಂಡ್ ತೀರ್ಮಾನ ಮಾಡ್ತೇವೆ. ಎಸ್, ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ಳೋರು ದಯವಿಟ್ಟು ಕೇಸ್ ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೋಬೇಡಿ. ಪೋಸ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡ್ರೆ ಐ ವಿಲ್ ಅಡ್ಜರ್ನ್ ಇಟ್ ಬೈ ಕಾಸ್ಟ್. ದಿಸ್ ಇಸ್ ಅ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್. At your instance, date was fixed.
Yes.
At your whims and fancies, you are creating inconvenience to genuinely interested persons who wants to go on with their case. ನನಗಾಗಲ್ಲ, ಡೇಟ್ ತಗೊಂಡ್ರೆ ಬಿಸಾಕುವ, ಕೋರ್ಟ್ಗೇನು ಬರ್ಲಿ, ಕೋರ್ಟ್ ಇರೋದೇ ನನಗೋಸ್ಕರ, ಕಕ್ಷಿಗಾರ ಹಾಳಾಗಿ ನೆಗೆದು ಬಿದ್ದೋಗ್ಲಿ. This is the attitude. Yes, call the next case.
7, Girish B. Baladhar.
Kindly pass over the matter, my lords.
Pass over.
8,
Lords, in the last occasion, my lords directed me to check whether the application filed before the land tribunal can AC give an endorsement.
Did I appear for petition?
So he can't, as per the provision, AC alone can't give an endorsement, my lords. It can be remanded back for the fresh consideration. The impugned orders at next year are, my lords.
Are at page number 63. My lord, the petitioner, my lord, has filed review petition.
Okay, does it have the power of review? Land tribunal?
My lord,
My lords,
Land tribunal, has it the power of review?
a fresh consideration, my lord.
I am asking you a specific question. Is the land tribunal having the power of review?
Please.
It has the power of review. sir.
48A6,
There is a bar.
48A6,
Of
48 years,
Land Reforms Act. Proviso, my lord.
only for correction, my lord.
Correction and any extent correction, my lords.
My lord, here also, my lord, extent and the survey number, my lord. Your lordship kindly see the 48A6 proviso. May I read, my lord? My lord, the assistant commissioner, my lord,
what is the application given by you, sir?
your lordship kindly see annexure Q, my lord.
Annexure?
Q, page number 58. There is a mistake in the survey number and the extent, that's why my lord, he filed. My lord, instead of placing the review petition before the tribunal, my lord, AC, my lord, on his own, my lord, has passed the order impugned.
Yes.
Not order, my lords, is issued an endorsement.
That is the order.
No, that is the, you're challenging.
ಇವ್ರು ನೋಟಿಸ್ ಸರ್ವ್ ಆಗ್ಬೇಕಲ್ವಾ?
ಅವ್ರು 6 ಆಗಿಲ್ಲ, ಅವ್ರು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಆಗ್ಲಿಲ್ಲ.
ಸೊ ನೋಟಿಸ್
Six
ಆಗ್ಬೇಕು.
ಇದೆ. ಅವರು ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ಮೈ ಲ್ಯಾಂಡ್ಸ್.
Correct.
Correct. See, if you impute him as a party to the proceedings, we have to issue notice to him.
Please, my lords.
If you dispense notice at your risk and cost, it will be dispensed and order will be passed.
I will file memo
ಏನಂತ?
for dispensation.
ಬನ್ನಿ, memo ಹಾಕಿ. The advocate for the petitioner submits that notice to respondent number 6 may be dispensed with. Full stop. Notice to respondent number 6 is dispensed at the risk and cost of the petitioner. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಗೊತ್ತಾಯ್ತಲ್ಲ? ನೋ ಕನ್ಫ್ಯೂಷನ್ ತಾನೆ? Yes. Next, judgment. The petitioner has petitioner has the second respondent land tribunal sir, ಇವ್ರಿಗೆ ಹೆಂಗೆ ನೀವು dispensation ತಗೊಂತೀರಾ?
ಅಲ್ಲ ಬೇಡ, ಹಾಗಾದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಲಿ.
ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಅಷ್ಟೇ.
Please.
ಹೊಡೆದಾಕಿ.
ಪ್ಲೀಸ್.
ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಏನಿದೆ.
ಅಲ್ಲ ಅವರು ಇದಾರಲ್ಲೂ ಪಾರ್ಟಿ ಇದ್ದಾರೆ, ಬಟ್ ಅವರು ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ಮೈ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಕನ್ಸರ್ನ್.
ಇಶ್ಯೂ ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6.
ಪ್ಲೀಸ್ ಒಬ್ಲೈಸ್.
ಯಾಕಂದ್ರೆ ಅವ್ರ ಮೇಲೆ ನೀವು ಇದ್ ಮಾಡಿರೋದು ಅದಕ್ಕೋಸ್ಕರ. ಈಸ್
ಇರ್ಲಿ.
ಜಸ್ಟ್ ಅಂಡ್ ನೆಸರಿ ಪಾರ್ಟ್.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಮೆಮೋ ಏನ್ ಬೇಡ.
ಬೇಡ ಬೇಡ.
9. 9 Murali Babu.
This case, I put the petitioner.
1 week to do the needful.
I
Yes.
sought for, not in this case,
Sir, furnishing of PFL idala, sir.
filing memo, my lord. I sought for only against R1, my lord, the direction. It was representation. Memo dispensation of notice to the. Annexary, my lord, the representation to consider.
At the request of the petitioner, notice to respondent number 2 is dispensed at the risk and cost of the petitioner. ಇದು AG accept ಆಗಿದೆಲ್ಲ notice?
I have taken notice, my lord. Their claim is that
R1 AG.
ಸರ್ವೆ ನಂಬರ್ 86 ಹಿಡುವಳಿದಾರರು ಒತ್ತುವರಿ ಮಾಡಿರುತ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು. ಅದರಿಂದ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು. ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
So they become just a necessary party.
ಖರಾಬ್ ಕಾಲುವೆ ಅದು ಯೂಸ್ ಮಾಡ್ತಾ ಇದೆ ನಮ್ಮ ಲ್ಯಾಂಡ್ಗೆ ಹೋಗಕ್ಕೆ. ಅದನ್ನು ಬ್ಲಾಕ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ, ರಿಮೂವ್ ಮಾಡಕ್ಕೆ. ಎಲ್ಲ ರಿಪೋರ್ಟ್, ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಆಗಿದೆ ಸರ್. annexary FI produced by the survey report. Survey report clearly says not the encroachment for 3 guntas of land, Karab Kalwe.
How can you dispense, sir? Records prima facie reveal respondent number 2 has blocked the Raj Kalwe.
ಅದು ಗೋಡೆ ಕಟ್ಟಿದ್ದಾರೆ, ಅದು ಆ ಪೋರ್ಷನ್ ಮಾತ್ರ
ಹಿಯರ್ ಮಾಡಿದ್ರೆ ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್, ಬೇಡ. Post the matter of a service of notice to respondent number 2. Yes. ಮಿಕ್ಕಿದೆಲ್ಲ ಹೊಡೆದಕ್ಕೆ. Then in Kumar.
And in survey number 9, 8 acre 20 guntas, my lord, belonging to my father, my lord. Where, my lord, kindly see the IL, my lord, showing my name, father's name, my lord. IL, document number A, my lord, annexure B. Narsappa B. Nugregoda, showing my father's name, my lord. Thereafter, my lord, I took loan, my lord, crop loan, by mortgaging this property in favor of Dodguni Crop Society, my lord. Kindly see loan agreement annexure C, my lord. Annexure C, type copy at page number 21, my lord. There is a annexure showing that 4 acre 10 guntas, showing my father's name, my lord, at page number 21, column number 7, my lord. Narsegoda bin Nugregoda, survey number 9, 4 acre 25 guntas, my lord. Thereafter, my lords, kindly see the RTC, my lord, showing the encumbrance in favor of, my lord, the Dodguni Cooperative Society, my lord, annexure
Whatever
C.
notice, sir. Notice order ಇದೆಯಾ ಅಂದ್ರೆ? Fresh matters.
Fresh matter, my lord. My lord, though the civil court is civil
No
suit is
question of entry order, sir.
my lord, though the civil
AG
suit is
accepts notice for respondents 1, 2 and 3.
submission,
Issue
madam.
emergency notice to respondent number 4 and 5.
madam, kindly see annexure, my lord.
Please read annexure H operative portion.
The university, there is no.
My lord,
Servant-
without making me as a party, my lord,
I3 read annexure H
annexure H, my lord,
operative portion ಓದಿ.
to do the needful action by taking clarification from the Dodguni Cooperative
What does
Society.
it mean?
My lord, they are going to
ಕರ್ನಾಟಕ
change-
ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ ಸೋ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಮೇಲ್ಮನವಿಯನ್ನು ಅಂಗೀಕರಿಸಿದೆ. ಪ್ರಕರಣದಲ್ಲಿ ಗುಬ್ಬಿ ತಾಲೂಕು ನಿಟ್ಟೂರು ಹೋಬಳಿ ಹಾರೇನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕ್ರಯವಾಗಿರುವ ಸರ್ವೆ ನಂಬರ್ ಅನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ದೊಡ್ಡ ಗುಣಿ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿಯವರಿಂದ ಮಾಹಿತಿ ಪಡೆದುಕೊಂಡು ಖಾತೆ ಪಹಣಿ ಮಾಡುವ ಸಂಬಂಧ. ಓಕೆ, ಯು ಆರ್ ನಾಟ್ ಮೇಡ್ ಅ ಪಾರ್ಟಿ ಅಂತನಾ ನಿಮ್ದು?
I am not a party, my lord, without hearing me, my lord, without making me party, this order has been passed. In the meantime, kindly see my next annexure, my lord, a suit for partition filed by me, my lord.
ಬರ್ಕೊಳ್ಳಿ. Any order to be passed pursuant to the impugned order dated so and so, passed by so and so, with annexure H to the writ petition, shall be done only after hearing the petitioner herein. Along petitioner herein, along with such other parties as may be required in accordance with law,
Well, a civil suit is,
This full stop, this order shall be subject to the result of the writ petition. Suppose ಇದು ಅದಕ್ಕಿಂತ ಮುಂಚೆ AG accepts notice for respondent number 1, 2, 3, issue emergency notice to respondent number 4 and 5.
a civil suit is pending, my lord.
ಆರ್ಡರ್ ಮಾಡಿದಿನಲ್ಲೇನ್ರಿ, ನಿಮ್ಮನ್ನ ಕೇಳದೆಲ್ಲ ಪಾಸ್ ಮಾಡಬಾರ್ದು ಅಂತ ಅನ್ಬಿಟ್ಟು. 11 ಕಲ್ಯಾಣ
Sought for writ of mandamus. Consider my representation to effect mutation, and it is based on my lord, the decree obtained from the civil court. Lord, decree, my lord, is obtained in RA, is at page number.
Page A for
My lord,
respondents.
I need
Already
to file.
Notice of-
Already,
I need
notice
to
is
file
ordered.
statement of objections because
Hmm.
the matter
Oh,
involved.
The
in the
request of
petition.
page A, call after 2 weeks, objections if any by then.
12, Puneet C. Number 12, Puneet C. Vandana, N.
R4.
Lord, petitioner, my lord, proceedings 136-2 and 136-3, please. Lord, my father purchased the land measuring 3 acres or in survey number 32 way back in the year 1959.
Ready, Nendre? Government ready na?
Yes, ma'am.
Yes, go on with the matter. 1 second, wait. Who is Timmamma?
My lord, the wife of,
First appellant's mother,
sorry,
madam.
mother of the first petitioner, please.
If she has purchased 1 acre of land, how
1 acre.
could,
My lord, what 3 acres, please, my lord, was purchased my father and my brother. Subsequently, it was orally partitioned to an extent of 1 acre each. My lord, the
now
portion.
the dispute is between whom? Are you related to each other?
No, my lord, we are not related to each other. Between, my lord,
Just give the facts, my lord. Survey number 32, my lord, totally measures 14 acres, 14 guntas.
Yes.
That is excluding 1 acre, 14 guntas of land. On 18/6/1959, two
Ah.
sale deeds are executed. One sale deed in favor of his father, where he purchases 3 acres of land.
Hmm.
One sale deed in favor of my grandfather, where he purchases 6 acres, 20 guntas of land.
Hmm.
My lord, my grandfather in 1960 transfers by way of gift deed to my mother to an extent of 2 acres, 20 guntas. These are registered gift deed. Revenue entries are mutated both in his name of his father, in my grandfather, and in the name of my mother. After the death of my mother, my lord, I make an application for transfer of Khata. That is accepted in 2013. Revenue entries are changed. Now, my lord, he has purchased 1 share from his brother. His mother had purchased 1 share from his brother, which gets transferred to him. Now he wants, my lord, the entire revenue proceedings from 1958 to be set aside and fresh proceedings to be held. This is why the DC says, my lord, go approach before civil court if you have some disturbance with respect to the boundaries. Now he cannot, my lord, under 126(3) seek to set aside in 2018 the proceedings which took it in 58, 59, 83, 84.
His grandfather is Kari Gaudaningaya, na?
Yes, my lord.
please.
Huh?
Yes, my lord.
Okay, he purchases how much? 3 acres.
That is divided between his brothers. Each have 1 acre of land. 1 acre is again repurchased by one of the brothers. There's no dispute there. They are objecting to the property which my mother gets under a gift deed, registered gift deed of 1960. 15/6/1960. Pursuant to which, my lord, on MR number 144 of 70.
Timmegowda sold 3 acres to Kari Gaudaningaya.
No, 2 persons, one to my grandfather and one to him.
Your grandfather's name?
My grandfather's name, my lord, is Kempegowda, my lord.
Kempegoda bin Gudegoda.
6 acres to Kempegoda.
6 acres, 20 guntas.
6 acres, 20 guntas.
He on
Kempegoda.
15/6/1960, my lord, he grants 2 acres, 20 guntas to my mother.
Gift deed 2 acres,
20 guntas.
20 guntas.
On which MR number 144 of 78/79 is registered. 144 of 78/79.
44 of
78/79.
78, 79.
I'm not
Okay. After the death of your mother, you inherited the.
We made an application, revenue entries are channeled. What we did, my lord,
In your name, MR number?
it's 20, my lord. It's
MRT of 2021.
MR?
30 of 2021.
30/2021.
30 of
2021.
2021.
My lord, what we had done, my lord, my mother got 2 acres, 20 guntas. We filed a suit for partition against our uncle, seeking for a bigger share. My uncle challenged the gifted. Therefore, we compromised, my lord. We said we'll hold whatever land we have, or you hold whatever land you have. It is on this, my lord, subsequently it was done. Now, he wants to contend, my lord, that his father, which had purchased 3 acres land, was a different area situated at a different portion. That's a matter of trial before a civil court where you'll have to lead evidence. That can't be gone under 136(3). Now, can you see his appeal memo, my lord, which is produced at annexure F, my lord, page 53. Can you see the prayer at page 59, my lord? Under 136(2), you'll have to challenge some MR proceedings. He does not challenge everything. He says, set aside everything, do fresh MR. Page 59, my lord, wherefore it is played. This honorable court may kindly please to call for records from the 13th respondent, direct the Tahsildar Punjab to accept fresh mutation to an extent of 2 acres in the name of first acre and 1 acre in name. What happened to the earlier proceedings? And the land now, madam, I'm told, are divided into 6 podies. Podi work is not never challenged. 35(1) to 35(2)(6). They don't challenge the podi work. This is why the deputy commissioner, my lord, while his impugned order, my lords may see the operating portion at page 63, my lord. Every order passed is subject to outcome of a civil proceedings at paragraph 2. ಉಭಯ ಪಾರ್ಟಿಗಳು ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪ್ರಶ್ನಿಸಿ ತಮ್ಮ ಹಕ್ಕುಗಳ ಬಾಧ್ಯತೆಗಳನ್ನು ಸಾಬೀತುಪಡಿಸಿ.
One second, sir. 1 second. I'll look into it. By MR number 144 of 78-79. Okay. What was the survey number given?
Same, my lord, 35.
ಪೋಡಿ ಆಯ್ತಾ ಅವಾಗ?
ಪೋಡಿ ಆಗಿಲ್ಲ.
ಪೋಡಿ ಆಗಿಲ್ಲ. Okay. ಪೋಡಿ ಯಾವಾಗ ಆಯ್ತು ಮತ್ತೆ?
Podi date exactly, I don't know, my lord, but in the writ petition itself, they have pleaded that podi work has taken, my lord. My party also does not know when podi took. I've asked them to.
You are owner of the property in survey number?
35 RTCs, my lord, I'm just arguing on the writ petition, but I'm told, my lord, there's no
ನಿಮ್ ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟ್ರಿ? ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು?
I'm handicapped, my lord, RTC, I don't know, exact number, I don't know, my lord. I'm extremely sorry, my lord. It's my mistake. I'll see, my lord, just a minute.
ರೀ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ನಂಬರ್ ಆದ್ರೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇರ್ಬೇಕಲ್ವೇನಪ್ಪ?
My lord, sir, right, my lord.
ಗೌರ್ಮೆಂಟ್ ಇವ್ರ ಪ್ರಾಪರ್ಟಿ ಸರ್ವೆ ನಂಬರ್ ಎಷ್ಟು, ಅವ್ರದ್ದು ಎಷ್ಟು?
Thirty-two bar 6, my lord. 32/6 is the petitioner's property.
32/6?
Please.
ಎಷ್ಟಿದೆ ಎಕ್ಸ್ಟೆಂಟ್? 32/6 ಇದನ್ನ ಹಾಕಿದಿರಾ? RTC ಹಾಕಿದಿರಾ?
RTC ಇದೆ ಮೇಲೆ 7.4 ಅದು ಕೋಡ್ ಆಗಿ 32(1) to 7 ಆಗಿದೆ ಮೇಲೆ after podi.
We'll read the impugned order, there will be clarification.
Before that, may
1 second, I will hear you now. Please get a clarification. I'm doing it. Impugned order.
Under 32/7, my lord, I'm sorry. At page 33C8, 32/7.
What is the impugned order?
Computerized RTC ನಲ್ಲಿ ನನ್ನ ಹೆಸರೇ ತೋರಿಸಿಲ್ಲ.
63.
ಅದಕ್ಕೋಸ್ಕರ my lord.
I will hear you, sir. Without
60.
hearing you, I will not pass any order.
Page 60, my lord, is the impugned order.
After purchasing of the property, my lord, they have not changed the mutation in the name of annexure B.
Yes.
Lord, what has happened, please, my lord? After my father purchased the property in the year 1959, mutation were affected, white annexure B. Please, my lord. Subsequently, in the computerized RTC, please, my lord, my name was not shown. Though there is an mutation in my favor and a sale deed in my favor way back in the year 1959. My lord, I approaches the assistant commissioner, my lord, seeking a direction to affect my name based on the registered sale deed. My lord, what is assistant commissioner? He, my lord, based on the documents of the respondent herein, he dismisses my appeal and further states that, please, my lord, there is a civil suit which he has filed, to which I am not a party to the proceedings. It was on that ground, please, my lord, my appeal was dismissed before the assistant commissioner. Subsequently, please, my lord, before the deputy commissioner also, he has confirmed the order of the assistant commissioner. My lord, what the private respondent herein he does is, my lord, prior to this, my lord, prior to me
Now,
filing an appeal,
Shankaraya, according to you, owns how much extent of property?
my lord, 3 acres is my sale deed. Mutation is also affected by annexure B.
Now, Shankaraya, according to you,
Please, ma'am.
owns how much of property?
3 acres.
Kempraju?
My lord, 2 acres in the name of Shankaraya, Kempraju 1 acre.
That's what I'm asking.
My lord, 2 acres, 1 acres. What has happened, please, my lord, what my father purchased under 3 acres, we have divided between that 3 acres only. My lord, what
After
my
your father purchased the property, was there a podium mutation?
My lord, the annexure B reflects only survey number 32, page 18. Survey number 32, 3 acres. My lord, what this respondent does is, my lord, he prefers an appeal before the DDLR, seeking cancellation of survey number 32/1. My lord, what the DDLR does is, he remands the matter back to the ADLR to conduct a fresh proceedings by giving an opportunity to me. My lord, by virtue of this document, please, my lord, no proceedings have been done by the ADLR. May I please? May kindly see, it's in the year 2019. The operative portion is at page number 5. My lord, the matter is remanded back to the ADLR. What he does is, he suppresses this particular fact before the assistant commissioner. Immediately after passing of this order, he files a civil suit. My lord, he has knowledge that I am claiming a right in respect of survey number 32 to an extent of 3 acres. He suppresses this particular fact before the assistant commissioner. He files a suit.
Yes, file your objections, detailed objections, both of you. Okay, government, you obtain the manner in which survey number 32 was ported. Number 1. Okay. Over a period of time.
Please.
See, initially it consisted of 15 acres.
14 guntas.
14.
No, total how
28,
much?
28 guntas. 14 acres, 14 guntas is remaining.
See, after excluding Karab, it is 14 acres, 14
14
guntas. Including Karab, it is 15 acres.
14 guntas. 1 acre, 14 guntas is the Karabna.
15 acres, 29 guntas.
15 acres, 29 guntas. I'm sorry, madam.
15 acres, 29 guntas is the original extent of survey number 32. Because of Barkole. 15 acres, 29 guntas, original extent of survey number
32.
32.
32. Karab is 1 acre, 15 guntas. A Karab.
Yes, madam.
A Karabo, B Karabo.
A road portion. On the road over there.
Road portion. So 1 acre, 15 guntas goes.
Always.
Okay. The remaining portion is 14 acres, 14 guntas.
Please.
Owned by Timbegoda.
Yes, madam.
Yes.
Okay.
Yes,
Of
ma'am.
which 3 acres is purchased by Kari Gowda Ningaya.
Yes, madam.
Yes. Yes.
And 6 acres is purchased by Kempegoda. That's only 9 acres. The rest probably remains with Timbegoda. Okay. Now, with regard to survey number 32, now it has been ported into survey number 32/1 to 7.
Yes, madam.
Correct, Andre?
Correct, madam.
32/1 to 7. How it got ported into 32/1 to 7? Okay, number 1. Number 2, what are the transactions that have taken place from the beginning till date?
Please.
With respect to entire extent.
In respect to entire extent of 32 acres.
Please.
Any court orders.
Please.
You people file your objections, let him get all the records. See, this is the way you need to prepare. You also
sir.
require to prepare the
Noted.
same way, but you are not done so.
Please.
My lord, sir.
ಏನಾಗಿದೆ ಅಂದ್ರೆ by virtue of the order, please, my lord, you have filed for Hadbus 32/7 gas.
No, whatever it is.
ಅಲ್ಲ,
See,
Hadbus
unless-
ಹಾಕ್ಬಿಟ್ರೆ,
Unless you place the entire picture of survey number 32 before the court, we can't deliver
my
the.
lord, what has happened, please, my lord, he has suppressed him, my lord, by virtue
See,
of that.
blame ಮಾಡೋದ್ ಬಿಟ್ಬಿಟ್ಟು ಏನಿದೆ materials placement.
And I'll place it on, please.
What I told the government advocate has to be done by you both also.
I'll do it, ma'am.
I'll
Get the AC and I'll do it.
Till such time, please, my lord, no precipitative action by the respondent. Hadbus
32/7, they don't challenge it.
It will lead to multiplicity of.
Notice order ಆಗಿದೆಯನ್ರಿ?
No, my lord, notice.
Notice ಆಗಿದೆ.
Notice order ಆಗಿದೆ. Interim orders ಇದೆಯಾ?
ಇಲ್ಲ.
ಇಲ್ಲ.
Interim order ಇಲ್ಲ. It was heard on 3 occasions, my lord, no interim. order.
Maintain status quo in respect of revenue entries ಅಷ್ಟ.
Please,
Only
my lord.
revenue entries.
In respect of revenue interest, that's all. Yes, at the request of parties, post the matter after 3 weeks. Respondents 1 to 3 are directed to maintain status quo in respect of revenue entries regarding the property which is the subject matter of the writ petition till next date of hearing.
Obvious.
Notice ಆಗ್ದಿಲ್ಲ ಇದೇನಿದೆ?
Notice ಆಗಿಲ್ಲ.
Notice ಆಗಿಲ್ಲ. Notice ಆಗಿಲ್ಲ.
Notice ಆಗಿಲ್ವಾ?
Notice ಆಗಿಲ್ಲ.
Then how can he come on record?
ಕೇವೇಟ್ ಹಾಕಿದ್ರು.
ಒಬ್ರು caveat ಹಾಕಿದ್ರು.
There are
He
family
accepts
members-
notice for respondents number 1 to 3, you are for 5 to 8,
4, my lord.
4 to 8,
Force.
So and so accepts notice for respondent number 4 to 8, ನಿಮ್ಮ ಹೆಸರು ಬರ್ಕೊಡಿ.
Yes, same.
5 to 8.
4 to 8.
4 ಗೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ, 5 to 8 undertake to file ವಕಾಲತ್.
Accepts notice for respondent number 4 to 8.
ಅಂದಾನ.
Okay. The request of parties post the matter after 3 weeks. Respondents 1 to 3 are directed to maintain status quo in respect of the revenue entries regarding the property, which is the subject matter of the writ petition till next date of hearing. Yes.
13, number 13. This Santosh.
Yes.
Challenge is to annexure A, page 12, my lord. The mutation
What's the
entries
answer?
are not ordered to be changed in favor of
about others?
respondent number. In favor of respondent.
ಆಯ್ತು
number 5.
ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ ಅದರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ಗೆ.
For consideration of interim prayer, my lords, I have, when the matter was last posted, my lords, the government advocate made a submission. My lords, in this matter, what has happened is, kindly see page 12, page 13, my lords.
Special deputy commissioner had challenge before the Honorable Court under section 129. The special deputy Tahsildar has passed the item. It has challenge before the Honorable Court.
ಸಬ್ಬಿಲ್ ಇದೆಯಲ್ರಿ?
Please,
Provision.
ಇಲ್ಲ, ಅದೊಂದು, I will convince your lordships on that point. Annexure G, page 38, my lords, may kindly be seen for a moment. Annexure G, page 38. My lords, this was a earlier order passed by the assistant commissioner. My lords, this order, I challenged this order by filing a writ petition before this honorable court on the ground that, my lords, the order was passed against a dead person, because respondent number 1 therein had died before the passing of the order. My lords, this honorable court directed me to approach the deputy commissioner and pursue the matter. I approached the deputy commissioner, my lord. The proceedings is still pending before the deputy commissioner. In the meanwhile, what the deputy Tahsildar does is, while annexure A, my lords, impugned order, orders for change of mutation entries in favor of respondent number 5 during the pendency of that proceedings.
ಆಯ್ತು ಬನ್ನಿ. Issue emergent notice to respondents 5 to 8. Respondents 1 to 4 are directed to maintain status quo in respect of revenue entries regarding the lands or the subject matter of the writ petition till next date of hearing. Yes.
14, Arvind N.
For the petitioner, your lordship, seeking the writ of mandamus, your lordship. Petitioner ಗೆ ಮತ್ತೆ ಅವ್ರ siblings ಗೆ partition, registered partition deed ಆಗಿ properties allot ಆಗಿದೆ ಸ್ವಾಮಿ. The petitioner has made a representation to the special Tahsildar through
Notice
annexure.
order ಆಗಿದೆಯಾ? AJ accept notice for respondent.
I have
Reddy 15.
ಏನಾಗ್ಬೇಕು?
I have taken one particular date ಕೊಟ್ಬಿಡಿ ಸ್ವಾಮಿ.
ಡೇಟ್ ಇಲ್ಲ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತಾರೆ. Yes.
15, Chukkareddy.
Petitioner, my lord. File number 57 is filed by the petitioner for seeking 1 acre grant. That is, my lord, the application file 3 to 23. That the amendment is existence, my lord, the.
Yes,
May
government, ready
23.
now?
He is having surplus land, my lord. He is owning more than 12 acres of land. I'm here to produce, my lord, all the RTCs. In spite of that, he files Form 57, which is itself, threshold itself, it will be rejected. But without disclosing the owning of lands, my lord, he once again moved the application, my lord. Time barred
Earlier,
application.
the application was not rejected. This is the first
Threshold
application.
itself is not entitled for any of the grant, my lord, because he is owning 12 acres of land.
Committee
Yes.
can be inquiry, my lord, under one
It's all
not,
right.
one not 80D, my lord.
The petitioner, the request of the petitioner for
1 acre of land.
regularization of unauthorized cultivation or for grant of land?
Regulation of
Regularization.
unauthorized cultivation of land.
Form
Regularization,
57
57.
files, my lord.
regularization of unauthorized cultivation. As the request of the petitioner for regularization of his unauthorized cultivation of land in survey number 444. In brackets measuring 1 acre,
1
brackets
acre.
close. Karnahalli village, Muguru Hobli, T. Narsirpura Taluk is rejected. Is rejected, the present writ petition is filed.
No.
Full stop.
No, my lord, it was not rejected, my lord. This is a
His
fresh
application is pending before consideration, my lord. His grievances is that the authorities have gone there and forcibly take possession, my lord.
Yes.
Because the thing is, he is owning 12 acres of land, my lord. He is not allowed to cultivate the land.
Cultivation of land, my lord.
He has not grown any crops, my lord. Last occasion, simply placing the materials that
That-
he's grown some crops and taken the
What are the-
order.
on the
produced
ground
the-
that petitioner is unauthorizedly cultivating 1 acre of land in survey number 444 of so and so village, same Melero village. And his request for the same, for regularization of the same has not yet been considered,
Yes.
has not yet been considered.
Not yet been considered. Prima facie
Considered by the
rejected.
respondents. The present writ petition is filed with the following prayers. Full stop. Prayers extract. Next para. The learned AGA upon instruction submits that the petitioner is owning
12 acres of land.
12
I've
acres
produced
of
all the
land and he
RTCs.
is not entitled for
Any of the grants.
regularization of unauthorized cultivation of land. Full stop. She further submits that he is not in cultivation of the lands
He's
as
not,
alleged.
he's not
as
allowed
alleged.
to cultivate the land.
As alleged. Full stop. Next para. The petitioner is not in a position to dispute the fact that he owns 12 acres of land
No, my lord, there are 3 brothers. We have detailed the.
as stated by the learned AGA. Full
RTC.
stop. Next. For the aforementioned reason, the writ petition is hereby dismissed. Yes, sir.
And we have produced the, my lord, their brothers list. My lord.
Yes,
There
sir.
was a partition, my lord.
Yes, sir. Matkoli, sir.
That the committee will inquire
Akshata
at that
Sharma.
point, my lord. This is the parts, the RTCs they have produced. Under 108 D6 is the committee has got every power, my lord. For inquiry.
Sir, do you own 12 acres of land or not?
No, my lord, we have no, my lord.
Your
I
family
will
owns
file-
12 acres
I
of
will-
land or not? Your family owns 12 acres of land or not?
Lord, I will file these objections to this RTCs, my lord.
I am asking you a specific question. Does your family own 12 acres of land or not?
My lord, this petitioner having 4 acres of land, their brothers have having the 4 acres. of
Yes,
land.
once you have 4 acres
There
of
was-
land, you are not entitled for regularization of unauthorized cultivation.
No, my lord, there was a provision under 108 D, my lord. 108 high, the committee has to inquire by the cultivation of how much I am entitled for the cultivation of the land or entitled. for the-
According to law, if you have how much extent of land, still you are entitled for regularization of unauthorized cultivation. Tell me.
My lord, the dry land, my lord, 2 hectares.
Hmm.
2 hectares means my brothers and we have only the 12 acres. 4 brother, we have 4
It's one
brothers.
family, sir.
Already-
It's one
Already
family.
partition, my lord, between my family, my lord. At least next date, I will file objections to this one, my lord.
No, next date, sir. Now you tell me, does your family own 12 acres of land or not as alleged by the,
But this petitioner says no. This petitioner says, no, 12 acres is not the owner.
okay, how much do you own then?
But I will give the details.
No question of that. You should have told before filing the writ petition. I will adjourn you. If you have even 1 gunta of land, I'm going to dismiss
But,
your writ petition with 10 lakh rupees cost. If you are agreeable for that, I will.
Kindly pass over, I will give instructions to my client. How much the total extent of the land in his name?
I have produced all the RTCs.
Artisanal your ಹೆಸರು ಇದೆಯೇನ್ರಿ ಕೊಟ್ರೆ?
Highlight ಮಾಡಿದ್ದೀನಿ.
Yes, ನಿಮ್ಮ ಹೆಸರಿದ ಮಾದೇವಯ್ಯ ಬಿನ್
In
Jolta
so many
Siddhaya.
survey
Put it-
numbers he has owned the land.
Yes, dismissed. Order stands. ನೋಡ್ರಿ ಕೋರ್ಟ್ ಇರೋದು ನ್ಯಾಯ ಒದಗಿಸಕ್ಕೆ, not to play with the process of law and unjustly enrich yourself.
Malad,
Yes.
in this RTC 15 guntas, 15 guntas, Malad, and 18 guntas.
10-12 RTCs ಇದೆ ನೋಡಿ.
I will peruse, one date may be given, Malad.
One date Allah. If her statement is denied by you,
Malad,
and look, mister, if her statement is denied by you,
Malad,
and if it comes out to be correct, I will order confiscation of all your property. Are you agreeable for it?
Malad, I don't know this one.
Then
Today,
your writ petition stands dismissed.
government has
You
produced
should be
these
aware of
RTCs.
it before coming to the court. This is not a ground to play around by abusing the process of the court.
Malad,
Yes, call the next case.
Chata Sharma 16.
My lord, this.
Hey, ಸುಳ್ಳು ಹೇಳ್ಕೊಂಡು ಇಲ್ಲಿ ದೋಚಕಲ್ಲ ನಿಮಗೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿರೋದು.
Malad, I have not given any false, Malad. They are instructions, we have filed this petition.
ಅದನ್ನ
Now
ಇನ್ಸ್ಟ್ರಕ್ಷನ್
they-
ತಿಳ್ಕೊಂಡು
now they-
ಬರ್ಬೇಕು.
Now they.
When you seek regularization of unauthorized cultivation, first question you have to ask your client is, do you have any alternate land or not? Yes, next.
16. Akshata Sharma.
My lord, this petition forms part of the HRP batch petitions, my lord, it's covered by judgment.
What are charged batch petitions?
My lord, this is Himavati Reservoir project, my lord,
Hmm.
wherein the petitioner's land was submerged.
Hmm.
And because of the submersion of the land, notification was issued by the government that 4 acres of land would be allotted to the petitioners. Accordingly, land was allotted to the petitioners also, my lord, by virtue of Form 1.
Hmm.
My lord, subsequently, my lord, by virtue of Annexure A,
Hmm.
the allotment has been cancelled, my lord. Some complaints were raised and about 8 clauses were removed, my lord, wherein certain clauses, they said either it is forest land or it is double allotment of land, or it is basically some tahsildar who had gone into or indulged in inappropriate activities and all that, my lord. 8 clauses are there. Out of that, 1 clause has been allotted to the petitioners, my lord, and the land has been, allotment has been cancelled.
Bunches of the matters has already been remanded for the special LAO for reconsideration of the matter.
It's a covered judgment, my lord. Last annexure, I've produced a similar judgment, my lord.
ನೀವ್ಯಾಗ ಅವರು ನೋಟಿಸ್ ಕೊಟ್ಟಾಗ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ?
How they have failed to appear before the authorities at the time of the hearing.
When do you appear? When they issue
We
notice?
had appeared, my mother, actually the property belonged to my mother, my lord. My mother has appeared and she has submitted the documents, my lord. I have the copies that we have submitted even to the SLAO back then. This is, they have just issued similar notices against everyone, my lord.
It's not notice, madam. Pratibha, come to page number 21. See, admittedly, there was a scandal wherein officers colluded with
That's why, my lord,
some of the persons who created
bogus grant has also.
false documents and got the lands allotted. Okay, so there was a review of whether you are a genuine sufferer,
Sufferer or
you
not.
have been displaced or not. Okay,
Please, my
so
lord.
for that, nodi.
My lord, if the matter gets remanded, like all the other matters are remanded to the SLAO, I'll resubmit my documents to the SLAO. Let the SLAO then take the decision, my lord, accordingly.
CBI inquiry is also going on, my lord.
See,
because so
ಅಡಿಯಲ್ಲಿ ನೀಡಿದ್ದರೂ ಸಹ ಪ್ರತಿವಾದಿ ಮಂಜೂರಿದಾರರು ಯಾವುದೇ ತಕರಾರಿನೊಂದಿಗೆ ಪ್ರತಿಕ್ರಿಯೆಯನ್ನು ಸಹ ನೀಡದೇ ಇದ್ದುದರಿಂದ ಮೇಲಿನ ಕಾರಣಗಳಿಂದಾಗಿ ಪ್ರತಿವಾದಿ ಶ್ರೀಮತಿ ಮಂಜೂರು ಮಾಡಿರುವ ಬೇಲೂರು ತಾಲೂಕು ಕಸಬಾ ಹೋಬಳಿ ರದ್ದುಪಡಿಸುವುದು ಅನಿವಾರ್ಯ ಮತ್ತು ಸಮಂಜಸವಾದ ಕ್ರಮವಾದ್ದರಿಂದ show the documents prima facie that you are a displaced person. Have you produced it?
My lord, that I have not produced. I have produced the allotment, what has been done to me.
Allotment, there is no dispute with regard to it.
My lord,
The question is, you are required to establish that you are a displaced person. Some document to show, yes,
My
you
lord,
owned a land which has been submerged in Hemavati Reservoir project. You produce before this court, I will grant you the relief.
my lord, a date may be provided. My lord, I'll produce those documents. I have those documents with me, my lord. Those documents per se have not produced. I'll produce those documents. A date may be provided.
Either dispose it of, remand the matter back.
because some.
You pay a cost of 2,500. Okay, pay a cost of 2,500 because you have been issued notice, you have failed to appear. That's the reason.
My
Yes,
lord,
Bunny.
in this particular matter,
The mother of the petitioner,
Yes, my lord, because why the fraudulent acts have been taken place, my lord, the very.
no, mother of the
Genealogical-
petitioners in Ray.
mother of the petitioners, my lord.
The mother of the petitioners is said to have been allotted.
ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಈಗ BS ಮಲ್ಲಪ್ಪ ಎಸ್ ಡಿಸ್ಪ್ಲೇಸ್ಡ್ ಪರ್ಸನ್ ಆದ್ರೆ ಪ್ರತಿಯೊಬ್ಬ ಮಕ್ಕಳುಗಳು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರ್ತಾರೆ.
Yeah,
That's why CBI enquiry has been gone on. It is enquiry is going on, my lord.
The mother of the petitioners is said to have been allotted ಎಷ್ಟು?
My lord, it
3
is
acres,
3
3
acres,
guntas.
30 guntas.
3 acres, 30 guntas of land in survey number 8, block 1, Kallahalli village, Kaspa Hobbli, Belur Taluk. On the ground that she lost her lands when the same were submerged. By the waters of Hemavati Reservoir. By the waters of Hemavati Tana?
ಹೇಮಾವತಿ ರಿಸರ್ವಾಯರ್ ಪ್ರಾಜೆಕ್ಟ್.
Hemavati Reservoir. ಏನ್ ಬಂತು ಸೆಂಟೆನ್ಸ್ ಶುರು ಆಯ್ತು? Okay, full stop. However, it was noticed by the state that several irregularities have been committed by the officers concerned in identifying and allotting the lands to the displaced persons. Full stop. Hence, an inquiry has been initiated regarding the grants made to several persons, and petitioner is one such person. Full stop. In spite of issuance of notice, petitioner is one such person, but the mother of the petitioner is one such person. She is no more, huh?
She is no more, my lord. I've produced her death certificate. She passed away in 2018.
The impugned order is passed on.
It is passed in 23.
No. In spite of service of no, yen bantu? Who is Veena Kumari?
Veena Kumari is the mother of the petitioners.
You are son of Kumara Aradhya.
I'm son and daughter, petition number 1 and 2, son and daughter of Veena Kumari.
No, you are son of Kumara Aradhya.
That's my father's name.
They have produced genealogical tree, my lord.
Okay. Your maternal grandfather's
Yes.
property was submerged. Yen bantu ಹೇಳಿ? Mother of petitioner, in spite of issuance of notice, mother of petitioner failed to appear for inquiry, because of which the impugned order has been passed.
My lord, if I may just interfere, my
One
lord.
second, wait, hear what I say. Agreed by the same, the present writ petition is filed. Full stop. Next para. The petitioner submits that the order has been passed against a dead person. When did your mother die?
2018, my lord,
Full stop.
34, 2000.
It is submitted that the mother of the petitioner died in the year 2018. And inquiry has been done subsequently. Full stop. It is also submitted that if an opportunity is provided, the petitioners shall produce all the relevant particulars to the authorities to show that the mother of the lands belonging to the mother of the petitioner were indeed submerged by the backwaters of Hemavati Reservoir, and and she was entitled to the allotment made in her favor. Full stop. Next para. As the impugned order is passed against a dead person, and without hearing the petitioners, the same is liable to be set aside, and the matter requires to be remanded back to respondent number.
Respondent number 1, my lord, SLAO.
Respondent number 1, SLAO. Respondent number 1, SLAO, Special Land Acquisition Officer. Full stop. Hence the following order. The impugned order dated so and so, while annexure 8 of the writ petition passed by respondent number 1 is set aside. Next, the matter stands remanded back to respondent number 1, and petitioners shall appear before respondent number 1 on
No, my
6 weeks bit date.
Date to, ಯಾಕೆಂದ್ರೆ enquiry is going on. Lots matters are pending consideration.
6 weeks bit date ಕೊಡ್ತೀನಿ.
ಇಲ್ಲ ಅದು CBI ಕನ್ಕ್ಲೂಡ್ ಆಗದೆ ಹೊರತು ವಿ ಕೆನಾಟ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲೂ ಡಿಸಿಷನ್ ತಗೊಳ್ಬೇಕು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ, ಬಿಕಾಸ್ ಸೋ ಮೆನಿ ಗ್ರಾಂಟ್ಸ್ illegally have been granted.
Correct.
Some time is required.
I'm remanding the matter back with a direction for
Time fix ಮಾಡೋದ್ ಬೇಡ.
them to appear before respondent number 1. ಇದೆಲ್ಲ ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೊಮ್ಮೆ ನೋಟಿಸ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕಮಿಟಿ ಯಾರ್ಯಾರು ಮಾಡ್ಬೇಕು, ಯಾರು ಡಿಸೈಡ್ ಮಾಡ್ಬೇಕು, ಗವರ್ಮೆಂಟ್ ಲೆವೆಲ್ ಅಲ್ಲಿ ಡಿಸೈಡ್.
ಬಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ಮೇಲೆ ಮಾತಾಡಿ ಮೇಡಮ್, ಏನಾದ್ರು ರೆಕ್ಟಿಫಿಕೇಶನ್ ಬೇಕಿದ್ರೆ ಹೇಳಿ. ಡೇಟ್ ಕೊಡಿ. 2/12 ಏನ್ ಬಂತ ಹೇಳಿ. 2/12/2024 at 3 PM. without further notice. That is to safeguard the interest of the state without further notice. Full stop.
Government level decision.
Respondent number one shall, respondent number one slash committee to be formed by the state.
It is not at form. Special
Committee to be respondent number one or such other authority as nominated by the state shall examine the claim of the petitioner in accordance with law and pass appropriate orders as expeditiously as possible. Full stop. Next. Till such a decision is taken by the state, petitioner shall not create any third party rights or otherwise alienate the property which is the subject matter of the writ petition. Writ petition disposed of accordingly. Okay? Yes. That takes care of everybody's interest. See, remand ಮಾಡ್ಬಿಟ್ಟು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೀವು ನೋಟಿಸ್ ಯಾರಿಗೋ ಎಲ್ಲೋ ಕೊಡ್ತೀರಾ.
Nearly 800 cases are there.
Listen,
Government has to take
ರಿಮ್ಯಾಂಡ್ ಅದಕ್ಕೆ ನೀವು ಡಿಸೈಡ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಟೈಮ್ ಫಿಕ್ಸ್ ಮಾಡಿಲ್ಲ.
appearance.
ಅಪಿಯರೆನ್ಸ್ ಗೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡದಲ್ಲ ಇದ್ರೆ ನೀವ್ ಎಲ್ಲೋ ಯಾರಿಗೋ ನೋಟಿಸ್ ಕೊಡ್ತೀರಾ. ನೋಟಿಸ್ ಸರ್ವ್ ಆದ್ರೂ ಇವ್ರು ಬಂದು ಅಪಿಯರ್ ಆಗಲ್ಲ, ಮತ್ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡು ಬರ್ತಾರೆ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಇನ್ನ ನಾಟ್ ಇಟ್ ಟೇಕನ್
ಹೇಳಿದ ಅರ್ಥ ಆಗ್ಲಿಲ್ವಾ?
ಅರ್ಥ ಆಯ್ತು ಸರ್, ಬಟ್
ಅದಕ್ಕೋಸ್ಕರ
ಯಾರ್ ಮುಂದೆ ಅಪಿಯರ್ ಆಗ್ಬೇಕು ಅನ್ನೋದು
Yes.
ಕ್ವಶ್ಚನ್.
Let them appear there. You take a decision, you direct them to appear.
Yes.
20, KP Bhuvan. Revision petition.
Notice ಆಗಿದೆ ಇದರಲ್ಲಿ. Death person petitioner died on my lord 1910-2000.
ಯಾಕೆ ಅಂತ petitioner died
Petitioner ಸತ್ತೋಗಿದ್ದಾರೆ. ಇದು ಅಲ್ಲ ಒರಿಜಿನಲ್ RRP ಅಲ್ಲಿ against their without informing to this court my lord they address the arguments they have obtained order. The order is nullity ಅಂತ ನಾನು kindly page number.
ಇದಾ?
Yes my lord.
Yes, ಇದು
Temple property.
ಲಾಸ್ಟ್ ಟೈಮ್ ಯಾತಕ್ಕೆ ಅರ್ಜನ್ ಆಯ್ತು?
ಅದೇ ನೋಟಿಸ್ ಅಂತ ಆಗಿದೆ. ಇವತ್ತಿಗಿದೆ ಸಮಯದಲ್ಲಿ ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ಎಲ್ಲ ಆಗಿ ಇದಾಗಿದೆ. ಇದು ಪ್ರೈವೇಟ್ ಟೆಂಪಲ್.
ಎಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ತಗೊಂಡಿಲ್ವಲ್ಲ ನೀವು? ಪೋಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್. ಎಸ್.
ಅಲ್ಲ ಕೋರ್ಟ್ ಇವತ್ತು ಕೈಂಡ್ಲಿ ಪರ್ಮಿಟ್ ಮಿ ಟು ಟೇಕ್ ಸಮನ್ಸ್ ಟು ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಮೈ.
ನೋ ಸರ್, ಇವ್ ಬೇಕಾದ್ರೆ ಹಾಗೆ ಸರ್ವ್ ಮಾಡಿ, ಆಸ್ ದಮ್ ಟು ಅಪಿಯರ್.
ಅಲ್ಲ ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ, ಇವತ್ತು ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಆಯ್ತು, ಕೊಡಿ ನೀವೇನಾದ್ರು ಮಾಡಿ.
ಟಿಲ್ ಮೈ ಲಾರ್ಡ್.
ಸರ್ ಇಲ್ಲ ಸರ್.
ಆಯ್ತು
ಭುವನ್ ಪ್ಲೀಸ್.
ಆಯ್ತು ಆಯ್ತು.
ಎಸ್.
18, A Karambaya, Harish Kumar,
ಇಟ್
MS.
ಲೀಡ್ಸ್ ಟು ಇಂಜಸ್ಟಿಸ್.
ಅಲ್ಲ ಟೆಂಪಲ್ ಎಕ್ಸ್ಪರ್ಟಿ
ಆಯ್ತು ನೋಡೋಣ.
ಡೆತ್ ಪರ್ಸನ್ ಮೇಲೆ ತಗೊಂಡಿದ್ದಕ್ಕೆ ಅಷ್ಟೇ ನಾವು ಇಲ್ಲ ಅದಕ್ಕೆ.
Serial number 18.
None appears for the petitioner, call after 4 weeks. Needful by then.
19, KV Narasimhan.
Needful.
Needful done, advocate for the petitioner submits that needful has been done.
Lord, in this, Lord,
Office to verify and proceed.
Lord, I undertake to file power, Lord, on behalf of respondent 2A 1 to 4, Lord, 1 to 2.
2A.
ಇವ್ರಿಗೆ ಏನ್ ಪ್ರೋಸೆಸ್ ತಗೊಬೇಕಲ್ಲ 2A 1 and 2, Roman 1 and 2. ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ, ಫೈಲ್ ಇಟ್ ಇನ್ ಅಕೌಂಟ್ ಮೇಲೆ, ಹಿಯರಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡಿ.
Yeah, so and so undertakes to appear for respondent number 2A in brackets 1 and 2 ಈ ತರ. ಕಾಸ್ಟ್ ರೇಟ್ ಅಲ್ಲಿ ಇದೆ ನೋಡಿ.
P Anand. P Anand. Yes.
ಹೇಳಿ, ರೆಡಿ ಇದ್ರೆ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಇಟ್ ಆಫ್. ರೆಡಿ ಇದ್ದೀರಾ?
Date may be fixed in mind. I am for R3. Sorry.
ಆಯ್ತು, ಅದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಕಾಲ್ ಆಫ್ಟರ್ 4 weeks. ಇಂಟರ್ ಮಾಟರ್ ಇದೆಯೇನ್ರಿ? ಆಯ್ತು. ಡೇಟ್ ಗೇಟ್ ಇಲ್ಲ. ಎಸ್.
20, L Lakshmi, K Lakshmikant, KV Narasimhan. Number 20,
None appears to the petitioner, call after 4 weeks, needful by then.
21, G Manivannan.
Respondent 4, man.
Where is the petitioner?
Alala, for the fourth respondent, representing Geeta Devi,
MP Geeta.
in this matter, my lord, the lordship kindly peruse the order dated 30/9/2024.
ನಾವು ಬರ್ಲಿ.
Alla, Barley, I permitted to file an application to implement the purchaser pending later, man.
ನೀವು
Officers-
application ಹಾಕಿ.
Alla, I have filed the application, notice agila inna. Officers raised an objection that wakalat is not filed along with the application. I filed the application to implement the purchaser, my lord. Notice will have to be ordered, my lord.
Issue notice on IA 2 of 2024.
Office objection may kindly be removed.
Observations kept open. Issue notice on IA 2 of 24 to the proposed respondent.
Please, much of.
22. Ramesh K.R. Hanumanthappa, we are-
2 weeks to do the need.
There is an interim order.
Interim order if any is extended till next date of hearing.
Please.
23. Naveen G.S.
Appearing for the petitioner, my lord. My lords, R6 has been escaping to receive the notice, my lords. We tried to contact the same, but we could not. My lords, kindly a week's time may be granted.
Yes, 1 week to do the need.
My lords, the interim order may be extended. my
Interim
lords.
order if any is extended till next date. of
Grateful.
hearing. 23 now.
24. Swati Ashok.
Building applicant, my lord.
Yes, none appears for the petitioner, 2 weeks to do the needful.
Date may be given, my lord. Impending application file ಮಾಡಿದ್ದೀನಿ. I file impending application, my lord.
Officer like,
File ಮಾಡಿದ್ದೀನಿ, my lord, already.
25.
I don't know, let us see.
Date may be given.
2 weeks to do the needful.
Bharadwaj R. Rao.
The stay has been extended in this.
ಯಾವ್ದ್ರಲ್ಲಿ?
25.
Rajendra M.S.
I'm for the, let's have filed.
Ready is the arguments ಹೇಳಿ, ready ಇದೀರೇನ್ರಿ?
Objections ಹಾಕ್ಬೇಕು. Let's make
The
it
request of respondent call after 2 weeks, objections if any by then, interim order if any is extended till next date of hearing.
Much of this.
26. Narendra Gowda.
Dismissed as withdrawn.
ಎರಡು ಸರ್ ಇಲ್ಲ ಒಂದು ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್
Okay, 26 ಮಾತ್ರ dismissed as withdrawn, 26.1 ಅಲ್ಲ. 26
For
ಮಾತ್ರ-
respondent number 4 in this case, my lord.
26 ಮಾತ್ರ dismissed as
20 connected matter, WP 10701.
ಹಾ.
I am for the fourth.
That will be
ಇದು 26.1 ಅಲ್ಲಿ at the request of petitioner call after 2 weeks. 2 weeks.
27.
One
Montes is
submission.
postponed.
Serial number 24, your lordship. I appear for petitioner interim order to be extended in that, your lordship.
24. None appears 2 weeks.
I was next court.
You didn't appear.
I was stuck in that.
Okay, 24 ಅಲ್ಲಿ at the request of petitioner call after 2 weeks.
Date may be given.
Interim order if any is extended till next date of hearing.
In 27, I have served the copy, my lord.
Hmm?
Office objection, my lord, copy served acknowledgement ಹಾಕಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. 27.
I received.
Government.
ಕೊಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದೆ.
ಆಯ್ತು, ರೆಡಿ ಇದೀರಾ?
Ready, sir.
ಕೊಡಿ.
May require some time, my lord.
No, go on with the matter.
Not prepared, my lord, since.
What is this? It's your writ petition, I say, go on with the matter. Interim order ಇದೆಯೇನ್ರಿ?
ಇಲ್ಲ interim order ಇಲ್ಲ.
Just, and a message.
Go on with the matter, sir. Yes, ready ಇದೀರಾ?
Yes, ma'am.
Why it was refused?
They have sought for mandamus, my lord. As per the court direction, they are required to issue Kayam Sagoli chit, but he is not entitled for any of the grants, my lord. At page 46, annexure clearly issued a report from the deputy Tahsildar to Tahsildar. There they have clearly mentioned, my lord. It is a Sarkari Kharabu land. It cannot be granted. Simply they have filed a writ for mandamus to different courts, my lord. And saying that the court has given direction, so you do issue.
This is
Sagoli
the
chit.
danger of madam,
Yes,
I'll
ma'am.
tell you.
That's why the
It
report
is,
has
it
not
is
been
incorrect submission, my lord. I have not filed any, my lord, only one writ petition I have filed. My lord, may kindly peruse, my lord, that is why I sought the time, my lord, it requires, my lord, a detailed hearing.
The request of petitioner call after 2 weeks.
28. Prasanna BR.
But ನೀವು appeal ಹಾಕ್ಬೇಕಿತ್ತು. the order passed by this court,
Yes, ma'am.
see, there is a mandatory injunction. I mean, sorry, there is a direction to issue him a sagawali check. See, it is not that consider and pass orders.
Yes,
There is a direction to, specific direction to issue a sagawali check.
One lot Hangami Sagoli cheat has been issued for a 5 years.
So, if you, once such a direction is there, you have to either obey or file an appeal. You just keep quiet and now say that he is not entitled to sagawali check. Where is the sanctity for the court orders?
There is
See,
no
madam,
positive-
listen, if there is a mandamus issue directing you to issue a sagawali check, he gets a right by virtue of the said order of this court. Right or wrong?
There is no positive direction till today, my lord.
Ida ನೋಡಿ ಅಲ್ಲಿ positive direction, ಕೊಡ್ರಿ ಇಲ್ಲಿ.
Your lordship orders, my lord, I have sought for, my lord, Cody and Durasti of the land. Your lordship was
Direction is
directed
to
to consider.
consider the representation.
While
No,
doing that,
Not that. See,
similar, that is not with respect to different lands, my lord, in consonance with that order, I have sought for. a
WP 2347 ನಿಮ್ ಲ್ಯಾಂಡ್ ಬೇರೆ ಲ್ಯಾಂಡ್
ಬೇರೆ
order ಅಲ್ಲ.
ಬೇರೆ ಲ್ಯಾಂಡ್
dated ಒಂದೇ ಬಂದಿದೆ.
ನೋಡ್ಬಿಟ್ಟು ಹೇಳಿ.
28 Prasanna BR.
appearing for petitioner, 2 weeks, pray for 2 weeks time, sir.
ಯಾಕೆ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂತೀರಾ ಎಲ್ಲ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್?
ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 20 ಡೆತ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಇದು ಕೋರ್ಟಲ್ ಮೂವ್ ಮಹಂತೇಶ್ ಹೊಸಮಠ ಕೋರ್ಟಲ್ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದು? ಕೋರ್ಟಲ್ ಯಾರು ಮೂವ್ ಮಾಡಿದ್ದು? ಎಸ್, ಬನ್ನಿ ಬರ್ಕೊಳ್ಳಿ ಹಂಗಾರ. ಸೀರಿಯಲ್ ನಂಬರ್ 27.
28
ಒಂದ್ ನಿಮಿಷ, 27 ಅಲ್ಲಿ ಆರ್ಡರ್ ಇನ್ನೂ ಮುಗ್ದಿಲ್ಲ. 27. The advocate for the petitioner got the matter listed by moving a memo, and when the matter is taken up for hearing, he prays for adjournment. Full stop. At his request, post the matter up to 4 weeks, subject to petitioner paying a cost of rupees 3,000. Yes, yes, sir. 3 weeks, 4 weeks time is granted. Cost of rupees 3,000 is imposed. Yes.
Listed in orders, not there.
Huh?
Listed in orders, not there, not. Listed in orders, not there.
ನೋಡ್ರಿ, ನಮ್ಗೆ ಇಲ್ಲಿ ಮೆಮೋಸು ಮ್ಯಾನೇಜ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ನಾನು 65 ಮ್ಯಾಟರ್ ಸಾಗಿಸ್ಕೊಂತಿದ್ದೆ. ಈಗ ಮೆಮೋಗಳು ದಿನಕ್ಕೆ 100 ಬರ್ತಾವ. ಅರೌಂಡ್ 100 ಮೆಮೋಸ್ ಐ ಆಮ್ ಗೆಟಿಂಗ್ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್. ಐ ಹವ್ ಇನ್ಕ್ರೀಸ್ಡ್ ಇಟ್ ಟು 80. ನಾವ್ ಎಕ್ಸ್ಟ್ರಾ ಕೆಲಸ ಮಾಡ್ಬೇಕು, ಕೋರ್ಟ್ ಆಫೀಸ್ ಎಕ್ಸ್ಟ್ರಾ ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಯಾರಿಗೆ ಕೇಸ್ ಬೇಕೋ ಅವ್ರ ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗೋದಿಲ್ಲ. ನೀವು ನಿಮಗೆ ಇಷ್ಟ ಬಂದಂಗೆ ಪಾರ್ಟಿ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾನೆ ಅಂತ ಅವನ ಹತ್ರ ಒಂಚೂರು ದುಡ್ಡು ಕಿತ್ಕೊಂಡು ಇಲ್ಲಿ ಮೆಮೊ ಕೊಡ್ತೀರಾ. ನಾವು ನೀವೇನೋ ನಿಮ್ಗೇನೋ ಅರ್ಜೆನ್ಸಿ ಇದೆ, ದೊಡ್ಡದಾಗಿ ಪ್ರಿಪೇರ್ ಆಗಿ ಬರ್ತೀರಾ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀವಿ. ಒಂದು ಕೇಸ್ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಅದು ಖರ್ಚಾಗ್ತದೆ, ಗೊತ್ತಾಯ್ತೇನ? ಜಸ್ಟ್ ಟು ಮೇಕ್ ಕಪಲ್ ಆಫ್ ₹1,000. ಆಮೇಲೆ ನೋಡು ಕೋರ್ಟಿಗೆ ಬಂದಿದೆ ನೋಡಿ ಇವತ್ತು ಲಿಸ್ಟು ಹೇಳ್ತೀರಾ ಪಾರ್ಟಿಗೆ. ಇಲ್ಲ ಬಂದ್ಬಿಟ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ, ಕೇಸ್ ನಡೆಸಲ್ಲ. ಬನ್ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಇಸ್ ರೆಡಿ, ಯು ಆರ್ ನಾಟ್ ರೆಡಿ. ನಾವು ಧಾರಾಳವಾಗಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಡ್ತೀವಿ, ನೀವು ಮಧ್ಯದಲ್ಲಿ ಕಾಸು ಮಾಡ್ಕೊಂತೀರಾ ಅಷ್ಟ. ಅರ್ಥ ಆಯ್ತಾ? ಇವಾಗ ನಾನು ₹3,000 ನಿಮಗೆ ಕಾಸ್ಟ್ ವಿಧಿಸಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಅಷ್ಟೊತ್ತಿಗೆ ಕಟ್ಟಿ ನೀವು ಜೇಬ್ಗೆ ಹಾಕೊಳ್ಳೋ ಬದಲು ನಮ್ಮ ಇದು ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ಗೆ ಹಾಕ್ರಿ. ನಮ್ಗೆ ಒಂಚೂರು ಇದು ಟಿವಿ ಗಿವಿ ಇದು ಒಳ್ಳೆ ಕುರ್ಚಿ ಗಿರ್ಚಿ ತರಿಸ್ಕೊಂತೀವಿ ನಾವು. ಎಸ್, ನಿಮಗೂ ಕೂತ್ಕೊಳ್ಳೋಕೆ ಒಳ್ಳೆ ಕುರ್ಚಿ ಮಾಡಿ ಸಾಕಿಸ್ತೀವಿ. ಕರೀರಿ 28. I pass my order, sir. If you are agreed, file an appeal. Yes, serial number 28.
Prasanna BR.
Pray for 2 weeks time.
Yes, ಇದನ್ನು ₹2,000 ಕಾಸ್ಟ್. ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ ಅಟ್ ಯುವರ್ ಇನ್ಸ್ಟೆನ್ಸ್. ಕೊಡಿ, ಅದು ಇದನ್ನ ಕೊಡಿ, ಯಾವ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ, ಇಲ್ಲಿ ಹೇಳ್ತೀನಿ. ವಿನಾಕಾರಣ ಮೆಮೊ ಮೂವ್ ಮಾಡೋದು, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕರ್ಟೈಲ್ಡ್. ಯಾರು ರೆಡಿ ಇರ್ತೀರಾ ಹೇಳಿ, ನಮಗೆ ದಿನಕ್ಕೆ 15 ಡಿಸ್ಪೋಸಲ್ ಸಿಕ್ಕಿದ್ರೆ ಸಾಕು ಸರಿಯಾಗಿ.
awaiting notice ಅಂತಿದೆ ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ 20 ತೀರೋಗಿದ್ದಾರೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ಆಯ್ತು, ಇದು ಡೇಟ್ ಗಿವನ್ ಎಂದಿದೆ? ಡೇಟ್ ಗಿವನ್ ಓಕೆ, ಕಾಸ್ಟ್ ಇಲ್ಲ. ಬಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಅಲ್ಲ, yes, 1 week time is granted
2 weeks time.
to do the needful. Steps ತಗೊಳ್ಳಿ first.
29 Sudhakar Reddy BV.
Number 29.
ಇದು ನೋಡಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂಡಿ ಯಾತಕ್ಕಿದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಏನಂತ ಹೇಳಿತ್ತು ಆರ್ಡರ್ ಆಗಿತ್ತು ಇದು ಟೈಮ್ ಆಗಿತ್ತಾ ಕಂಪ್ಲೈನ್ಸ್ ಏನು ಆಯ್ತು 2 weeks to do the needful. Yes.
30, use Rohit Sikaria. Petitioner by me, my lord. State has to file the objection.
2 weeks time maybe.
The request of respondents call after 2 weeks.
In the meantime, my lord, office objections are welcome. On IA, my lord, office objection.
41 appearing for the
Flash.
41 appearing for the petitioner. Lords.
Compliance by
Lords, office objection which has been mentioned is that Annexure G nalli Chinnaya anta toriside. His name is Jinnaya in the even in the offshoot proceedings, my lords, it was only Jinnaya. Then subsequently it was typed as Chinnaya in English, my lords, which has now translated to Chinnaya even in Kannada in the impugned order. That is the office objection which has been raised, my lords. I have given
all subjections kept open.
My lords, the case is that the petitioner, my lords, is owner of land to an extent of 3 acres and 3 guntas, my lords, which is situated at Samse village. Now, my lords, his mutation dates back to the year 1981, which is at page number 18, my lords. In the interregnum, my lords, a PODI came to be formulated, which, my lords, divided this survey number 15 into 15/1 to 15/4, my lords. This was done behind the backs of the petitioner, my lords. And that, my lords, this was brought to the notice of the ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ತಾಂತ್ರಿಕ ಸಹಾಯ ಹಾಗೂ ಪದನಿಮಿತ್ತ ಭೂದಾಖಲಾತಿಗಳ ಉಪನಿರ್ದೇಶಕರು, my lords. I draw the attention of this honorable court to page number 31, my lords. Page number 31, annexure D, my lords. Wherein at paragraph number 2, it can be observed that ಮೂಡಿಗೆರೆ ತಾಲೂಕು ಕಳಸಾ ಹೋಬಳಿ ಸಂಸೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿ ಮೇಲ್ಕಂಡಂತೆ ಹಂತ ಹಂತವಾಗಿ ಸರ್ವೆ ನಂಬರ್ 15/1, 2, 3, 4 ಪೋಡಿಯಾಗಿರುತ್ತದೆ. ಸಂಬಂಧಿಸಿದಂತೆ ಪೋಡಿ ಮಾಡುವಾಗ 4ನೇ ಎದುರುದಾರರು, ದಟ್ ಇಸ್ ದ ಪಿಟಿಷನರ್ ಹಿಯರಿನ್, ಅನುಭವದಲ್ಲಿ ವ್ಯತ್ಯಾಸವಾಗಿದ್ದು ಅನುಭವವನ್ನು ಅನುಸರಿಸಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ದುರಸ್ತಿ ಪೂರೈಸುವುದು ತಾಂತ್ರಿಕವಾಗಿ ತಪ್ಪಾಗಿರುತ್ತದೆ ಎಂದು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯ ನಿರ್ದೇಶಕರು ಮೂಡಿಗೆರೆ ತಾಲೂಕು ರವರು ನಕ್ಷೆ ಹಾಗೂ ವರದಿಯೊಂದಿಗೆ ಸ್ವಯಂ ಪ್ರೇರಿತ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿ ಮೇಲ್ಕಂಡಂತೆ ಅನುಭವಕ್ಕೂ ಹಿಸ್ಸಾ ಪೋಡಿಗೂ ವ್ಯತ್ಯಾಸ ಇರುವ ಹಿಸ್ಸೆಗಳನ್ನು ರದ್ದುಪಡಿಸುವಂತೆ ಮನವಿ ಮಾಡಿರುತ್ತಾರೆ. ಪ್ರಕರಣದ ವಿದ್ಯಮಾನಗಳನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲಾತಿಗಳು ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಮೂಡಿಗೆರೆ ರವರು ತಾಲೂಕು ರವರು ಸ್ಥಳ ಪರಿಶೀಲಿಸಿ ಸಲ್ಲಿಸಿರುವ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿದೆ ಹಾಗೂ 1ನೇ ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಮನವಿಯನ್ನು ಪರಿಶೀಲಿಸಿದೆ. ಈ ಹಿಂದೆ ದಿನಾಂಕ 6/10/2015 ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿ ಅಳತೆ ಮಾಡಿ 1, 2 ಎಂಬುದಾಗಿ ಹಿಸ್ಸಾ ಪೋಡಿಯಾಗಿದ್ದು ಅದರಂತೆ ಹಿಸ್ಸಾ ನಂಬರ್ 15/2ರಲ್ಲಿ ಶ್ರೀ ಜಿನ್ನಯ್ಯ ಬಿನ್ ಚಂದಪ್ಪಯ್ಯರವರಿಗೆ 2 ಎಕರೆ 31 ಗುಂಟೆ ಪ್ರದೇಶಕ್ಕೆ ಪೋಡಿ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಆದರೆ ಸದರಿಯವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 15/3ರಲ್ಲಿ 5 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಸ್ವಾಧೀನ ಇರುವುದು ಸ್ಥಳ ಪರಿಶೀಲನಾ ವರದಿಯಿಂದ ಕಂಡು ಬರುತ್ತದೆ. ಕಾರಣ ಸಂಸೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 15ರಲ್ಲಿ 1/2 ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 1ರಲ್ಲಿ 3/4 ಎಂಬುದಾಗಿ ಹಿಸ್ಸಾ ಪೋಡಿ ಮಾಡಿರುವುದು ವ್ಯತ್ಯಾಸವಾಗಿರುವುದರಿಂದ ದಾಖಲೆಗಳನ್ನು ಸಮರ್ಪಕವಾಗಿ ನಿರ್ವಹಣೆ ದೃಷ್ಟಿಯಿಂದ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಿದೆ. They set aside the podi done, my lords. Now, my lords, a revision petition comes to be filed, even, my lords, eclipsing the fact that there is a availability of second appeal under section 50. A revision comes to be filed. A revision is a limited jurisdiction. Without going through any of these aspects, my lords, the impugned order comes to be passed, my lords. Wherein originally the revision petition came to be filed before the deputy commissioner. Now, my lords, during the pendency of the proceedings,
Same family name,
my lords,
same family members
not a same family members, my lords. They are different persons altogether. The fact is that, my lords, a road came to be put up across the agricultural land. While during that process, 5 guntas of land on which the house of the petitioner is situated went on the upper portion of the road, and the agricultural land came to the lower portion of the road. Now, my lords, while during the course of podi, they have considered the lower portion of the property situated, whereas left out the upper portion of the road, my lords. Therefore, my lords, this extent of 5 guntas is now under dispute. Now, the contention of the petitioner is simple, my lords. You set aside the earlier podi. On my participation, as well as recognizing the possessory rights, you go into the merits of the matter and do a new podi. That's all the contention.
Accept notice for response.
Petitioner have an alternative remedy before the tribunal. Petitioner have an alternative remedy before the.
For revision petition, I don't have any alternative remedy, my lords, and it is a
50C, 51C, may kindly see.
51C of?
Karnataka Land Revenue Act, my lord. If such an order is passed by the Joint Director of Land Records or Joint Director of Settlement, or by the Director of Survey, Settlement and Land Records to the Tribunal. The Joint Director of Land Records has passed the order, my lord. Under section 49.
This is an order passed under section 56.
No, under what provision he has an appeal according to?
B, 1C, my lord, of the Karnataka Land Revenue Act.
Don't see ಅಂತ ಯಾವ್ದು ಇಲ್ಲ.
Section 51C, yeah.
51C, my lord, 50.
Okay, 50.
Please, 501C. Subclass 1C.
My lord, that is as against.
1 second, appa.
Yes,
Examine it.
yes, my lord, please.
If such an order is passed by the Joint Director of Land
A
Records.
second appeal shall lie against any order passed in the first appeal under section 49. This is, this order is passed under section 49. huh?
49.
ಇಲ್ಲ ಇಲ್ಲ, it is under section 56, my lord. It's a revision, my lords. It is not a first appeal.
Impugned order lida.
Impugned order at annexure G, my lords, 43. It is under section 59. The categorically states, my lords, it is a RP. Revision petition 489/2021-22, which is under 56, my lords. It has been preferred. The petition also, my lords, is produced at annexure E, my lords, which is under 56 of KLR.
No,
56 is a revision petition for which there is
49A,
no
my lord.
appeal.
They have mentioned 49A.
Illa, it is under annexure E may be seen, my lords. It is the petition originally preferred by the petitioners, the respondents. It is under section 56. Because the original proceedings was an appeal, my lords, which is at annexure D.
This is a proceeding under section 56 comes. Either ನೋಡಿ first paragraph of the impugned order ಅಲ್ಲಿ ಬರುತ್ತೆ.
Yeah.
A was the offshore original proceedings.
They have mentioned 56, my lord. Here 49A ನಲ್ಲಿ order pass ಮಾಡಿದ್ದಾರೆ.
ಪ್ರಕರಣ ದಾಖಲಾಗಿರೋದು
They don't
section
read.
56 ಕೆಳಗಡೆ.
Article 56, my lord.
ಹಾ, ಮತ್ತೆ
Even the 56 also, my lord, 56(2). All revenue officers shall be deemed to be subordinate to the tribunal. 56(2).
correct, but 49 applicability ಆಗಲ್ವಲ್ಲ.
Even though, my lord, it's a
What kind of appeal I can
56,
prefer against a revision?
power for revision. Later on, my lord, 56(2) says all revenue officers shall be deemed to be the subordinate to the tribunal.
My lords, that is for the purpose of preferring a revision.
Tribunal has to adjudicate the matter, my lord. Whether,
Lords,
appeal provision ತೋರಿಸ್ರಿ. Where does it say? An order passed under section 56 is appealable ಅಂತ.
Please.
Where does it say? Show me, I will dismiss it, reserving him the liberty.
(56)(2), my lord. 56(2).
It is for a revision, my lords, to be
Section
filed.
56(2).
56(2) is not an appeal. It is a revision to be filed.
If in any case it shall appear to the tribunal or to such officer as aforesaid, that is including the officer here under. Notice ಹೋಗಿ ಬರ್ಲಿ ಬಿಡಿ.
Please.
ಏನ್ ಬಂತ ಹೇಳಿ? Notice for respondents. 1 to 4, issue emergency notice to respondents, 5 to 7. Next, there shall be stay of further proceedings pursuant to the impugned order dated so and so, wide annexure G to the writ petition, passed by so and so, till next date of hearing. Yes.
Macha, please.
32, Nagesh.
1 week to do the needful, comply with officer directions.
Monday, my lord.
1 week to do the needful, ಮಾಡ್ಬಿಟ್ಟು ನಾವು
Anand Shetty.
My lords, the needful has been done, my lords. An amended cost title has been filed. It was filed today, my lords.
The advocate for the petitioner submits that needful has been done. Next week, Akla.
Very well. David,
That is a request call next week.
grateful.
34, Saravana, yes.
Lords, it's that matter, your lordships indicated, the lords, when the matter came up the last occasion. that This is only an application for recall, not even a review. Lords, I filed a review petition, my lords, which is filed today. Lords, I'll take my chance, my lords. If I'm in a position to convince otherwise, my lords, just a human difficulty is, there are 3 daughters. ಆ 3 ಜನ ಹೆಣ್ಮಕ್ಳಿಗೂ ಮನೆ ಕಟ್ಸ್ಕೊಟ್ಟು ಬುಧವಾರಕ್ಕೆ ಅಥವಾ ಗುರುವಾರಕ್ಕೆ ಹಾಕ್ಸ್ಕೊಂಡ್ರೆ I will take my chance, my lords. I understand. And what your lordships have said, there is nothing incorrect with what your lordships have expressed, my lords. I do not want to say beyond it. Thursday, my lords, I'll take a chance.
The request of petitioner call on Thursday.
Please, my lords.
Thursday, Friday. Thursday, tax.
Please, my lords.
35, Lokesh Bonahalli.
Objections ready.
Objections. And I'm unable to pay.
For
Directly in the counter. Objection is ready, but it is, I'm unable to file it.
Sharing ನೀವು.
I'm for the petitioners.
Petitioner ನೀವು ಅಂತ objection ಹಾಕೋದು.
ಅವರು IA ಹಾಕಿದ್ರು. Proposed application ಹಾಕಿದ್ರು. ಒಂದು implementing application ಹಾಕಿದ್ರು.
ಆಯ್ತು, ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ.
Please.
Request of petitioner call next week. ಆಯ್ತು, ಡೇಟ್ ಕೊಡಿ.
2017 matter, date may be fixed.
ಡೇಟ್ ಕೊಡಿ.
28.
Please.
36, Abhinav R. For petitioner, my lord. R2 impleading application ಹಾಕಿದ್ದಾರೆ. R2 passed ಇದೆ. LRs have filed an impleading application. It may be allowed, my lord. I'll carry out amendment.
Yes. Odds on IA 1 of 2024. It is submitted that respondent number 2 died on.
During 2017, lads. 17. On 24/9/2017, lads. 2017.
24/9/2017. The aforementioned application is filed to bring the legal representatives on record. So and so undertakes to appear for the proposed legal representatives. ನೀವೇ appear ಆಗ್ತೀರಾ?
Yes.
ಬರ್ಕೊಡಿ. ಹೆಸರು.
MS Manjana.
MS Manjana. Undertakes to appear for respondents to full stop. Next, accepting the caution. The aforementioned IA is allowed. Petitioner is directed to amend the writ petition, file amended petition within a period of 2 weeks from today.
May be permitted to carry out amendment now itself. Yeah, please. 7,
Vishwas Gowda.
I appear for petitioner, my lords. Kindly pass over the matter. Senior is engaged in another.
Password.
Grateful.
38.
My lords, I appear for the petitioner, my lords. 38.
Memo for retirement.
Lord,
For whom?
Yes.
Memo for retirement.
ಯಾರಿಗೆ?
My lords, they were the previous counsel on record. I filed my NOC wakalat on Saturday.
You are Sidmalappa. So and so undertakes to appear for the petitioner.
My lords, LM Chidanandaya, the name of LM
Registry is directed
Chidanandaya.
to show the name of so and so is the advocate for petitioner.
Chidanandaya.
And delete the name of Shri so and so.
PM Sidmalappa.
My lords, and I,
Shri Siddhamalappa has filed his memo of retirement. Kudi,
my lords, I pray a week's time, my lords, to,
the request of petitioner call after 2 weeks.
my lords, in the,
I'll file my objections.
my lords, interim order to be extended, my lords,
Interim order if any is extended till next day.
in all matters, my lords, connected matters.
ಆಯ್ತು. ನೋಡ್ಬಿಟ್ಟು extend ಮಾಡಿ.
Grateful, my lords.
39, Prasanna VR.
For the petitions. The petitions are the tenants, my lords. Their applications came to be rejected by the tribunal, my lords, without considering the entries in the record of rights. As well as, my lords, the material placed on record. Lord, levy receipts were produced. RTC entries, my lords, show that they are in possession as on
Yes, respondents ready ಇದಾರನಪ್ಪ.
our private respondent number 3, my lord, is absent, my lords.
Will pass over, let's see.
ಅಲ್ಲ, ಅವರು ಫೋನ್ ಮಾಡಿದ್ರು, ಅವ್ರಿಗೆ ಏನೋ ಹೆಲ್ತ್ ಇಶ್ಯೂ ಇದೆ ಅಂತ ಹೇಳಿ, ಅದಕ್ಕೆ ಬಟ್
Okay. None appears for respondent number 3, call after 2 weeks.
ಅಲ್ಲ, ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಇದೆ, ಮಂಡೇ ಹಾಕೊಳ್ಳಿ, ಮಂಡೇ ಅವ್ರು ಬರ್ಬೋದು ಅದಕ್ಕೆ, ನೆಕ್ಸ್ಟ್ ಮಂಡೇ, ಸೊ ದಟ್ ವಿ ಕ್ಯಾನ್
None appears for
conclude the
respondent
proceedings.
number 3, call on Monday ಹಾಕೊಳ್ಳಿ.
Monday.
Interim order may kindly be extended.
Interim order if any is extended till next date of hearing.
Please, Majid.
Number 40, Shankar Narayan Bhatt.
For the petitioner.
Yes, I put the including applicants, my lord.
Petitioner advocate is no more, my lord. Mainly, I undertake to appear on behalf of the petitioner.
ನಿಮ್ಮ ಹೆಸರು
B.R. Raghavendra.
ಕೊಡಿ ಬರ್ಕೊಡಿ. So and so undertakes to appear for petitioner. Registry is directed to show his name and delete the name of Sri
S.N. Bhatt.
Shankar Narayan Bhatt.
S.N. Bhatt. Huh?
On
So
date
the
as
advocate
such.
appearing for the petitioner. Huh? Ready?
Pleading application.
Ready?
Date my objection to 2 weeks time to file objection.
Impleading allow ಮಾಡಬಹುದಾ ಬೇಡವಾ?
No, my lord, it is no more.
It is a villages, my lord, it is martial land, my lord, it is.
It's all right, you want some time. He is appearing now. At the request
date
of the
fine.
petitioner, call on 2 weeks bid date ಕೊಡಿ.
Interim order making.
411,
Much.
Interim order if any is extended till next date of hearing.
41, CM Nagbhushan. Number 41.
Yes.
Lord, we have filed an application for production of additional documents, Lord. It is with regard to regularization of
ಆಯ್ತು
land.
ನಿಮ್ಮ ರೆಡ್ ಪೊಸಿಷನ್ ಹೇಳಿ. ಏನಿದೆ?
ಅವ್ರ objections file ಮಾಡ್ತೀನಿ ಅಂತ.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇದೆಯಾ?
Production of documents.
ಹಾ?
IFR production documents. It can be,
ರೀಡ್ ಪೊಸಿಷನ್ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯೋ ಹಂಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳ್ತೀರಾ?
ಹಂಗೆ ಹೇಳಿ.
ಹೇಳ್ತೀರಾ? ಹೇಳಿ ಮತ್ತೆ.
Then my lord, it may be taken up next week.
ಯಾಕ್ರಿ? ಕೋರ್ಟಲ್ಲಿ ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರೆ?
Lord, filed an application for production of document, my lord.
The request of petitioner, call on next week date ಕೊಡಿ. ಅವತ್ತು ನೋ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್. 28 ಬೇಡ. ಆಯ್ತು ಕೊಡಿ. 30. 28, 29, 30 ಅವಾಯ್ಡ್ ಮಾಡ್ರಿ ಸ್ವಲ್ಪ. ಇದ್ರ ಫ್ರೆಶ್ ಮಾಡಿಸ್ ಬರೋದಾ ಊರ್ಗ್ ಹೋದ್ರಿಲ್ಲ ಅಷ್ಟೇ ಗ್ಯಾರಂಟಿ. 1, 2, 3, 4th one.
411.
411.
42, Mahesh Kiran Shetty.
But appearing for the petitioner in this matter, but he has filed application for impleading himself.
R. Ramachandraya.
Yes, I am impeding. He may not be the necessary party because if the averments made in the impleading application are concerned, he doesn't indicate any rights so far as his clients are concerned. But only he says that, my lord, it is a government land, except that nothing is forthcoming in his application.
Do you have objection for it?
Let him come on record.
You can come on record. We will allow the application.
Please.
You have filed the application.
And I have already filed, I only filed the application, my lord.
That's what. Orders on IA 1/2024. Full stop. The aforementioned IA is filed by the impleading applicants who wants to be impleaded as respondents. 6/2/14. Full stop. The petitioner has no objection for the same. Full stop. Hence, the same is hereby allowed. Petitioner is directed to implead the proposed respondent 6/2/14 as a respondent proposer, huh?
Yes.
6/2/14 by amending the writ petition and filing amended petition within 2 weeks from today.
Date may be given, madam. My lord, interim order may candidates.
Date ಬೇಕಾ?
Date. Interim order is.
I thought his request call on
611.
6/11. Interim
Please,
order
madam.
if any is extended till next date of hearing.
Please.
43,
Okay, for the
Rajeshwar P.
petitioner.
Apartments.
It's a matter where my lord's BDA commissioner writes a letter to the registrar.
Matter, huh?
Yes, my lords. They have
Big-
filed objections.
After, see, I'll tell you, ಇವ್ರ ಹತ್ರ indemnity ತಗೊಂಡಿರ್ತೀರ ತಾನೆ?
I'm filing the objection.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಇವ್ರ ಹತ್ರ indemnity ತಗೊಂಡಿರ್ತೀರಲ್ವೇನಪ್ಪ?
Sorry, my lord.
See, first land is acquired. ಯಾರ್ land ಆಮೇಲೆ ಬರುತ್ತೆ. First land is acquired. Right? You make an inquiry. Inquiry ಆಗಿದೆ ಅಲ್ಲೇನ್ರಿ?
Award pass ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ.
ಅಲ್ಲ, enquiry in the sense they have got it done through their police, STF police.
ಹಾ.
Inquiry ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ correct ಅಂತ
Inquiry ಮಾಡುತ್ತೆ. Listen
I'll point.
completely. An inquiry is conducted. You find them to be the owners of the property concerned. Okay? You find them to be the owners of the property concerned. You pass an award in their favor for sharing of land, for giving developed land. Okay, and you execute sale deed in respect of how many lands?
9 survey number, 9 sites.
9 sites.
In respect of 7 sites, they don't do.
Then on the ground that ಯಾರೋ ಮಂದಿ ಮೌಖಿಕ ದೂರು ಕೊಟ್ರು, ಅದನ್ನು ರಿಟರ್ನ್ ಇದಿಲ್ಲ. ಮೌಖಿಕ ದೂರು ಕೊಟ್ರು ಅಂತ ಅನ್ಬಿಟ್ಟು ಯು ಸ್ಟಾಪ್ ಎಕ್ಸಿಕ್ಯೂಟಿಂಗ್ ಸೇಲ್ ಡೀಡ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು 7 other sites. Okay, then you are not filed a police complaint against anybody. Have you filed ಮೌಖಿಕ ದೂರು ಒಪ್ಕೊಳ್ಳೋಣ?
I'll answer that.
ಪೊಲೀಸ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದ್ರೇನ್ರಿ ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಮೇಲೆ?
May I make the submissions?
ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಹೇಳ್ರಿ.
ಹೇಳ್ತೆ. Listen, Maukika Duru is not something which was received by the Commissioner of PDA. Maukika Duru is received by the Regional Commissioner. Regional Commissioner, my lords, may kindly have the order which is passed by him, communication, page 85, annexure
So
SL.
it is
I'll just
oral
point-
complaint
I'll point out.
by regional commissioner.
No, received to the Regional Commissioner.
Huh?
Received by the Regional Commissioner.
ಅದೇ oral complaint received by regional commissioner
Regional Commissioner.
and he communicates to you. ಇಲ್ಲೇನೋ
No, he does not simply communicate it to me. He points out very specific aspects with regard to the file which pertains to the petitioner here and says, look, these are, and my lords may kindly note, Regional Commissioner is not just some officer, my lords, who is not concerned with it. He is the officer who is the responsible one with regard to the Revenue Department. He is not some third party officer who is writing to me. He himself writes to me and says that, look, I have gone through the records which are there in my office, and myself, I prima facie find out, looking into the records, that these are fraudulent. I'll take my lords through that. Kindly have page 85 in the writ petition.
Okay.
And he says,
Huh.
for these things, it is apparent on the face of the record, prima facie, his view is that his own officers, along with the petitioner also, have committed fraud and they have manipulated the records.
Okay, I want to ask you a question.
Please.
I want to ask you a question. Having come to such a conclusion, as a criminal complaint,
That the state would have to answer.
state
ಹೌದು.
is a criminal complaint filed against any of your officers and the petitioner herein for having colluded with the petitioner and committed fraud on the state.
Secure, my lord, because this is the communication
And-
is of the very.
and
deep
second,
side.
I will pass it over, get instruction,
And second thing also.
get
Yes,
instructions.
my lord, this communication.
Ha, ಹೇಳಿ.
Second thing also, it is not, my lords, that for the first time, all of a sudden, something like this props up. When at the time of 17.5 inquiry or further before passing of the award cards, we note that this is a government line, government Mufat Kaval antide. This one person only has filed an objection. And this one person says that he has a grant certificate. He does not produce the grant certificate. He does not produce the grant certificate. He comes up with certain revenue documents, entries in the revenue entries and those ones and all. But doubt was arisen. Hence, my lords, we write to the concerned STF section, which learned senior also pointed out. That's the STF section also, my lords, does not have power over these sold records. So he writes to the Tahsildar and to the concerned and asks for a report. That's what the report sent back by them also is that, look, these are all the records which I have. Nobody has sent to me the original grant certificate or the, any order which has been passed was not received. Very part of those records, that is the recitation also there. But since the concerned Tahsildar himself has written to me stating that these are the records which are available with me, and it shows that there is an entry made, my lords, award was passed. I did not pass award sumo to stating or coming to a conclusion that yes, I'm fully satisfied that there is a grant made in his favor. My lords, there are other persons also appears who also are making a similar claim that they also have been granted maybe some portion of that larger extent of the land. None of theirs has gone through. It is only with, sorry, it's only with regard to the petitioner is concerned that there is some entry which has come up. Thereafter, because the STF section also could not find any other minutes, we passed the award. And we were also proceeding further. Now the regional commissioner says, please wait. Prima facie, I feel that there is some fraud which has taken place. Do not proceed further. Hence, I had two preliminary objections to also to bring to my lord's notice. That's one, the regional commissioner needs to be made a party. Secondly, Annexure A, which is,
State is made a party, that is
the
sufficient.
regional commissioner should also be made a party.
State is made a party, sir, that is sufficient, yes.
It's the consent section at that. Second, the Inspector General to whom the Annexure A is addressed, Annexure A is not addressed. Sorry. To respond number 4, it is addressed to the Inspector General of Stamps and Registration. ಅವರನ್ನು party ಮಾಡಬೇಕಾಗ್ತದೆ ಅಂತ.
Okay, anything else?
Those are two preliminary objections, sir. Whether they have initiated inquiry or not, well, state has to.
Yes, what do you say?
What's they say that we don't have a grant certificate and there's a no grant order, it's not correct. But kindly see, my lords, the grant certificate, grant order at page 22, annexure C, and the grant certificate at page 26, annexure C1. So that is there. And there's no comment made by the regional commissioner at annexure S with respect to the grant certificate and the grant order. He only says RTC mutation entries alla ಕೊನೆಯಲ್ಲಿ entry ಆಗಿದೆ, therefore it leads to a doubt. So it's based on a doubt. And he says inquiry is required to be made, and he writes to the government saying that we hold an inquiry. Nothing happens. Now, Commissioner BDA, after having been satisfied, award has been passed and sale deeds have been executed. Now, once an award is there, my lords, it's traceable to a statute. It becomes final. The only way that it can be set aside is either by reference or by filing a separate suit. The letter of the regional commissioner, my lords, is not traceable to any provisions under the Land Revenue Act. Lords, under the Land Revenue Act, my lords, the power vests either with the deputy commissioner, Tahsildar, or the assistant commissioner. Regional commissioner is not the original authority. So this letter cannot be traced to any provision under the Land Revenue Act, whereunder he could have exercised.
No,
his
I'm
power.
asking you a question.
My lord.
Supposing an award is passed, as in this particular case. Now, rightly or wrongly, the authority concerned comes to the conclusion, fraud has been played. Fraud has been played. Then the award is not completely fulfilled, as in this particular case. Now, under what provision of law they can withhold the award or set aside the award? Does the statute provides for it?
Yes. Once the award becomes final, my lords, under the Land Acquisition Act, by the approval of the
Land
competent
Acquisition Act,
authority, plus only under section 18 of the Land Acquisition Act could it be challenged. Or my lords could exercise jurisdiction under Article 226. So far as the Land
Land Acquisition Act ಇದೆಯೇನ್ರಿ? ನಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು ಇಲ್ಲ. ತರ್ಸಿ ಬೇಗ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಕ್ಟ್. ರೈಟ್ ಟು ಫೇರ್ ಕಾಂಪನ್ಸೇಷನ್ ತರ್ಸಿ ಇರ್ಲಿ. What provision, Rajesh?
Under section 12, my lords, once the land acquisition
So
officer
you
makes
said
the award.
section 18.
18 is the way it could be challenged. Kindly see section 12, my lord. Once an award is made under section 11, the land acquisition officer is required to, and it becomes final.
Okay, now if I pass an order directing them to fulfill the award, giving them the liberty to initiate appropriate inquiry in accordance with law, and you will not alienate your property for a period of 6 months. I think that balances out interest. See, listen, it's like this. ಒಂದು if it is state property, by playing fraud, someone else should not claim any compensation. Correct. Number one. Now, before passing an award, you are required to make all the necessary inquiries. And only upon complete satisfaction that he is the owner of the property, you are required to pass an award. Now, having passed an award, if you come to the conclusion he is not entitled to the award, if there is fraud and things that are played, there is an indemnity clause in the award that he will recompensate. Correct?
So they take an indemnity bond, my lord,
Huh.
after the award.
Yeah, there is an
Supposed to take an indemnity bond.
indemnity bond ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
They are supposed to required to do that. ಮಾಡಬೇಕು ಅದನ್ನು.
ಆಯ್ತು, ಇಂಡಮ್ನಿಟಿ ಬಾಂಡ್ ಅದನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡೋಣ
Please.
indemnity bond. And an indemnity bond.
Yes, I am prepared to furnish an indemnity bond if I have
Now-
not already furnished.
If you come to the conclusion, if it is your submission, that he has indeed played fraud and he has obtained the necessary compensation, and the fraud has been played in collusion with BDA officials and without proper authentication. Revenue officers in collusion with BDA officials. If it is your contention, fraud has been played by revenue officials in collusion with BDA officials, then you are immediately required to file a necessary police complaint against BDA officials, revenue officials, and the petitioner. Nothing on record shows that a complaint has so far has been filed against any of these parties concerned.
Yes.
Okay. So now listen, if we were to accept your submission, ಏನಾಗುತ್ತೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು, then persons like petitioner will be put to the way the government authorities are functioning. Lot of harassment. Lot of harassment. There will be extortion and blackmailing of the landowners. This much I can tell. I think you also are not in a position to deny it.
Not all.
If, okay, huh? For 6 months, I will direct them to execute the sale deed in respect of the other lands are also concerned. But you will not alienate those sites for a period of 6 months. Is it okay with you? Within which time, if they take any action, it's okay. If they don't take any action, then it's just to balance out equities. Tomorrow,
I understand, my lord.
if you play a fraud and you run away,
Lords, generally in
If you-
KDB matters,
if you-
with my experience with KDB, my lords, where an indemnity bond is taken and later on it is found that the person who took the compensation was not entitled to compensation, the way we enforce is under section 36 of the Land Revenue under the KD Act, which provides Land Revenue Act is to be invoked and proceed against the properties and recover it, my lords. That's the way it is, my lords.
no. What I am telling you is, tomorrow it is found that it is not your land at all.
Yes, my lords, I understand.
Okay, then they should be in a position to recover back whatever they have given it to you.
Understand.
Or we'll say that any alienation made by you.
Third party interest once it is created.
No,
Because that itself
that
will
will,
be cause.
that will be subject to, mister, you should have taken action, I say.
State is.
Hey, complaint ಹಾಕಿದ್ದೀರೇನ್ರಿ?
Your state has directed Millers to take it up. The regional commissioner has written.
Have
it to
you
them.
filed a criminal complaint?
State has to answer, my lords. State has to answer
They're
that.
very
No, against BDA officers, you'll have to say whether
My
complaint
lords,
is there or
Lords,
not.
complaint is raised by the regional commissioner and complaint
But
is.
subject to that, what has happened? It's a criminal offense. Once you allege for, see, you have said
But
that
once-
in your objection statement. Subsequently, on oral complaint, came to be raised before regional commissioner,
Yes.
Revenue Department, Bangalore, that the revenue officers, in collusion with BDA officials, had without proper authentication allotted sites measuring about 15,000 square feet, which values in crores of rupees. Acting on such complaint, the regional commissioner issued letter dated so-and-so, pointing out various lapses pertaining to the alleged grant in favor of petitioner and the dubious entries between 1981 to 2000. The regional commissioner has given specific remarks as regards the time period between the alleged grant on the date of allotment by BDA. The regional commissioner, who is the senior authority in the revenue department, has stated that the alleged entries in the revenue records and also mutation entries to be dubious and that the same needs to be inquired into, more so since the lands were classified as government lands. Please. Okay, since the allotment by BDA was based solely on the said dubious entries in the revenue documents and mutation entries, and also since public property in the form of developed sites were either allotted or sold or were to be sold in favor of the petitioner, the regional commissioner rightly asked second respondent to cancel all such orders of allotment in favor of petitioner, and also in cases where allotments were complete, to ensure that no third-party rights were created on such sites, and also directed to inquire if the officials of BDA were involved in the same. The second respondent, acting on the said letter, has issued the communication at Annexure A informing the Inspector General of Registration.
Inquire the officials of BDA were involved in the same or not? Did they inquire?
Did you inquire?
It's being initiated, my lords. Lords, we have
How
to
many
get the
days after,
information, my
after
lords.
the retirement?
Lords, we need to get the information from the revenue department also, what they have done.
No, after retirement. When did this happen? When did this happen?
20th May is the letter given by the commissioner.
20th May is the letter given by
In
commissioner.
October now, my lord.
Please.
Okay,
Once.
20th May. When was the impugned order passed?
It's the
June.
24th of June 2024.
25 was the letter given. Then impugned order was passed on
24th of June,
24th of June.
please.
Okay, what action have you taken against your hearing officers till date? This is how much? 21st of
October.
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 Please.
6 months. So I mean 4
4 months.
4 months have elapsed.
4 months.
Yes. What action have you initiated?
Once, kindly grant me some time. Lords.
No,
Maybe
no,
tomorrow I'll answer.
You inquire. I'll pass it over. You inquire and let me know.
It's tomorrow, Tawals.
No, sir.
Tomorrow morning itself I'll be there.
Okay. Day after tomorrow.
Plus, this is the practice in BDA, my lords. If everything goes well, everything goes well. Otherwise, they raise some queries like this
My
and
lords,
harass the
it's
petitioner.
My lords, it's the same with the ones my lords who make such incidents also. Then it's not that, my lords, every single person over there, my lords, it's quite clear.
See, Ajay, it's like this. See, we have.
Whereas for me, it doesn't come to our notice. The ones which comes to our notice, at least let us do something.
Listen. If it is government land, question of estoppel or anything does not arise at all. Don't worry about it.
Please,
Correct. Okay. And fraud vitiates everything.
please, certainly.
If it is government land, on false premise by forging documents, concocting documents, if he has taken compensation, he is liable to pay back the compensation along with the interest and also face jail term, criminal prosecution. You can proceed against him. Okay. At the same time, a mere allegation of fraud by any of the officer, including the topmost executive of the state, should not be a ground to harass an innocent land loser.
I bow down to that. I bow down.
Okay. Now, balance has to be struck. The law may not contemplate the actual method. I mean, the statute may not contemplate the actual methodology that has to be adopted. It has not contemplated that. Under these circumstances, what it should happen. No statute book says so. It is for the court to interpret it based on case-to-case basis. Now, here is a case. When is the preliminary notification?
2008, my lords.
2008 is the preliminary notification.
Please.
Final notification?
18 to 2010.
2010 is the final notification. We are in 2024. Still the matter is not settled. Just look at the plight of the land loser, number one. Okay, rightly or wrongly, you pass an award. When did you pass an award?
2/8/2022.
2/8
2022.
to 2022, you pass an award.
Please.
Okay. Now your officer passes an award after verifying all the documents and comes to the conclusion that he is the owner of the property. Now, the presumption in law is he is the owner of the property once you have passed an award. Okay. Now, the regional commissioner says that he has received an oral complaint and that he made certain inquiries, and it looks on the face of it that it is a dubious transaction. It's a government land, and the petitioner has illegally claimed ownership over the land concerned. Okay. He says so. And based on that, you put a halt for further execution of sale deeds in his favor. And also you intimate the officer concerned, the
Inspector General and
the sub-registrar concerned not to register any site in any
Not to permit
further
the petitioner to deal with the property.
to deal with already allotted sites. This you do on 24/6.
June, please.
24/6, then you sit quiet.
I understood what my lord said.
Listen, you sit quiet. No action, criminal action is initiated against any person concerned. That order is passed without hearing the petitioner. That communication is sent without hearing the petitioner. There is no speaking order as to why the award passed in favor of him is bad in law. If we allow, is it not state excesses?
Lords, at the time of framing the award, the land acquisition officer had the opportunity. At the time of confirming the award, the deputy commissioner had the opportunity. Thereafter, the time of allotment, the commissioner had the opportunity. Then the police had the opportunity. Tahsildar, deputy commissioner, through whom all these papers have gone through, had opportunity. All of them say everything was all right. And now when it comes to another 7 sites to be given, something amiss happens, therefore it is not being done. My lords could join the dots and find out why, for what reason this is being done.
I'll submit.
No, I'll pass it over. You get. Illa, sir. I'll pass over, sir.
Kindly have tomorrow morning. I'll do it. Kindly tomorrow morning, please.
See, any action initiated pursuant to today will not be considered.
I bow down to that. Kindly have it tomorrow. And let me crop and get. I've always come back. I'll come back.
Yes, for further hearing, the advocate for respondent number 2 and 3 has filed his objections. The same is taken on record. Copy kotidira?
Couldn't
Same is taken on record. Full stop. For at his request for further hearing, call on day after tomorrow date.
23.
Great. See, Ajay, government, you both, if no criminal complaint has been lodged till today, what is the time now? Till 12:49. I'm going to allow the report.
I'll inform.
See, it's a clear case of harassment.
I'll inform.
Yes.
44, Harish Bandari.
Ray, ನೀವು ಒಂದು ಕೇಸು ನಡೆಸಲ್ಲ, ಎಲ್ಲ ಬರೀ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತೀರಾ, ಆಮೇಲೆ ಅಡ್ಜರ್ಮೆಂಟ್ ಕೇಳ್ಕೊಂಡು ಹೋಗ್ತೀರಾ. ಏನೋ ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆದ್ರೆ ಸಾಯಂಕಾಲ ಬಂದ್ಬಿಟ್ಟು ಸ್ವಾಮಿ ರೀಕಾಲ್ ಮಾಡಿ, ನಾನು ಇರ್ಲಿಲ್ಲ, ಆ ಕೋರ್ಟಲ್ಲಿದ್ದೆ, ಈ ಕೋರ್ಟಲ್ಲಿದ್ದೆ, ಅಷ್ಟೇ. ಏನ್ ಮಾಡ್ತಿರೋ, ಏನ್ ಬಿಡ್ತಿರೋ. 2013 ಮ್ಯಾಟರ್. Tell him no further adjournment will be given. He has to be here by 2:30. Yes.
45 is done. 46, SK Acharya. P. Harish Bhandari.
Instructions ಇಲ್ಲ ನಿಮಗೆ. You want a passover. Get your friend. 2:30. Huh? Passover.
47, B. R. Prasanna. Nagaraj Jagde, K. Chandranath Tariga.
I go for spot number 3.
You're for whom?
Cuts have come.
Passover.
48, Uddarangappa. See number 48. Uddarangappa.
It's a restoration of Beelu.
Hmm?
They have challenged they have filed application for restoration of Beelu.
Restoration of?
Beelu. Pada land.
Uh-huh.
Pada land. They have, the Pada has entered in the year 1939, madam. They have purchased, the purchaser as before this honorable court. The purchaser purchased the land in the year 1940.
I'll dismiss it for non-prosecution. ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಮಧ್ಯಾಹ್ನ.
The last
Even on
date
the
of-
last date of occasion, twice the matter was called, none appeared. It's a 2017 matter. Why we should keep it pending if they are not interested? Passover. 2:30 ಬಂದಿಲ್ಲ ಅಂದ್ರೆ dismiss ಮಾಡ್ತಾರೆ.
49, D.S. Vasmat.
Here for the petitioners in this matter. One submission, advocate on record is no more. His name may be deleted and my name may be shown. Vide was not.
Yes, registry is directed to delete the name of C.D.S. Osmat and show the name of so and so as the advocate appearing with the petitioner. ವಕಾಲತ್ ಹಾಕಿದಿರಾ?
ಇದೆ.
ಅವ್ರ ಹೆಸರು, ನಿಮ್ಮ ಹೆಸರು ಬರ್ಕೊಡಿ.
Please.
Vinay D.
Vide was.
Vinay D. Vasmat.
Please. The petitioners in this petitions are challenging the order passed by respondent number 5 and 6, wide annexure B and K.
Ready now, that side.
Sir.
Ready?
Ready.
Comment.
Please.
1 second, wait. Why didn't you appear before the deputy commissioner,
Please.
assistant commissioner?
Assistant Commissioner Munda, I was not a party. After the order passed by the Assistant
You were
Commissioner,
you not required to go there?
the present petitioners purchased the property only after the order of the Assistant Commissioner. Deputy Commissioner Munda,
You purchased in the year 2015.
please, my lord.
Huh.
ACS passed an order
2017 the order is
2014.
passed.
ಅದು DC. Deputy Commissioner 2017 ನಲ್ಲಿ
Why didn't you appear before deputy
my
commissioner?
vendors, they said that they will give all the
That's no
documents and
ground.
they will get it done. Only mutation entries ಇದಿರೋದ್ರಿಂದ ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. But ultimately even the deputy commissioner said that
Release date ಮಾಡ್ಕೊಡಿ ಸರಿನೇನ್ರಿ ನೀವು?
No, your lordship, they are not the concern to the suit property, they are not related.
Listen, have you executed a release deed in respect of the suit property in favor of Shankar?
No, I am not executed. I am not in separate ಸಂಬಂಧ ಇಲ್ಲ.
Release deed copy ಎಲ್ಲಿದ್ದಾರೆ?
annexure E, my lords.
A genealogy, they are not,
In page 20.
they are not concerned to my family. You are pleased to go through the judgment of the DC, page number 9 or page number 59 of the order of the DC. 59 page in the order DC ಹೋಗಿರುತ್ತೆ. Annexure K ದಲ್ಲಿ page number 59
You come to page number 20, sir.
20.
20.
ಇವರು ನಾವು ಬರೋದು ಕೊಟ್ಟಿಲ್ಲ ಇವರು. This is ಬಿಡುಗಡೆ ಪತ್ರ ಅಂತ ಏನಿದೆ. They are not, we are not concerned to this family of this property.
Now, are you Siddhamari?
Yes, I am Sidmari, but this Lingaya, ಯಾರಿಗೆ ಬರೋದು ಕೊಟ್ಟು ಅವ್ರೇನ್ ಸಂಬಂಧ ಇಲ್ಲ ನಮಗೆ. The present petitioners are not concerned to my family.
Now, what is this release deed about?
ಅದು got up ಅಂತ it has been got up ಅಂತ ಹೇಳಿ ನಾವು concerned, it has been created in the contention ತಗೊಂಡಿವಿ ನಾವು. Therefore they are requested to go to the civil court and decide the matter with the rights of the parties.
It's a registered document, na?
Already.
Please, my lord.
It's a registered document, na?
Registered ಹೌದು.
Huh?
ಹೌದು registered. Registered document.
Come to page number 21.
Yes.
Is it your photo or not?
I have not seen, ಅವ್ರು ನೋಡಿಲ್ಲ ನಾನು.
Now, I'll order
I have
in
not,
police investigation into this. Are you agreeable?
I have not seen the parties.
I will order police if you make a submission, this is a concocted document, I will order police investigation into
No,
it.
I will discuss with the concerned parties. Party ಕಂದ್ರೆ ಯಾಕೆ ನೋಡಿನಿಲ್ಲ ಅವ್ರಿಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್.
I'm going to remand the matter, sir.
Yes.
I'm going to set aside the impugned order and remand the matter. Go to.
Please, my lord.
Remand ಮಾಡು.
Yes, Bani. The case of the petitioner is that they have purchased the property, which is the subject matter of the writ petition, by way of a registered sale deed dated
My lord, 13/4/2015.
13/4/2015 from one
L from Chandrama and others, the sons and daughters of,
one Chandrama and others, one Chandrama and others.
please.
Full stop. It is further submitted that petitioners, respondents 1, 2 and 3 had executed a release deed. Chandrama, Shankar and others ಅಂತ ಮಾಡಿ. ಯಾವ್ದ್ರಲ್ಲಿ?
Please.
ಮೇಲ್ಗಡೆ ಸೇಲ್ ಡೀಡ್. Chandrama, Shankar and others. ಅಲ್ಲಪ್ಪ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಬಂತಲ್ಲ ಏನ್ ಮಾತಾಡ? ಹಾ, ಎಲ್ಲಿದೆ ಚಂದ್ರಮ್ಮ ಅಂತ?
Please, my lord.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಚಂದ್ರಮ್ಮ ಎಲ್ಲಿ ತೋರಿಸಿದ್ರ?
Once. Second para, my lord. ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆ
Chandrama,
ಕೊಳ್ಳೇಗಾಲ
Shankar and others, huh?
ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ
ಆಯ್ತು ಇರ್ಲಿ.
ನಂಬರ್ 9 ಚಂದ್ರ.
Okay, it is further submitted. In favor of Shankar in respect of the Shankar in respect of the respect of Sri Shankar regarding the property consent, and Sri Shankar is one of the vendors who has sold the property in favor of the petitioner. Huh? Full stop. However, behind the back of the petitioners, impugned order by the annexure A to the writ petition has been passed by respondent number 5 at the behest of respondents 1, 2, and 3, wherein petitioners have not been included as a party.
ಪಾಸ್ ಬೈ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 ಮೈ ಲಾರ್ಡ್ಸ್ ನಾಟ್ 5.
Respondent number 5 re.
ಅಲ್ಲ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಪಾಸ್ ಮಾಡಿರೋದು. Okay.
Okay, deputy commissioner. Right. Respondent number 6 ಅಂತ ಮಾಡಿ. Full stop. Agreed by the same, the present writ petition is filed. Full stop. Next para. Admittedly, petitioners have purchased the property, which is the subject matter of the writ petition, by a registered sale deed dated
13/4/2015.
13/4/2015. Huh? Full stop. The impugned order has been passed without hearing them, and an order has been passed to mutate the names of respondents 1, 2, 3.
ನೇಮ್ಸ್ ಆಫ್ ಒರಿಜಿನಲ್ ಪರ್ಸನ್ ಮಾಸ್ ಇದ್ದ ಡೆಡ್ ಪರ್ಸನ್ ಹೆಸರಲ್ಲೇ ಇರ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಾರೆ. ಇವ್ರ ಹೆಸರು ಹಾಕಿಲ್ಲ ಅವರು. ಅವ್ರು ಡೆಡ್ ಪರ್ಸನ್ ಹೆಸರಲ್ಲೇ ಇರ್ಲಿ ಎಂಟ್ರೀಸ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಾರೆ. ದಟ್ ಇಸ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್.
impugned ಏನ್ ಬೇಡ ಅದೇನ್ ಬೇಡ ಏನು ಅಂತ ಹೇಳಿ ಅಂಡ್ ಏನ್ ಬಂತ ಅದಕ್ಕಿಂತ ಮುಂಚೆ without hearing them. Full stop. Full stop. Next para. Without hearing them. Full stop. For the sole reason that the impugned order has been passed without affording an opportunity to the petitioners, the writ petition is liable to be allowed. And it would be appropriate to remand the matter back to respondent number 6 to afford an opportunity of hearing to the petitioner and all concerned persons and pass appropriate order thereafter.
Okay.
Full stop. Hence the following order. The impugned order dated so and so, passed in so and so, by respondent number 6 is hereby allowed. Full stop. Next, the matter is remanded back to respondent number 6. Full stop. Petitioner and respondent number 1, 2, 3 shall appear before respondent number 6 on 6 weeks with date code. Three 12/2024. Full stop. The 24. Full stop. Respondent number 6 on 3/12/24 without any further notice. Without any further notice. Full stop. Respondent number 6 after issuance of notice to other concerned persons, if any. Shall hear all the parties concerned and pass appropriate orders thereafter as expeditiously as possible.
On time, 3 months or 6 months only.
Sir, notice over back, sir. Yes.
One more submission. If I am not wrong, ಫಸ್ಟ್ ಆರ್ಡರ್ ಬರೆಯುವಾಗ ಅನೆಕ್ಸ್ ಇಂಪ್ಯೂಂಡ್ ಆರ್ಡರ್ ಸೊ ಅಂಡ್ ಸೊ ವೈಡ್ ಅನೆಕ್ಸ್ ಅಂಡ್ ಸೊ ಅಂಡ್ ಸೊ ಇಸ್ ಅಲೌಡ್ ಅಂತ ಬಂದಂಗಿತ್ತು. ಸೆಟ್ ಅಸೈಡ್ ಆಗ್ಬೇಕಷ್ಟೇ ಅದು. ಪಾಸ್ ಬೈ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6.
This set aside ಅಲ್ಲೇನ್ರಿ? Set aside.
ಪ್ಲೀಸ್ ಮಚ್ಚು.
50, Sumant Bharadwaj.
The petitioner minutes. The cause of exorcisms are involved. Land grant to exorcismen. The land which is sought by the petitioners are already reserved for being granted in favor of exorcismen soldiers minutes.
File my objection.
The request of which call for 2 weeks objections.
2018 matter minutes.
Call on 2 weeks with date today objections if any by then.
Please,
Oxford 2018 matter, pa?
please.
611.
611.
Please.
51, Mithun Geraldine.
Yes, yes, respondent 4 and 17. Matter has to be remained back to the assistant commissioner. Directly they have filed a quick petition before this.
Challenge the mutation entry, my lord, before
This,
report.
this is the matter where
Matter has to be
the,
remained back.
Remedy before the assistant commissioner. Under section 136(2), there is a remedy before the assistant commissioner.
What is the impugned order?
please, Lords. This matter arose where pursuant to an order of 8/3/2017 or passed by the Honorable Court, the matter was remanded back to the Land Tribunal, Lords, for the fresh consideration of proceedings between the occupant and the occupant. The occupant was claiming the occupancy, the petitioner therein. And during the pendency of this Land Tribunal proceedings, the land owner has sold this property to one Girish, who has got the mutation done in his name during the pendency of the proceedings. Now, the Land Tribunal proceedings, there is no pendency, there is no constitution of the tribunal, Lords, because of this fresh, because of the elections, and then there is no sitting for a long time. Therefore, we could not approach before the tribunal. In the meanwhile, the again sold the land to another purchaser. He is also an impleading applicant before this court. While the matter is pending before the Land Tribunal, and even the Tahsildar is aware of the fact that the matter is pending before the Land Tribunal, he has allowed the mutation to be changed in favor of purchasers, and they have been subsequently further alienating the properties lots. And now, if I have to seek before the assistant commissioner, I cannot seek not to alienate or maintain status quo before the assistant commissioner. And Land Tribunal, there's no proceedings pending.
You're a tenant or
I'm an tenant, lots.
you're a tenant?
Tenant.
What
And
is
the
it?
Honorable Court has passed an order.
My lord, the sale did executed by one.
He's a rival tenant or a landlord?
He's a purchaser.
My Kata has been,
The original vendor,
Original vendor is the landowner,
landowner.
first purchaser. I'm an claiming occupancy again under Chick Narsamaya.
the sale transaction took place on 22/3/2007, my lord. To based on the sale date, Kata has been transferred. Matter is remained back 2017 remained back agide. Based on the sale date.
The order passed by this court?
Lords will find at page 105, Annexure K.
I have produced document number 1 along with applications, documents. Documents.
112 is operating.
I have produced a document 128 as per the document number 1.
Fourth respondent is not a party in the said proceedings. And 17 respondent.
Page 42, the Tahsildar, in spite of an order of remand, he has referred to the remand order as a dismissal of the said petition of the petitioner. That's page 42.
What is the order under challenge?
Because now they have
Passionate.
carried out an MR in respect of one Girish, and now he has further served it to another impeding applicant.
Now, where is the order of, which is the impugned order?
Impugned orders at page lots annexure A,
15.
15 and 16. The type copy is at 16.
Hmm.
The operation of the order is 17. The order sheet is at page 42, where the Tahsildar has effected the mutation during the pendency of the land tribunal orders, referring to the remand order as dismissal order.
Fine, you file an appeal on that.
Appeal.
The issue is here, Lords. The fact is that they are now further alienating the properties.
So what? See, I'll get you, they will not, revenue
Well-
entries are not, they do not confer any rights on them.
But they're forming layouts and they're alienating the property in favor of third party. Land tribunal is not under constitution, Lords. I have, at least if land tribunal is under constitution, I could have made them parties and stated
No,
that.
whatever it is, there is an appeal provided against this order, you file an appeal.
But in virtue of the fact that land tribunal is not in effect, I cannot seek any other remedial laws because they now, 2022 also, they further alienated the property.
Oh, see,
Before the assistant commissioner, I cannot seek an order of not to alienate.
it's like
Please,
this.
You have to
Please,
approach civil,
please.
civil.
See, I'll tell you, you will get a right or you will not get a right over the property concerned by virtue of the order of land tribunal. See, land tribunal order is something like a sale deed or a gift deed or something like that. Or an order of a civil court where it declares as to who is the owner of the property.
Please.
Okay. What are revenue entries? It is done for the purpose of collecting assessment. That's all.
That's true, Lords. But now,
Nothing else.
please.
If you want, I'll make see, you are aggrieved by an order passed by Tahsildar,
Please.
which is appealable under section 120,
136.
136.
36 to
136,
2
136 clause 2.
Please.
Okay, to the assistant commissioner.
Please.
Right, then
Please.
there is a revision to
Please.
the deputy commissioner. Where is the question of coming directly? I'll observe your right.
The difficulty is, Lords, if land tribunal was an
I'll
operation.
make that observation.
I would have made them a party there and I would have said they cannot alienate the property while the pendency before land tribunal is pending. I would have made all of them a party there, Lords, and also would have sought for an application for not to alienate.
I'll make all those observations. Land tribunal constitute agidi andre?
ಇಲ್ಲ ಇಲ್ಲ.
How can?
ಯಾವ
One month.
Bane. The petitioner,
my submission, my lord, the kata transfer on the based on the sale deed executed
the
in the year of.
petitioner has agreed by the order passed. ಈ ರೀತಿ ಮಾಡ್ಕೊಳ್ಳಿ. Agreed by the order passed by so and so. While annexure A to the writ petition. In so and so. The present writ petition is preferred. Full stop. Next para. The case of the petitioner is that he is a tenant.
Please.
Of the land concerned, of the land which is the subject matter of the writ petition. He is a tenant of the land which is the subject matter of the writ petition. And he has filed, case number ಎಷ್ಟು?
LRF 2027 of 1974-75.
2027
LRF number
of
2027 of 1974-75.
1974-75. Before the land tribunal. And the same is pending consideration.
Same is rejected by the.
Remand ಆಗಿದಲ್ಲ ಅಂದ್ರೆ the same, and the same is pending consideration. Full stop. In the meanwhile, the landlord
Please.
has alienated the property concerned in favor of has alienated in favor of some person.
Respondent number 4.
Respondent number 4.
And he has further alienated in respect of impeding applicant.
And he has further alienated in favor, in favor of
17.
17.
respondent number 17.
Please,
17.
please.
Full stop. Respondent number 17. Implementing application allow agidala.
Allow, please allow.
Respondent number 17. Huh? Full stop. It is submitted based on it is submitted that on the strength of the same, the third respondent has passed the impugned order. Correct?
Please, allow.
Third respondent has passed the impugned order. Full stop. Next para. The learned AGA appearing for respondent number 3. Respondents 1, 2, and 3 submits that the order impugned herein submits upon instruction submits that the petitioner has an alternative efficacious remedy, and the order impugned herein can be challenged under section 136 clause 2 of Karnataka Land Revenue Act 1964 before the jurisdictional assistant commissioner. Full stop. On the said ground, he prays for dismissal of the writ petition. Full stop. Next para. It is noticed that the petitioner is indeed having an alternative efficacious remedy under section 136 clause 2 of Karnataka Land Revenue Act 1964. 1964. Full stop. He is required to challenge the impugned order before the jurisdictional assistant commissioner. Full stop. It is needless to state that mere change of revenue entries does not extinguish the right of the petitioner if he has any over the property consent. Full stop. Revenue entries do not create a title in favor of
Subsequent.
any person consent. Full stop. Next part. For the aforementioned reasons, the writ petition is hereby dismissed, reserving the liberty to the petitioner to approach the appropriate authority in accordance with law. Full stop. If he were to so approach, the consent authority shall take into consideration the time spent by the petitioner in this court while considering any application made for condonation of delay. If preferred, if preferred. Full stop. Writ petition disposed of accordingly. Dismiss. Yes.
Good.
P2, M. Shiv Prakash, B.R. Prasanna.
Respondent number 7, please.
Layout and Monday,
Mandamus, they are seeking, my lord. The petitioner is.
Senior not in station.
Here already we have issued a endorsement. It has to be challenged. Next year, your own.
If he has already issued an endorsement, there is a question of mandamus.
Already issued an endorsement.
There is no grant records.
22, page number 22, my lord, annexure F.
Page number
22, my lord, running page 22.
22 of the writ petition.
22 of the restriction. Around document ಇದು ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ annexure F ಅಂತ ಮಾಡಿ.
Annexure D ಇದು
28, 28 and 29.
ರೈಟ್ ಟು ಇನ್ಫಾರ್ಮೇಶನ್ ಆಕ್ಟ್ ಕೇಳಿದಾರ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದರಲ್ಲಿ ಕಡತಗಳು ಲಭ್ಯ ಇರುವುದಿಲ್ಲ ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ. There is no grant at all. The bogus grant. Therefore, my lord, we have given this. There is no records available in the office of the.
ಎಲ್ಲಿದೆ ಕಡತಗಳು ಲಭ್ಯವಿರುವುದಿಲ್ಲ ಅಂತ?
Kindly see, my lord. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾಹಿತಿ ಹಕ್ಕು ನಿಯಮ 2005 ರಡಿ ಉಲ್ಲೇಖ ಸಂವತ್ಸರದಲ್ಲಿ ಮಾಹಿತಿ ಕುರಿತು ವಸ್ತಾರೆ ಹೋಬಳಿ ಅಣೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 260
Annexure F1
ಪ್ಲೀಸ್ ಕಡತಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲಾ ಅಧಿಕೃತ ಪತ್ರಗಳನ್ನು ಕೋರಿದ್ದು ಈ ಬಗ್ಗೆ ಅಭಿಲೇಖಾಲಯದಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಕಡತ ಲಭ್ಯವಿಲ್ಲ ಎಂಬ
Yes, Bane. The present writ petition is filed. Huh? With a prayer to issue a writ of mandamus against respondents 3 and 4 to issue relevant documents pertaining to the grant order made on 1/2/1943 in favor of one Srimati Siddhamma regarding
Survey number 126.
ಅಲ್ಲ, regarding Bada, as requested by the petitioner under the Right to Information Act 2000, Right to Information Act 2005. In brackets wide annexure F to the writ petition. Full stop. Next para, it is noticed that the concerned authority have issued a reply pursuant to the application made by the petitioner and have stated that no such document as requested by the petitioner is available. Full stop. Next para, in the light of the said reply, no direction can be granted to respondent number 3 and 4 as requested by the petitioner in the instant writ petition. Full stop. Hence, the writ petition is hereby dismissed. Yes,
Liberty may be reserved to challenge.
you can do whatever you want, sir. I did not say so.
Observation may.
Yen ಬೇಕಾಗಿಲ್ಲ.
PK Sanjay, 53.
For the respondent number 7 in this case.
2 weeks, madam. I'm for petitioner, madam. Kindly adjourn after 2 weeks, madam.
Your Honor, they have been taking time.
No, the reason is
What is this matter about?
I make some submission, Your Honor, whatever reason they have. Last hearing date, there was an affidavit which was filed by respondent number 1, clearly stating that the document which we are relying upon is a genuine document from what they were relying as annexure B. Now, they are avoiding on one or the other to take, if at least a date is, Your Honor, let them commit on that date to come and
When do you want?
a date for a upper.
When do you want?
after 2 weeks, madam.
Why no 2 weeks under? Next Monday.
Next Wednesday or Thursday, madam.
Monday
Next
end date?
Thursday, because senior function ಇದೆ.
ಈ ತರ ಹೇಳ್ತಾರೆ.
Preparation.
Function ಇದೆ.
ಅದಕ್ಕೆ.
95 years
Thursday or
petitioner
Wednesday.
ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ. 75 years DP holder ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ. ನಾವು ಮೂವ್
Right,
ಮಾಡೋದು.
we'll have it on 4th. 4th.
411.
But the request of petitioner finally call on 411.
Obliged, ma'am.
54 B ಬೆಳ್ಳಿಯಪ್ಪ, B ಬೋರೇಗೌಡ. 54 B ಬೆಳ್ಳಿಯಪ್ಪ.
Password.
55 ರಮ್ಯಾ ರಾಮಚಂದ್ರನ್.
My lords,
Preliminary objections on maintainability.
Hmm.
Order passed by the Assistant Commissioner is challenged without approaching the revisional jurisdiction and before the Deputy Commissioner. Straight away, they have filed the writ petition, not maintainable.
My lords, the response, my lords, to that objection, my lords, is that we were not provided an opportunity of hearing, my lords, before the assistant commissioner.
Okay, go before.
And my lords, moreover, my lord, there is gross misuse of jurisdiction, my lords.
Go before DC and ask the same thing. Now, when there is an alternative efficacious remedy, why should we bother?
My lords, there's settled law, my lord, that if.
Listen,
gross-
counsel. When there is an alternative efficacious remedy available, you please go there. Why rush to the High Court?
My lords, if there's gross misuse of jurisdiction, my lords.
Whatever, go and urge the same thing.
My lord, the property is converted to a residential property and under the Land Revenue Act, my lord, jurisdiction is assumed, my lord.
I'll
by
give
the-
you liberty to approach DC. Yes, Mani. The impugned order. It is seen that The petitioner is having an alternative efficacious remedy under section
136 of clause 3,
clause 3 of
Karnataka Land. Tribunal.
Karnataka Land Revenue Act 1964. And he is entitled to challenge the impugned order in brackets wide annexure A
And B, my lord.
B, impugned orders to the writ petition, which are passed by respondent number 2, 3 and 4 respectively.
3 and 4, my lord.
Correct,
Please, my lord.
3 and 4 respectively. Full stop. Next para. For the aforementioned reason, the writ petition is dismissed, reserving the liberty to the petitioner to approach the appropriate authority in the manner known to law. Full stop. If the petitioner were to approach the appropriate authority, full stop, comma. The time spent by the petitioner pursuing the writ petition before this court shall be considered for condonation of delay.
Both orders passed by 3, my lords, R3 only. Both orders A and B passed by Assistant Commissioner, not by Tahsildar. 3 and 4 anta bantu, 3 ಅಂತ ಆಗ್ಬೇಕು ಅಷ್ಟೇ.
3 ಅಷ್ಟೇ. ಎಲ್ಲಿ ಮೇಲ್ಗಡೆ ಏನ್ ಬಂತೇಳಿ? ಅದಲ್ಲ, ಬೈ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಅಷ್ಟ. 3 and 4 ಅಲ್ಲ. ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ಬೇಕಲ್ಲ ಅಂದ್ರೆ.
I apologize.
I presume that yeah, okay.
Girish Kumar PM. Punit C.
Before petitioner in this case.
Lords, respondent number 7, my lords, is dead, my lords, on 9/9/2024.
The request of petitioner call up to 2 weeks.
Great.
57, Jaikar Shetty, Kalyan R. Seal number 57. Jaikar Shetty H. Kalyan R.
But in this case, my lord, the petitioner has challenged,
Pass over ಮಾಡ್ಲಾ?
but please.
Pass over. ಆಯ್ತು, ಟೈಮ್ ಆಯ್ತು. ಲಿಖಿದ್ದು ಮಧ್ಯಾಹ್ನ.
Serial number 60, my lord. Weeks time may be given.
Yes, who is on the other side?
Will insert, my lord.
Serial number 60.
Respond.
Already punch.
They were-
He is asking for time. ಕೊಡ್ಬೋದಾ?
Date may
The-
be
The request of petitioner ನೀವು?
Yes, my lord.
Petitioner call on 2 weeks with date ಕೊಡ್ರಿ. 4th, 5th,
7.
6th.
With my lords permission, may I mention
Number
62, my lords.
62 ಅರ್ಜನ್ ಆಗಿದೆ sir.
My lord, the problem is, they have been seeking adjournments. It is ready for hearing. If my lords give me a date, I'll be deeply
62
obliged to my
ಕೆಲ್ಸ
lords.
ಮಾಡಿ ಒಂದು ಟೈಮ್ ಕೊಟ್ಬಿಡಿ. 2 weeks ಬಿಟ್ಟು.
511.
Grateful to my lords, obliged to my
511.
lords.
ಹೇಳಿ.
Serial number 63, your lordship, serial number 63.
1 second, 63.
Serial number 63, your lordship.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
I am for the respondent number 7 and 8, your lordship, in this matter. ಇದರ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ, IML ಪುಟ್ಟಪ್ ಆಗ್ಬೇಕು ಅಂತ ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ಅದಕ್ಕೆ
When the writ petition is there, you argue the matter.
ಇಲ್ಲ ಸ್ಟೇಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ, ಅದು
ಅಪ್ಲಿಕೇಶನ್ ಇರ್ಬೋದು.
ಅದಕ್ಕೋಸ್ಕರ IML
ಸ್ಟೇ ಇದೆಯಲ್ಲ, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
ಅದಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಗ್ ಅಪ್ಲಿಕೇಶನ್
ಬಂದಿದೆಯಲ್ಲ.
ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
ಅದಕ್ಕೆ IML ಆರ್ಗ್ಯೂ ಮಾಡಲ್ವಾ ನೀವು?
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ, ಇವತ್ತೇ. At least tell a proper reason if you want adjournment. What kind of submission is this?
Sorry.
This is absolute nonsense. You are finding a fault with the court for putting it in B group instead of to hear on IA, is it? And can that be a ground for adjournment?
Sorry.
Go on with the matter. Yes.
7 minutes.
Next week, any day. How, sir?
ಈಗ ಪಾಸ್ ಅವರ್
57.
You are for whom?
Petitioner.
ಈಗ ಪಾಸ್ ಓವರ್ ಆಯ್ತು.
ಅವ್ರು ಇದಾರೆ. Next week, any day. Please.
ಆಯ್ತು, the request of petitioner call on ನಿಮಗೆ ಬೇಕಾ ಡೇಟ್ ತಗೊಳ್ಳಿ, ಅವತ್ತು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳಿದ್ರೆ ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ.
Next week, any day, madam.
Monday.
ಆಯ್ತು, 4th ಹಾಕಿ.
411.
4th ಜಾಸ್ತಿನೇ ಕೊಟ್ಟಿದ್ದೀನಿ.
Serial number 58. And for respondent.
ಆಯ್ತು, interim order if any is extended till next date of hearing. 57. 58.
It is for respondent number 3. They have taken date without informing me.
ನಾನು ಏನಪ್ಪ ಮಾಡ್ಲಿ?
Any date may kindly fix.
ಆಯ್ತು 58 ಒಂದು ಡೇಟ್ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ 2 weeks ಬಿಟ್ಟು.
6/11.
ಹಾ
Serial number 78.
67, ma'am.
ಹಾ
Here for the petitioners, that the respondents try to file objections, readings are not yet complete. But kindly
67.
I'll file my.
No, no, no,
petition, my
no.
lord. Date may be fixed, my lord. any
ಆಯ್ತು
date.
2 weeks ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ.
8/11.
much of it.
Please.
Interim order may kindly.
Interim order finish extended till next date of hearing.
78, my lord, state has to file some affidavit. and request some more
70.
time. 8, my lord. LA matter release. Affidavit ಹಾಕಿ ಅಂತ direction ಇದೆ.
So parted matter, I am for the petitioner.
ಯಾವ್ದು ಪಾರ್ಟೆಡ್?
LA matter ಇದೆ sir,
In the
78.
Land acquisition matter, my lord, your lordship, before vacation, your lordship has heard on 25th. And
Huh.
government was asked to file some
File an affidavit.
report.
Not yet ready. Kindly grant me 10 days time.
The request of AGA call on date ಕೊಡಿ.
5/11.
Mobilized.
5/11. Parted matter.
Mobilized.
Adjournments.
A court officer, sir. Court officer, sir.
Ready, sir.
ಸರ್ ಇದು ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಮುಗಿತಾದ್ಮೇಲೆ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ತೆಗಿತಾರಾ?
ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ತಗೊಳಲ್ಲ ಸರ್. ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಡೈಲಿ 10 to 20 ನಾವು ಪಿಕಪ್ ಮಾಡ್ಕೊಂಡು ಮೇನ್ ಲಿಸ್ಟ್ ಹಾಕೊಂತೀವಿ.
ಆಯ್ತು.
ವಾರ್ನಿಂಗ್
ಓ
ಲಿಸ್ಟ್
ಆ ತರ. ಓಕೆ, ಅದೆಲ್ಲ ಏನು ತೆಗೋಲ್ದಿಲ್ಲ.
ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಕಾಲ್ ಮಾಡಲ್ಲ.
ಓಕೆ ಓಕೆ ರೈಟ್ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಅಂದ್ರೆ ಇವಾಗ ಈ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ಸ್ ನಾಳೆ ಬರುತ್ತೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ. ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಹಲೋ.
61ನೇ ಮ್ಯಾಟರ್ ಏನಾದ್ರು ಅಡ್ಜರ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಲ್ವಾ? 61. 61.
Reservation ಬಂದ್ಬಿಟ್ಟಿದೆಯಲ್ಲ ಸರ್.
ಸಾರಿ.
ಲಕಾಶ ರೋಡ್ ಇಲ್ಲ.
ಮಧ್ಯಾಹ್ನ. 2:30. ಹೇಳಿ ಮೇಡಮ್.
ಎಲ್ಲದವರು 54.
ಅದೇ ಸರ್ ಇವಾಗ ಈ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ನಾಳೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರುತ್ತೆ.
80. 88. 80. 2:30 ಗಂಟೆ. ಅದಾ ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟ್ರಾ? ನೋಡೋಣ, ವೇಟ್ ಮಾಡಿ ನೋಡೋಣ. ಹೇಳಿ ಮೇಡಮ್.
ಹಾ ಸರ್ ಇವಾಗ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಏನ್ ಬೇಕು?
ಅದು ಇವಾಗ ಇವತ್ತು ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನೀವು ಹಾಕಿದಿರಲ್ವಾ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ.
ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಕಾಲ್ ಮಾಡಲ್ಲ, ಕೇಳಿಸ್ಕೊಳ್ಳಿಲ್ವಾ? ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಕಾಲ್ ಮಾಡಲ್ಲ. ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ. ಡೈಲಿ ಪಿಕಪ್ ಮಾಡ್ಕೊಂತೀವಿ 20 ಮೇನ್ ಲಿಸ್ಟ್ಗೆ.
ಓಕೆ ಅಂದ್ರೆ ಇವತ್ತಿಂದು ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ನಾಳೆ ಬರುತ್ತೆ.
ನಾಳೆ ಬರಲ್ಲ, ಅದ್ರಲ್ಲಿ 20 ಪಿಕಪ್ ಮಾಡ್ಕೊಂತೀವಿ. ಬಿ ಗ್ರೂಪ್ ಫೈನಲ್ ಇಯರಿಂಗ್
ಓಕೆ ಓಕೆ
ಕಾಲ್
ಓಕೆ
ಮಾಡಲ್ಲ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಒಂದ್ ಸೆಕೆಂಡ್ 61 ಇದು ರಾಜಶೇಖರ್ ಸರ್, ರಾಜಶೇಖರ್ ಎಸ್ ಅಂತ ನೇಮ್ ತೋರಿಸಿಲ್ಲ ಅಂತ ಹೇಳಿ ನೇಮ್ ತೋರಿಸದೆ ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ, ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವುದು? ಒಂದು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಅಫೇರ್ ಆಯ್ತು, ಜ್ಞಾನಜನ ಸರ್
ಗೊತ್ತಿಲ್ಲ, ಆ ತರ ಇಲ್ಲ. ಫ್ಯಾಕ್ಸ್ ಮೇಲೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಅಲ್ಲ ರಾಜಶೇಖರ್ ಸರ್ ನೇಮ್ ರಿಫ್ಲೆಕ್ಟ್ ಆಗಿಲ್ಲ, ನೀವು ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು ಯಾವ್ದ್ರಲ್ಲಿ ಇದೇ ಯಾವ್ದು ಅಂತ ನಮ್ಗೆ ನಂಗೆ
ಆ ತರ ಇಲ್ಲ ನಮ್ಗೆ.
ಏನ್ ಸಮಾಚಾರ? ಊಟ ಮಾಡಿದ್ರಾ?
ಮ್ಯಾಕ್ಸ್ ಸರ್ ಇಷ್ಟ ಇಷ್ಟ ಒಂದು 7 ಆಯ್ತಾ ಸರ್? 2, 3, 4, 5, 6, 7, 8. ಪರವಾಗಿಲ್ಲ 8 ಆಯ್ತು. 5 ಆದ್ರೆ ಎಷ್ಟಾಗುತ್ತೆ? ಟಾರ್ಗೆಟ್ 10,000 ಆಗ್ಬೇಕು.
Memo in the morning and the wrong quote on the demolition should be held on witness.
ಜೋರಾಗಿ ಹೇಳಿ ಕೇಳಿಸಲ್ಲ.
Demolition to be held on Wednesday, my lord. I
Ah.
have moved a memo in the wrong hotel by tomorrow morning, Kindly have it for the tomorrow, my lord.
ನಾಳೆ ಇಲ್ಲ, ನಾಡದ್ದು.
Tomorrow 2:30 is
ನಾಳೆ ಟ್ಯಾಕ್ಸ್ ಮ್ಯಾಟ್ರ್.
Wednesday.
Day after tomorrow.
2:30 ಕರೀರಿ.
Number 80, 230 meter. 80 R.B. Sadashivappa, N.R. Girish, Chandan.
The lordship recollects. The lordship recollects on the last occasion, your lordship had directed BDA to file their objections, if any, on this. And they have filed their objections. They have served a copy on others as well. If your lordship peruses the objection at para 8,
ಯಾರು who appears for BDA?
BDA.
N.R. Girish.
He was here.
Can I get him? I'll pass over.
Much obliged.
His role is important, that's it.
Much obliged.
Call pass over matter.
Passover matters.
ಪಾಸ್ ಓವರ್ ಆಗತ್ತೆ ತಗೊಂತೀನಿ ಚಂದನ್.
Lordship.
ಪಾಸ್ ಓವರ್ ಆಗತ್ಲೆ ಮ್ಯಾಟರ್ ತಗೊಂತೀನಿ. ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಆಗತ್ಲೆನ.
Much obliged.
Try to find him where he is. Get him as soon as
Kindly pass over the matter.
Number
Senior
7.
counsel is engaged. ma'am.
Serial number 7.
Please. ma'am.
Girish Baladhare, Ajay Kumar Jain.
Challenge the order. 108 K, my lord. 108 K proceedings has been challenged before this honorable court. There is a appeal provision before the deputy commissioner. Straight away come before this honorable court.
Let them come, he wants a pass over.
Yes, ma'am.
Please, for a career, badme.
Please, my lord.
On the
Great.
dismiss it. Yes, next.
7. Passover
7
matters.
pass over, okay, 7 pass.
List 37, 37.
My lord, the petitioner is a temple, my lord. There is series of litigations, particularly emanating from a claim made by a post called Panchashala Guttedar.
ಎಂತ ಗುತ್ತೇದಾರ?
Panchashala Guttedar.
ಪಂಚಶಾಲಾ ಗುತ್ತೇದಾರ.
Guttedar.
Ah.
That is a temporary post, my lord, in any temple in the old Mysore area for 5 years for a person. There is a decision of this honorable court on that point, my lord, of Panchashala Guttedar, by his lordship Justice Baruka, that I will give on next time, my lord. Now, my lord, there was a claim by one person by name Narsimaya, who is now dead, claiming a right over this property belonging to the temple, 1 acre and 20 guntas. That he was dismissed by the tribunal. Then he went to the
ನಾನು occupancy rate ಕೇಳಿದ್ರಾ?
occupancy right. Now the matter is pending before this honorable court. The grant has been questioned on merit that is entirely different, my lord. It may take some time because litigation is there since 1977. The lordship may kindly see the judgment of this honorable court, ink page 41.
ಈಗ both sides, if you are ready, I'll go on with the matter.
No, my submission is only this, my lord. Now they are planning to alienate this property. Let there be a stay till next hearing date. Next hearing date with synopsis, everything. There are 7 rounds of litigations in the whole case.
You go on with now itself. I don't want to pass an interim order in a 2020 matter now.
Your lordship may kindly turn to ink page 41. my-
If you want to get ready, ನಾಡದ್ದೇ ಹಾಕೊಂತೀನಿ. Go on with the matter.
ಅಲ್ಲ ನಾಳೆ ಸೇಲ್ ಡೀಡಿಗೆ ಬಂದಿದೆ ಅದಕ್ಕೆ ಅರ್ಜೆಂಟ್
No.
let them give an oral undertaking. They will not sell the property.
Whatever it is subject to your rights.
Otherwise I am ready with the argument.
Go on with the argument. Are you ready?
I will file objections, my lord. Kindly have it on Monday. or
What
Tuesday.
objections you will file? You will file for what?
My lord, recently I have filed the wakalat.
Then don't alienate
ಅಲ್ಲ
the property.
ಎಲ್ಲಾರ್ಸ್ ಬಂದಿರೋದು ಅವರು. ಎಲ್ಲಾರ್ಸ್ ಬಂದಿದ್ದಾರೆ.
Then don't
Recent-
alienate the
ಅದು
property.
recently ಬಂದಿರೋದು ತಿಂಗಳಾಯ್ತು
Let
ಅಷ್ಟೇ.
them
ಆಯ್ತು, ನಿಮ್ಮ
not-
arguments
No,
ನೀವು ಹೇಳಿ.
objection, sir.
Let them not alienate.
ಕೊಡಿ ನಿಮ್ಮ arguments ನೀವು ಹೇಳಿ.
ಅಲ್ಲ ಎಲಿನೇಟಿಗೆ
Yes, ಹೇಳಿ ನಿಮ್ಮ arguments ಕೇಳೋಣ.
May your lordship may kindly turn to ink page 41. The judgment of this honorable court in writ petition number 15756/2005. First four paragraph, the entire facts is there, my lord.
41
41, annexure D. The petitioner is said to be tenant in respect of, ink page 43, my lord. Petitioner is said to be a tenant in respect of 1.26 acres of land out of 2.10 acres in survey number 152 of Nelamangala village, and it was a Sri Lakshmi Channakeshava deity Inamti land. Petitioner filed an application seeking a grant of occupancy rights before Special Deputy Commissioner for Inam Abolition Act 24/12 to 1980, annexure A. According to petitioner, he has been in possession of said land for the more than 50 years on the basis of a Panchashala Gutta. And he had paid Gutta to the third respondent Tahsildar and also taxes, and the petitioner had grown vegetable, paddy, flower plants, etc. on the said land. The Pani stands in his name as per annexure B. He had also put up,
His right is similar to an archaka.
no, his right is administrator for a temple for a period of 5 years, Panchasala, 5 ವರ್ಷಕ್ಕೆ ಕೊಡ್ತಾ ಇದ್ರು old Mysore. So he was the administrator for 5 years. He is not an archaka. Archaka has no right to claim the temple properties at all. Latest judgment has come from this honorable court. Archaka has no right. Now this is he administrator for 5 years, much prior to 1980, because the act gave scope for filing of this application. He filed an application. He had also put a construction on the land and is residing therein, as is evident from the photograph, so and so. The first respondent, Special Deputy, after inquiry, has passed an order on 2/8/23, and actually registering the petitioner as an occupant. Against the order of Deputy Commissioner, second respondent went in appeal before the appellate tribunal. After inquiry, the appellate tribunal set aside the Deputy Commissioner by way of its impugner order, hence this petition on various grounds. Heard counsel representing the parties. The land in survey number 152 of Nelamangala village, measuring about 2.10 acres in the Inam land of Sri Lakshmi Channakeshava Swami Divaru, by virtue of Mysore Religious and Charitable Act 1955 under section 3, the right, title and interest vested in the state, and the Inamdar had ceased to have the interest in the Inam land. Section 6A of the act provided that persons who have been rendering religious service, maintaining the institution as pujari, rendering any service in such institution, or any person cultivating the land for specified period prior to the date of vesting can seek for grant of occupancy on such abolition of the Inam. Application had to be filed on or before 30/6/1987, and the tribunal shall consider such application in respect of the land in question after vesting of the land for re-grant. According to the petitioner, he filed an application for grant of occupancy rights before Special Deputy Commissioner out of 2.10 acres in survey number 152. 1.26 acres is said to be the deity Inamti land. The Special Deputy Commissioner is vested with the power to decide the application to register for grant of occupancy right. Petitioner in his application before Special Deputy Commissioner contended that he is in possession of the land in question for more than 50 years on the basis of Panchsala Gutta and had paid the Gutta to the third respondent Tahsildar and has also paid taxes and was growing vegetable, paddy, flower plants on the land. The Pahani stands in his name. Petitioner also has put up a house on the said land and is residing in the said house. The first respondent, pursuant to the application filed by the petitioner, at the inception having considered the grievance of the petitioner and after inquiry, declared him as an occupant to an extent of 1.20 acres and passed an order on 2/8/2003.
The second respondent challenged the very same order before the Karnataka Appellate Tribunal and got set aside the order of the Special Deputy Commissioner. According to the petitioner, the Appellate Tribunal failed to consider the case and the relevant documents and his entries therein. Although according to the respondent, one Sanjeevaya is the holder of the Pansala Gutta and the same has been assigned to the petitioner, there are no records to reveal that it is a sublease. Petitioner states he is the holder of Pansala Gutta and second respondent has no locus standi to challenge the very order of grant made in his favor by the tribunal, nor land tribunal had granted the occupancy rights at the first instance and also for the second time. Except that extent of land is disputed in the earlier two grounds of litigation, the evidence remained undisturbed. Evidence is there on record that the land is being cultivated throughout by the petitioner and the same has not been disputed. Further, he has been paying the taxes and also there is a demand of tax by the Tahsildar. According to the petitioner, second respondent has not established that he is the convener of the temple. Even the second respondent has not questioned the earlier grant of occupancy in favor of the petitioner. The petitioner has been cultivating the land even prior to 1955 and to the extent of 1.20 acre in the Pahani for the year 1950-60. Petitioner's name is shown as cultivator. Even on Chandrappa's name was also entered along with the name of petitioner for about 10 to 12 years in the cultivator's column. However, Chandrappa has admitted that he was not cultivating the land in question. It is a specific case of the second respondent that the land in question was leased out. As such, according to the petitioner, though the words Panchasala Gutta is mentioned in the Pahani, but it is not the Panchasala Gutta is mentioned in the Pahani, but it is not a Panch and Gutta. Petitioner continues to be in possession of the land as per the Pahani extract and he is entitled to be registered as occupant as per section 4 and 5 of the Act. This aspect has not been taken into consideration by the tribunal. Accordingly, in support of his contention, petitioner's counsel has relied upon a decision in the case of so-and-so to contend the status and the nature of possession of a person who is admittedly a tenant even under a void lease would be that of tenant and his right have been treated on the basis of possession. Further, learned counsel contended, assuming that the petitioner filed an application for grant of occupancy rights even under the Land Reforms Act 1961 as amended on 1/4/72. His application has to be considered as per provisions of Land Reforms Act on the basis that he is deemed tenant as per section 4 of the Land Reforms Act as is held by the Supreme Court in case of so-and-so, so-and-so. The contention of the respondent's counsel that it is a Panch Sal Gutta in favor of one Sanjeevaya unless and until the further lease has been granted by the Tahsildar, it is deemed to have been extinguished. There is no further grant made in favor of the petitioner. The order passed by the tribunal is well considered one. Despite the order of injunction, petitioner has put up construction of a non-residential nature. Petitioner is using the land in question for non-agricultural purpose and petitioner has not produced any material regarding Pansal Gutta. The second respondent is a convener of the temple and he has preferred an appeal before the appellate tribunal against the order of the deputy commissioner and also produced several decisions in support of his argument to stand by his contention to reject the claim of the petitioner. In case of Sumitra versus State of Karnataka with reference to so-and-so, this court has considered the question as to whether the person cultivating the land on the basis of Pansala Gutta leased by the Tahsildar and the order of the special commissioner granting occupancy right is sustainable. In case of Mahalinga Swamigulu so-and-so, AR 1978 Karnataka, the effect of section 107 of the Karnataka Land Reforms Act and the effect of section 25 Mysore Religious and Charitable Institution Act has been considered. In case of Shivashankar so-and-so, the apex court held that under 226, while exercise discretion, court can pass orders in terms of public interest and equity. In the case of Hanumanta Devaru so-and-so, this court held that persons cultivating the land under Pansal Gutta are not entitled to grant occupancy right under the Land Reforms Act. The appellate tribunal stating that the petitioner has not produced any oral or documentary evidence that he is a tenant as per section 84 of the Revenue Code and as permanent tenant, Kadim tenant, protected tenant as defined under the Inams Abolition Act. Also referring to the judgment of this court in 1992 4 KLJ 360. Has reversed the order of the Deputy Commissioner and also observed that the petitioner ought to have shown his name in the register of Inam or quit rent register or alienation register or any revenue register maintained by the authorities, and that the petitioner has not produced any order of the Tahsildar as a successful bidder in public auction for a period of 5 years. The tribunal has noted that petitioner does not fall under the category of Kadim tenant or protected tenant or a permanent tenant. How the Deputy Commissioner has committed an error has not been considered by the appellate tribunal. In the case on hand, the evidence said to have been produced by the petitioner that he contended as a tenant since 1955 and also is paying the rentals, and there is a demand for payment of rental gutta to the Tahsildar has been ignored by the tribunal. In the circumstances, as on the date of vesting, whether petitioner was the occupant of and whether he is entitled to continue in possession and whether he has.
After this appellate tribunal,
This petition was allowed only with the 2 observations which requires to be followed by the land tribunal. Matter was remanded. Page 53, my lord. Page 52, last para. In the instant case, the petitioner, whether he falls under the category of Kadim, permanent or personal protected tenant, has not been considered by the appellate tribunal based on explanation mentioned as above, and also the demand of the payment of rental by Tahsildar amounts in recognizing the right of the petitioner to treat him as a tenant or not has also not been considered. In the circumstance and in the light of observation made above and the ratio laid down in Savitramma's case, also Ramaya Setti's case.
What happened thereafter? What happened in appellate tribunal?
Appellate tribunal has not considered these 2 observations while remanding the matter and has given its own explanation confirming the judgment of the Deputy Commissioner.
Where is it?
It is at the page it is in Kannada, my lord. Ink page 60. Page 66 is the relevant paragraph. Page. ಈ ಮೇಲ್ಮನವಿಯನ್ನು 50 ದಿನದ
ಬನ್ನಿ ಒಂಚೂರು.
ಆರ್ಡರ್ ಆದೇಶ ಪೇಜ್ 71. ನೆಲಮಂಗಲ ತಾಲೂಕು ನೆಲಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 152 ಜಮೀನಿನಲ್ಲಿ ಅರ್ಜಿದಾರ ನರಸಿಂಹಯ್ಯನವರ 196263 ರಿಂದ ಸರ್ಕಾರಕ್ಕೆ ಗುತ್ತಿಗೆ ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಜಮೀನಿನ ಸಾಗುವಳಿಯಲ್ಲಿ ಇರುವುದು ಲಭ್ಯವಿರುವ ಪಹಣಿ ದಾಖಲೆಗಳು ಹಾಗೂ ಗುತ್ತಾ ರಸೀದಿಗಳಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಚಂದ್ರಪ್ಪನವರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಮುಂದೆ 25/8/81 7/8/82 ಹೇಳಿಕೆ ನೀಡಿ ಸರ್ವೆ ನಂಬರ್ 152 ಜಮೀನನ್ನು ತಾನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿಲ್ಲವೆಂದು ಈ ಜಮೀನನ್ನು ನರಸಿಂಹಯ್ಯನವರೇ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವುದಾಗಿ ಹೇಳಿಕೆ ನೀಡಿದ್ದು ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 4/10/99 ಆದೇಶದಂತೆ ವಿಚಾರಣೆಗೆ ಪಡೆದಾಗ ಚಂದ್ರಪ್ಪನವರು ಪಾವತಿಯಾಗಿದ್ದು ಅವರ ವಾರಸುದಾರರು ಯಾರು ಪ್ರಕರಣದಲ್ಲಿ ಸೇರ್ಪಡೆಯಾಗಲು ಆಸಕ್ತಿ ಹೊಂದಿಲ್ಲದ ಕಾರಣ ಚಂದ್ರಪ್ಪನವರನ್ನು ಪ್ರಕರಣದಿಂದ ಕೈಬಿಟ್ಟಿರುವ ಕಾರಣ ಚಂದ್ರಪ್ಪನವರ ಅರ್ಜಿಯನ್ನು ವಜಾಕರಿಸಿ ಮತ್ತೊಬ್ಬ ಅರ್ಜಿದಾರರಾದ ಅರ್ಚಕ ಡಿ ನಾರಾಯಣ ಭಟ್ ರವರು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಆಧಾರವಿಲ್ಲದೆ ಇರುವುದನ್ನು ಪರಿಗಣಿಸಿ ಡಿ ನಾರಾಯಣ ಭಟ್ಟರ ಅರ್ಜಿಯನ್ನು ವಜಾಕರಿಸಿ ಆದೇಶಿಸಿದೆ. ಅರ್ಜಿದಾರರ ನರಸಿಂಹಯ್ಯನವರು 1962-63 ರಿಂದ ಜಮೀನನ್ನು ಗುತ್ತಿಗೆ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವುದು ದೃಢಪಟ್ಟಿರುವುದರಿಂದ ನೆಲಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರದೇಶದಲ್ಲಿರುವ ಪ್ರಕರಣಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಉಳಿದ 1.20 ಏಕರ್ ಪ್ರದೇಶಕ್ಕೆ ನರಸಿಂಹಯ್ಯ ಬಿನ್ ಮಾರಯ್ಯರನ್ನು ಮೈಸೂರು ಧಾರ್ಮಿಕ ದತ್ತಿ ಇನಾಮ್ ರದ್ದತಿ ಕಾಯ್ದೆ 1952 ಎಂದು ಆದಿಭೋಗರನ್ನಾಗಿ ನೋಂದಾಯಿಸಿ ಆದೇಶಿಸಿದೆ. 4ನೇ ಎದುರುದಾರರು ಕಚೇರಿಯ ಕಡತ ಪ್ರಸ್ತುತ ಆದೇಶವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ನೆಲಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ದೇವದಾಯ ಇನಾಮ್ ಜಮೀನ್ದಾರಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ದೇವದಾಯ ಇನಾಮ್ ಜಮೀನುಗಳು 1770 ರಂದು ಸರ್ಕಾರದಲ್ಲಿ ನಿಹಿತವಾಗಿರುತ್ತದೆ. ಇನಾಮ್ ಜಮೀನುಗಳು ಸರ್ಕಾರದಲ್ಲಿ ನಿಹಿತವಾದ ಆದೇಶ ವಿಳಂಬ ಮನ್ನಾ ಮಾಡಲಾಗಿದೆ. ಪೇಜ್ 74. ಮೇಲ್ಮನೆಯನ್ನು ವಜಾ ಮಾಡಲಾಗಿದೆ. 4ನೇ ಎದುರುದಾರರು ಆದೇಶ ಸಂಖ್ಯೆ ನಾಲ್ಕನೇ ಎದುರುದಾರರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೊ ಅಂಡ್ ಸೊ ಎತ್ತಿ ಹಿಡಿಯಲಾಗಿದೆ.
ನಾಲ್ಕನೇದಾರರ ಆದೇಶ
ಸ್ಪೆಷಲ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
ಅದು ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ 18 ಅಲ್ಲಿ ಇದೆ, ಅನೆಕ್ಷರ್ ಎ.
ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಏನ್ ಹೇಳುತ್ತೆ?
ಅದರಲ್ಲಿ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಅರ್ಜಿದಾರ ನರಸಿಂಹಯ್ಯನವರು ಪೇಜ್ 21 1962-63ರಿಂದ ಜಮೀನನ್ನು ಗುತ್ತಿಗೆ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವುದು ದೃಢಪಟ್ಟಿರುವುದರಿಂದ ನೆಲಮಂಗಲ ಗ್ರಾಮದ ಸೊ ಅಂಡ್ ಸೊ ಗಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಹೊರತುಪಡಿಸಿ ಉಳಿದ 20 ಎಕರೆ ಪ್ರದೇಶಕ್ಕೆ ನರಸಿಂಹಯ್ಯ ಬಿನ್ ಮಾರಯ್ಯರ್ ಅವರನ್ನು ಮೈಸೂರು ಇನಾಮ್ ದತ್ತಿಯಾದಿ ಕಾಯ್ದೆ ಅಡಿ ಅಧಿಭೋಗನಾಗಿ ನೋಂದಾಯಿಸಿ ಆದೇಶಿಸಿದೆ. ದಿನಾಂಕ 30/3/2001 ಹೊರತುಪಡಿಸಿ ಮಧ್ಯಂತರ ಆದೇಶ ಹೊರಡಿಸಿದೆ. ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರದ್ದುಗೊಳಿಸಿ ಮಂಜೂರಾದಾರರು ಸರ್ಕಾರಕ್ಕೆ ಕಟ್ಟಬೇಕಾದ ಪ್ರೀಮಿಯಂ ಹಣ ಪಾವತಿ ಮಾಡಲು ಆದೇಶಿಸಿದೆ. ದೇರ್ ಇಸ್ ಎನ್ ಆರ್ಡರ್ ಫಾರ್ ಗ್ರಾಂಟಿಂಗ್ 20 cents, 20 guntas. Now, my lord, 1.20 acres, my lord. 1.20 acre. My submission is this, my lord. This honorable court remanded the matter on 22nd February 2011 with the two specific conditions regarding the rent payable and regarding the
what is the type of tenant he is? Is he a
Panchasala? He is not a tenant tilling the land as required under the Land Reforms Act. ಆತ ಉಳುವವನೇ ಭೂಮಿ ರೈತ ಅಲ್ಲ. He is a administrator. ಪಂಚಸಾಲ ಗುತ್ತೇದಾರ್. In Savitramma's case, this honorable court, His Lordship Justice Baruch has clearly held that judgment was here, my lord. It's not. I will give it, my lord. That clearly says that Panchasala guttadar is not a tenant. So my humble submission is that learned single judge, while giving direction to the appellate tribunal to consider two factual aspects of the matter, ignoring that direction, the tribunal has passed an order holding that he is a tenant because other fellow said that a rival tenant said he is not cultivating the land.
Not just that, there is an admission that Narasimhaya has been cultivating the land.
My lord, now, my lord, there are two things. One, cultivation of the land. When he is a Panchasala Guttadar, he may be cultivating it under the status of Panchasala Guttadar. But that Panchasala Guttadar cannot be equated with a tenant defined under the Land Reforms Act.
What is the finding regarding whether he is a tenant or not?
No, here in the High Court, the appellate tribunal, in the first instance, my lord, order dated 29.
Come to page number 70.
Page number
70.
Please, ma'am.
Or rather, come to page number 69. Karnataka Ucha Nyayalaya ಅಲ್ಲಿಂದ ಓದಿ.
ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 22/22/11 ತೀರ್ಪಿನಲ್ಲಿ ನೀಡಿರುವ ನಿರ್ದೇಶನದಂತೆ ಪ್ರಕರಣವನ್ನು ಮರು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಂಡು ಉಭಯ ಪಕ್ಷದವರು ವಾದಗಳನ್ನು ಕೇಳಲಾಯಿತು. ಯಾಕೆ ಅದು ವಾಪಸ್ ಬಂದಿದೆ ಅಂತ ಅವರಿಗೆ ಗೊತ್ತಿಲ್ಲ, ಅವರು ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ. ದಿ ರೀಸನ್ ವೈ ಇಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಮಾಂಡೆಡ್ ಈಸ್ page 52 last para, whether he falls under the category of Kadim, permanent or protected tenant.
Sir, you please go ahead, sir.
ಕೇಳಲಾಯಿತು. ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಯಿತು. ಪ್ರಶ್ನಿತ ಜಮೀನಿನ ದೃಢೀಕೃತ ಪಹಣಿಗಳನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ 68-69ರಿಂದ ಎದುರುದಾರ ನೆಲಮಂಗಲ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 152 ವಿಸ್ತೀರ್ಣ 1.06 ಎಕರೆ ಜಮೀನಿನಲ್ಲಿ ಮತ್ತು ಚಂದ್ರಪ್ಪನವರು 0.20 ಎಕರೆ ಜಮೀನು ಗುತ್ತಿಗೆಗೆ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವ ಬಗ್ಗೆ ಪಹಣಿ ಕಾಲಂ 12/2 ಒಂದನೇ ಎದುರುದಾರರು ಮತ್ತು ಚಂದ್ರಪ್ಪನವರ ಹೆಸರುಗಳನ್ನು 68, 69, 79, 80 ಸಾಲಿನವರೆಗೆ ನಮೂದಿಸಿದ್ದು ಕಾಲಂ 12/3 ಸಾಗುವಳಿ ರದ್ದತಿ ಪದ್ಧತಿಗೆ ಎಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ.
ಗುತ್ತಿಗೆ ಎಂದು ನಮೂದಿಸಲಾಗಿರುತ್ತದೆ. 80-81 ಒಂದನೇ ಎದುರುದಾರರ ಹೆಸರನ್ನು ಪಹಣಿಯ ಕಾಲಂ 12/2 ಸಾಗುವಳಿದಾರ ಎಂದು ನಮೂದಿಸಲಾಗಿದೆ. ಸಾಗುವಳಿ ಪದ್ಧತಿ ಸ್ವಂತ ಎಂದು ನಮೂದಿಸಿರುವುದು ಕಂಡುಬಂದಿದ್ದು 2003-4 ಸಾಲಿನವರೆಗೆ ಮುಂದುವರಿಯುತ್ತದೆ. ಚಂದ್ರಪ್ಪನವರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಮುಂದೆ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿ ತಾನು 0.20 ಎಕರ್ ಜಮೀನು ಜಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು 1.06 ಎಕರೆ ಜಮೀನನ್ನು ನರಸಿಂಹಯ್ಯನವರೇ ಗುತ್ತಿಗೆದಾರರಾಗಿ ಗುತ್ತಿಗೆಗೆ ಸಾಗುವಳಿ ಮಾಡಿ ಬರುತ್ತಿದ್ದನ್ನು ತಿಳಿಸಿರುತ್ತಾರೆ.
4ನೇ ಎದುರುದಾರರು ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ಪರಿಶೀಲನೆ ಮಾಡಲಾಗಿ ಸದ್ರಿ ಆದೇಶದಲ್ಲಿ ಈ ಕೆಳಕಂಡಂತೆ ಹೇಳಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಕಡತ ಪರಿಶೀಲನೆಯಂತೆ ಅರ್ಜಿದಾರ ನರಸಿಂಹಯ್ಯನವರು 1960 ಇಂದ ಸಾಗುವಳಿದಾರರಾಗಿರುತ್ತಾರೆ. ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ ಸೋಯನ್ಸೋ ಸರ್ಕಾರಕ್ಕೆ ಗುತ್ತಿಗೆ ಪಾವತಿ ಮಾಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ತಹಸೀಲ್ದಾರ್ರವರು ಗುತ್ತಿಗೆ ಪಾವತಿಸುವಂತೆ ನೋಟಿಸ್ ಸಹ ನೀಡಿರುತ್ತಾರೆ. 1968-69, 95-96 ಪಹಣಿ ದಾಖಲೆ ಪರಿಶೀಲಿಸಲಾಗಿ ನರಸಿಂಹಯ್ಯ ಸೋಯನ್ಸೋ, ಚಂದ್ರಪ್ಪ ಸೋಯನ್ಸೋ ಎಕರೆ ಗುತ್ತಿಗೆ ಎಂಬುದಾಗಿ ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದಿಸಲಾಗುತ್ತದೆ. ಆದರೆ ಚಂದ್ರಪ್ಪನವರು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ಮುಂದೆ ದಿನಾಂಕ 25/8/81 ಮತ್ತು 17/8/88 ಹೇಳಿಕೆ ನೀಡಿ ಸರ್ವೆ ನಂಬರ್ 152 ಜಮೀನನ್ನು ತಾನು ಸಾಗುವಳಿ ಮಾಡುತ್ತಿಲ್ಲವೆಂದು, ಈ ಜಮೀನನ್ನು ನರಸಿಂಹಯ್ಯನವರೇ ಸಾಗುವಳಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುವುದಾಗಿ ಹೇಳಿಕೆ ನೀಡಿರುತ್ತಾರೆ. ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಯ ದಿನಾಂಕ 4/3/81 ತಾಲೂಕು ಮೋಜಣಿದಾರರಿಂದ ಮಾಡಿಸಿದ ನಕ್ಷೆಯಂತೆ 0.06 ಎಕರೆ ಪ್ರದೇಶದಲ್ಲಿ ಕಟ್ಟಡಗಳು ಇರುವುದು ಕಂಡುಬರುತ್ತಿದೆ. ಉಳಿದಂತೆ ಸಾಗುವಳಿ ಇರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಉಳಿದ ಅರ್ಜಿದಾರರುಗಳಾದ ಡಿ. ನಾರಾಯಣ್ ಭಟ್ರವರಾಗಲಿ ಪ್ರತಿವಾದಿ ಸುಬ್ಬಯ್ಯ ಶೆಟ್ಟಿಯವರಾಗಲಿ ಸಾಗುವಳಿ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ಯಾವುದೇ ಆಧಾರಗಳು
ಪಿಟಿಷನ್ ಬೈ ನರಸಿಂಹಯ್ಯ ಎಲ್ಲಿದೆ? ಅಪ್ಲಿಕೇಶನ್ ಬೈ ನರಸಿಂಹಯ್ಯ ಫಾರ್ ಗ್ರಾಂಟ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಎಲ್ಲಿದೆ?
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ಇಸ್ ವಿ ಹ್ಯಾವ್ ಎ ಕಾಪಿ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್.
After hearing so much, see, look sir, this is not a court of first appeal where we can go through the evidence once again. Okay, the finding has been given from 1968-69. Narasimhaya has been cultivating the land. Okay, the revenue entries also show Narasimhaya has been cultivating the land in respect of 1.06 acres. The rest 20.20 acres, Chandrappa is cultivating the land. But Chandrappa comes and says even that 0.20 he is not cultivating, only Narasimhaya is cultivating. Okay, now only thing that is left over is there is no question of we differing from this view. The only question that is left over is what application Narasimhaya made and under what category he asked for declaring him as an occupant and grant him occupancy right. Looking into that, if you say that such a person is not entitled for making an application itself, probably you have a case. Okay, so I'm asking, Elre, you Narasimhayan Varasdarallenre?
I produced those documents, madam.
Elida?
Next date of.
Yeah, next date.
Right. Madam, recently filed wakalat. I contacted my client and they are also bringing the documents. I have to file a detailed objections.
At the request of, I'll heard the arguments in part. At the request of respondent number?
In first case, nalli 10AB,
Huh?
LRs of 10, my lord, 10AB,
Respondent number 1AB,
10.
10AB, na?
10.
Huh? Respondent 10AB in WP number
First one.
14699 of 2020. Call on.
Any date.
Date today.
29 29. Fourth. Till then, let them not alienate.
Till such time, respondent number?
All the respondents.
My lord.
All respondents.
ಇನ್ನು ಕೆಲವರನ್ನು ಎಲ್ಲ
6 to 14.
Who appears for respondent?
Allah, there some are not served, some all are served, they are not filed wakalat. 6 to 4 are the persons who are causing danger to this property. 6 to 12. 6 to 14, including Narayan Bhatt, the priest.
Whom are they claiming under?
My lord,
Whom are they claiming under?
my lord, your ನರಸಿಂಹಯ್ಯಸ್ತು ಎಲ್ಲಾರು ಇವರೆಲ್ಲರೂ 4 to 13 ಎಲ್ಲ ಸೇರಿ ಮಾರಾಟ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟು ಬಿಟ್ಟಿದ್ದಾರೆ ಕೇಸ್ ಪೆಂಡಿಂಗ್.
ಏನು ಮಾರಾಟ ಆಗ್ತಾ ಇಲ್ಲ.
ಅದು 20% ಅಡ್ವಾನ್ಸ್
That ಏನು
ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮಾಡ್ತಾರೆ?
ನಾಳೆ ನಾಡಿದ್ರಲ್ಲಿ
Easy,
ಸೇಲ್ಸ್
ಇಲ್ಲ,
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ
easy.
ಕೊಡ್ತಾರೆ.
ನಿಮ್ಗೇನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್?
Let them not alienate till next hearing date. Conclude the matter next year. ಕೊಡ್ರಿ ಇಲ್ಲ ಫೈಲ್ ಕೊಡಿ ಎತ್ಕೊಂಡು ಹೋಗ್ಬಿಟ್ರಲ್ಲ ಆರ್ಡರ್ ಡಿಟೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ನಾವು ಮುಂಚೆ Your Lordship may kindly see the column 1 of the EP matter, registered agreement they have executed for this property. Okay. One second, wait. B. Ramesh. Column number B. Name of agreement, sale of immovable property, Pushpalata, KM. Correspondent order ಇದೆ. Pushpalata is the respondent. Fourth respondent order ಇದೆ. Yeah, sir. Fourth respondent order ಇದೆ. ಅಲ್ಲ, fourth respondent ಅಲ್ಲ, ಇವರು ಎಲ್ಲಾರು Pushpalata is the respondent number 12 in this writ petition. Mr. Fourth respondent order ಇದೆ. Fourth respondent to the order. ಅಲ್ಲ, fourth respondent ಅಂದ್ರೆ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 74 ಅಲ್ಲಿ ಆರ್ಡರ್ ರೆಫರೆನ್ಸ್ ಇದೆ ಅಲ್ಲ, ಎತ್ತಿ ಹಿಡಿಯಲಾಗಿದೆ. ಹೌದು. ಎಲ್ಲಿದೆ ಆರ್ಡರ್? The document is not produced. I'll come to page number 63. 63. ಮೇಲ್ಮನವಿಯನ್ನು ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ಧಾರ್ಮಿಕ ದತ್ತಿ ಇನಾಮ್ ರದ್ದತಿ ಕಾಯ್ದೆ ಸೋ ಅಂಡ್ ಸೋ ನೆಲಮಂಗಲ ತಾಲೂಕು ನೆಲಮಂಗಲ ಗ್ರಾಮದ 152 ವಿಸ್ತೀರ್ಣ 2.10 ಎಕರೆ ಜಮೀನ್ ಲಕ್ಷ್ಮೀ ಚನ್ನಕೇಶವ ದೇವಸ್ಥಾನ ನೆಲಮಂಗಲ ಇದಕ್ಕೆ ಸೇರಿದ ಜಮೀನಾಗಿರುತ್ತದೆ. 1 ಮತ್ತು 2ನೇ ಎದುರುದಾರರು ಈ ಜಮೀನಿಗೆ ಅಧಿಭೋಗರಕ್ಕೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ who should not alienate 4 to 12 mile 4 to 14 mile 4 to 14 shall not alienate or create any third party rights over the property concerned till next date of hearing. Oblige. See, because of your incompetence, Mr. Because of your incompetence, your client is suffering an order.
No, my lord, they are sending the records, my lord, because something happened. Their health reason, they won't come.
Yes.
Yes, Your Lordship.
44.
Yes, Harish, finally
Yes.
you are here.
No, no, I am sorry, Your Lordship. And ತಾವು ತಪ್ಪು ತಿಳ್ಕೊಬೇಡಿ ಆ ತರ.
No, no, no. ಆಗ ಹೇಳದಲ್ಲ ನೀವು ಬರ್ತಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿದ್ವಿ ಅಷ್ಟ. ಕುಡಿ.
Lordship, annexure B, Your Lordship, is a land tribunal order of granting land in respect of 3 items of lands, Your Lordship. Page 20, Your Lordship.
Annexure?
Annexure B. Page 20, Your Lordship.
20.
10. In respect of 3 items of land, Your Lordship, land was granted, Your Lordship. I am the tenant, Your Lordship, Venkappa Gowda. And owners are, Your Lordship, one Kukkappa Gowda, Lingappa and Hengst, Your Lordship. And this has been challenged by Your Lordship, the present respondent hearing. One of the Suresh Acharya, third respondent hearing, claiming that, Your Lordship, he is the owner of the land. In writ petition number 2208 of.
50 cents was granted in your favor.
Illa.
ಹೌದು, 1 acre 50 cents.
1 acre 20 cents. 1 acre 20 cents. ಈಗ ಸಬ್ಜೆಕ್ಟ್ ಇರೋದು 64/3 ಇಶ್ಯೂ ಇದರಲ್ಲಿ.
Not 64/4A.
ಅದರಲ್ಲೆಲ್ಲ ಇಲ್ಲ.
Okay, 1 acre 20 cents.
20 cents that he has challenged, Your Lordship. On the ground, he is the owner of the property, and the owners mentioned Kukkappa Gowda and Lingappa Gowda has no role. On that ground, he has challenged in the writ petition number at annexure C, Your Lordship. The matter was remanded to the tribunal.
1 second, wait.
Your lordship will operate a portion. Hence, the impugned order is quashed and the matter is remanded to the land tribunal, Puttur, with the directions to issue notice to all the concerned parties and then proceed to dispose the matter in accordance with law, if necessary by holding further inquiry insofar as relates to 64/1, 64/3, measuring 1 acre 20 cents, your lordship. So only one item subject was there. Then your lordship, before the land tribunal, your lordship, now your lordship, the whole issue is your lordship, whether this land is agricultural land or not, your lordship.
Subsequent to remand, what happened?
Subsequently,
Subsequent to remand,
ah,
annexure A was passed, right?
yeah, it was passed, your lordship. That your lordship, I am taking your lordship from page 16 onwards, internal page 6. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ 1 acre 20 cents ಅಲ್ಲಿ ಎಲ್ಲೋ ಒಂದು ಪೋರ್ಷನ್ ಅಲ್ಲಿ ಒಂದು ಭೂತಾರಾಧನೆ ಇದಿದೆ, ಅದು ಊರ್ನಾಡ್ದಲ್ಲ ಇದಾಗುತ್ತಾ ಇದೆ ಅದರಲ್ಲಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇಟ್ ಇಸ್ ನಾಟ್ ಎಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
So 20 cents ಮಾತ್ರ.
20 cents ಗೆ
The
ಮಾತ್ರ.
dispute pertains to 20 cents.
20 cents. So now your lordship, it is reserves the land, saying that it's for the public ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ರಿಸರ್ವ್ ಮಾಡ್ತಾರೆ. So it does not give the findings, your lordship, so as whether it is agricultural land or not, ಏನು findings?
It doesn't matter. It is not being cultivated by you, that's the finding given.
No, your lordship, that is why, your lordship, my submission, lordship, he is not at all the owner. That's why your lordship wanted to draw your lordship from page 16, your lordship.
Let's see what is the finding given.
Yes, your lordship. Page 16, internal page 6, your lordship, last paraದಿಂದ. ದಿನಾಂಕ, your lordship got. ದಿನಾಂಕ 19/8/2011 ವಕೀಲರಾದ NJK ಅವರು ಭೂಮಾಲೀಕ ಹರೀಶಾಚಾರ್ಯ ಪಾಠಸವಾಲು ಮಾಡಿದಂತೆ ಪಾಠಸವಾಲಿಗೆ ಉತ್ತರಿಸುತ್ತಾ, ಅಲಂಕಾರ ಗ್ರಾಮದಲ್ಲಿ ವೆಂಕಪ್ಪಗೌಡರು ಎಷ್ಟು ವರ್ಷದಿದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 64 ವೆಂಕಪ್ಪಗೌಡರು.
Listen. Come to page number 13.
13, your lordship.
1-3.
Yes. ವಿವಾದ ಜಾಗದಲ್ಲಿರುವ ಭೂತದ ಹೆಸರು ಮುಡಿಪುಣಾರ್ ಎಂದು ಹೆಸರು. ಈ ಭೂತದ ಪೂಜೆ ಇತ್ಯಾದಿಗಳನ್ನು ನಮ್ಮ ಅಜ್ಜನವರ ಕಾಲದಿಂದಲೂ ಕುಟುಂಬ ದೇವರಾಗಿ ನಾವು ನಡೆಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇವೆ. ಅಡಂಗಲ್ ರಿಜಿಸ್ಟ್ರಲ್ಲಿ 62 ಮುಡಿಪುಣಾರ್ ಭೂತ ಎಂದು 1973 ತೋರಿಸಿರುವ ದೃಢೀಕೃತ ಪತ್ರವನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. ದೇವತಾ ಕಾರ್ಯತವನ್ನು ಮೊದಲು ಅಜ್ಜನವರು, ಅನಂತರ ನಮ್ಮ ತಂದೆಯವರು, ಈಗ ನಾವು ನಡೆಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇವೆ. ವಿವಾದಿತ ಜಮೀನಲ್ಲಿರುವ ಭೂತ ಸ್ಥಾನದ
ಪೇಜ್ ನಂಬರ್ 13 ನಲ್ಲಿ ವಿವಾದಿತ ಜಾಗದಲ್ಲಿರುವ ಭೂತದ ಹೆಸರು ಮುಡಿಪುನಾರ್.
ಮುಡಿಪುನಾರ್.
ಆಯ್ತಾ? ಒಂದ್ ನಿಮಿಷ ತಡ್ರಿ. See page number 12 ಅಲ್ಲಿ ಕೃಷ್ಣಪ್ಪ ಗೌಡ. Who is ಕೃಷ್ಣಪ್ಪ ಗೌಡ?
ಕೃಷ್ಣಪ್ಪ ಗೌಡ. ಕೃಷ್ಣಪ್ಪ ಗೌಡ, your lordship, now one of the
advocate ಇರ್ಬೇಕು.
Yes. ಕೃಷ್ಣಪ್ಪ ಗೌಡ is one of the LR now.
ಸದ್ರಿ 4 ಲೈನ್ ಕೆಳಗಡೆ. ಸದ್ರಿ ದೈವಗಳ ಬಾಪ್ತು ನಾವೇ ನೈವೇದ್ಯ ಮಾಡುವವರು. ಪೇಜ್ ನಂಬರ್ 12 4 ಲೈನ್ ಕೆಳಗಡೆ.
ಸದ್ರಿ ದೈವಗಳ ಬಾಪ್ತು ನಾವೇ ನೈವೇದ್ಯ ಮಾಡುವರು. ಉಚ್ಚ ನ್ಯಾಯಾಲಯ 1 ಎಕರೆ 20 ಜಾಗ ಮಾತ್ರ ಪುನರ್ವಿಚಾರಣೆ ನಡೆಸಲು ಆದೇಶ ನೀಡುತ್ತದೆ. ಪ್ರತಿವಾದಿಯವರು ಆರ್ಟಿಸಿಯಲ್ಲಿ ಸದ್ರಿ ಜಾಗ ಮೂಲ ಹಕ್ಕಿನಲ್ಲಿ ಬಂದಿದೆ ಎಂದು ತೋರಿಸುವುದು ಸರಿಯಲ್ಲ. ಡಿಕ್ಲರೇಷನ್ ಕೊಟ್ಟ ನಂತರ ಸರ್ವೇಯರ್ ಬಂದು ಜಾಗವನ್ನು ಅಳತೆ ಮಾಡಿರುತ್ತಾರೆ. ವಿವಾದ ಜಾಗದಲ್ಲಿ ಭೂತದ ಹೆಸರು ಮುಡಿಪುನಾರ್ ಎಂದು ಹೆಸರು. ಈ ಭೂತದ ಪೂಜೆ ಇತ್ಯಾದಿಗಳನ್ನು ನಮ್ಮ ಅಜ್ಜನವರ ಕಾಲದಿಂದಲೂ ಕುಟುಂಬದವರಾಗಿ ನಾವು ನಡೆಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇವೆ. ಅಡಂಗಲ್ ರಿಜಿಸ್ಟ್ರಲ್ಲಿ 62 ಮುಡಿಪುನಾರ್ ಭೂತ ಎಂದು 1973 ತೋರಿಸುವ ದೃಢೀಕೃತ ಪತ್ರವನ್ನು ಹಾಜರುಪಡಿಸುತ್ತೇನೆ. ದೇವತಾ ಕಾರ್ಯವನ್ನು ಮೊದಲು ಅಜ್ಜನವರು, ಅನಂತರ ನಮ್ಮ ತಂದೆಯವರು, ಈಗ ನಾವು ನಡೆಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇವೆ. ವಿವಾದ ಜಮೀನಿನ ಭೂತ ಸ್ಥಾನವು ಜಾಗವು ಸಾರ್ವಜನಿಕ ಜಾಗವಾಗಿರುವುದಿಲ್ಲ. ಸದ್ರಿ ಜಾಗದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಜಾಗವಾಗಿರುವುದಿಲ್ಲ. ಸದ್ರಿ ಜಾಗದಲ್ಲಿ ಸಾರ್ವಜನಿಕರು ಪೂಜೆ ಪುರಸ್ಕಾರ ಇತ್ಯಾದಿಗಳನ್ನು ಮಾಡ್ತಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಸದ್ರಿ ಜಾಗದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಜಾತ್ರೆ ಇತ್ಯಾದಿ ನಡೆಯುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಅಸಮಾಧಾನದ ಪ್ರಶ್ನೆ ಇರುವುದಿಲ್ಲ. ಸದ್ರಿ ಸರ್ವೆ ನಂಬರ್ 64/3 ಅಲಂಕಾರ ಗ್ರಾಮದ ವೆಂಕಟಾಚಾರ್ಯರಿಗೆ ಯಾವುದೇ ಹಕ್ಕಿರುವುದಿಲ್ಲ. ಹಾಗೆಯೇ ಅಡಂಗಲ್ ರಿಜಿಸ್ಟ್ರಲ್ಲಿ ವೆಂಕಟರಮಣಾಚಾರ್ಯ ಯಾವುದೇ ರೀತಿಯ ಹೆಸರು ಬರುವುದಿಲ್ಲ. ಭೂತರಾಜನ ಬ್ರಾಹ್ಮಣರು ಮಾಡುವುದಿಲ್ಲ. ಹಾಗೆಯೇ ಆರ್ಟಿಸಿಯಲ್ಲಿ 68/9 ನಂತರದಲ್ಲಿ ಮುಡಿಪುನಾರು ಭೂತ ಜಾಗದಲ್ಲಿ ಆಡಳಿತಗಾರರಾಗಿ ಕಾಲಂ 9 ಮತ್ತು 12ರಲ್ಲಿ ವೆಂಕಟರಮಣಾಚಾರ್ಯ ಎಂಬುವರ ಹೆಸರು ಕೊಂಡಿರುವುದು ಕಾನೂನು ಬಾಹಿರವಾಗಿದೆ. Your Worship, in South Canara, ಭೂತವನ್ನು ಆ ಬ್ರಾಹ್ಮಣರು ಮಾಡೋದಿಲ್ಲ.
ಆಯ್ತು.
Only in Bunds and Gaudas and other
Correct,
castes.
correct, correct. Do it. Read,
Jai.
read.
ವಿವಾದಿತ ಜಾಗವು ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ವೆಂಕಟರಮಣಾಚಾರ್ಯ ಸ್ವಾಧೀನ ಇರುವುದಿಲ್ಲ. ತಮ್ಮ ಅಜ್ಜನ ಕಾಲದಿಂದಲೂ ತಮ್ಮ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುತ್ತದೆ. ವಿವಾದಿತ ಜಾಗವು 1374 ಅದರ ಮುಂಚೆ ತಮ್ಮ ನಂತರದಲ್ಲಿ ತಮ್ಮ ಸ್ವಾಧೀನದಲ್ಲಿ ಇರುತ್ತದೆ. ತಮ್ಮ ದನಿಗಳು ಸಬಳೂರು ಕರಿಯಪ್ಪ ಗೌಡರವರು ನಮ್ಮ ಮತ್ತು ವೆಂಕಟರಮಣಾಚಾರ್ಯರಾಗಲಿ ಅಥವಾ ಸುರೇಶಾಚಾರ್ಯರಾಗಲಿ ಯಾವುದೇ ರೀತಿಯ ದನಿ ಒಕ್ಕಲು ಸಂಬಂಧ ಕಲ್ಪಿತಗೊಂಡಿರುವುದಿಲ್ಲ. ವಿವಾದಿತ ಭೂಮಿಯ ತೀರ್ವೆಯನ್ನು ಮೊದಲು ನಮ್ಮ ಅಜ್ಜನವರು ಅವರ ಕಾಲದ ನಂತರ ನಮ್ಮ ತಂದೆಯವರು ಮತ್ತು ಅನಂತರ ನಾನು ಕಟ್ಟಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇನೆ. ವಿವಾದಿತ ಜಾಗದಲ್ಲಿ ಸುರೇಶಾಚಾರ್ಯ ಆಗಲಿ ಅವರ ತಂದೆಯಾಗಲಿ ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ತೀರ್ವೆಯನ್ನು ಕಟ್ಟಿರುವುದಿಲ್ಲ. ಭೂತ ಸ್ಥಾನದ ಜಾಗವು ನಮ್ಮ ಗೇಣಿ ಜಾಗಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. ಈ ಜಾಗದ ವಾರ್ಷಿಕ ಪೂಜೆ ಇತ್ಯಾದಿ ಕೋಲಗಳನ್ನು ನಾನೇ ಮಾಡಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇನೆ. ಸಾರ್ವಜನಿಕರಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಹಕ್ಕು ಇರುವುದಿಲ್ಲ. ಮುಡಿಪುನಾರು ಭೂತದ ನೆನೆಮರು ಅಂದರೆ ಜಾತ್ರೆ ಇತ್ಯಾದಿಗಳನ್ನು ಸುರೇಶಾಚಾರ್ಯರು ಅಥವಾ ಇತರ ನಡೆಸಿಕೊಂಡು ಬರುವುದಿಲ್ಲ. ಅವರನ್ನು ಸದರಿ ಜಾಗದ ಆಡಳಿತ ಎಂದು ಹೇಳುವುದು ಶುದ್ಧ ತಪ್ಪು. ವಿವಾದಿತ ಜಾಗದಲ್ಲಿ ಅಡಿಕೆ ತೋಟ, ತೆಂಗಿನ ಸಸಿ, ಗದ್ದೆ ಮತ್ತು ಭೂತದ ಗುಡಿ ಮತ್ತು ನಮ್ಮ ಮನೆ, ನಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ಇತರ ಜಮೀನುಗಳಿವೆ. ಅಡಿಕೆ ತೋಟ ಇರುವ ಜಾಗ ಬೆಳೆ ಗದ್ದೆಯದಾಗಿತ್ತು. ಗದ್ದೆ ಬೇಸಾಯ ನಾವೇ ಮಾಡುತ್ತಿದ್ದೆವು. ವಿವಾದಿತ ಜಾಗದ ಸ್ವಾಧೀನವು ನಮ್ಮ ಅಜ್ಜನ ಕಾಲದಿಂದಲೂ ಮತ್ತು ಈಗಲೂ ನಾವೇ ಸ್ವಾಧೀನ ಹೊಂದಿರುತ್ತೇವೆ. ಪ್ರತಿವಾದಿಯವರು ಸಾಜೀಪಡಿಸಿರುವ ಆರ್ಟಿಸಿಯಲ್ಲಿ ಇರುವ ಎಂಟ್ರಿ ಶುದ್ಧ ತಪ್ಪು. ವಿವಾದ ಆಸ್ತಿಯಲ್ಲಿ ಮೊದಲು ಗದ್ದೆ ಇದ್ದಾಗ ಅದಕ್ಕೆ ಲೆವಿಯನ್ನು ನಾವೇ ಕೊಡುತ್ತಿದ್ದೆವು. ಸುರೇಶಾಚಾರ್ಯ ಆಗಲಿ ವೆಂಕಟರಮಣಾಚಾರ್ಯ ಆಗಲಿ ನಮಗೆ ಯಾವುದೇ ಸಂದರ್ಭದಲ್ಲಿ ಗೇಣಿ ಕೇಳಿದ್ದಿಲ್ಲ ಮತ್ತು ಕೊಟ್ಟಿದ್ದಿಲ್ಲ. ಕಾರಣ ಅಂದ್ರೆ ನಮಗೂ ಅವರಿಗೂ ಯಾವುದೇ ಸಂಬಂಧ ಇರಲಿಲ್ಲ. ನಾವು ಕರಿಯಪ್ಪ ಗೌಡರಿಗೆ ಗೇಣಿ ಕೊಡುತ್ತಿದ್ದೆವು. ಕರಿಯಪ್ಪ ಗೌಡರು ಸಾಲದ ಪ್ರಕರಣವನ್ನು ಸಂಬಂಧಿಸಿದಂತೆ ಕೋರ್ಟ್ ಆದೇಶ ಮೇರೆಗೆ ವಿವಾದಿತ ಜಾಗದ ಹಕ್ಕು ಕರಿಯಪ್ಪ ಗೌಡರಿಗೆ ಬಂದಿರುತ್ತದೆ. ಕರಿಯಪ್ಪ ಗೌಡರಿಗೆ ಹಕ್ಕು ಬಂದ ನಂತರ ಸಹ ಒಕ್ಕಲಾಗಿ ನಾವು ಮುಂದುವರೆದಿರುತ್ತೇವೆ. ನಮ್ಮ ತಂದೆಯವರು ವಿವಾದಿತ ಜಾಗಕ್ಕೆ ಡಿಕ್ಲೇರೇಷನ್ ಕೊಡುವಾಗ ಸಬಳೂರು ಕರಿಯಪ್ಪ ಗೌಡರಿಗೆ ನಮ್ಮ ದನಿ ಎಂದು ಕಾಣಿಸಿರುತ್ತಾರೆ. ಅದೇ ದನಿಗಳಾದ ಕರಿಯಪ್ಪ ಗೌಡರು ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಸಮಕ್ಷ 28/81 ವಿವಾದಿತ ಜಾಗಕ್ಕೆ ನಾವು ನಮಗೆ ಒಕ್ಕಲು ಆದೇಶ ನೀಡುವುದಕ್ಕೆ ತಮ್ಮ ಒಪ್ಪಿಗೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಭೂನ್ಯಾಯ ಮಂಡಳಿಯ ವತಿಯಿಂದ ಭೂಮಾಪಕರು ಬಂದು ವಿವಾದಿತ ಜಾಗದ ನಕ್ಷೆ ಇತ್ಯಾದಿಗಳನ್ನು ತಯಾರಿಸಿ ನಂತರ ಭೂನ್ಯಾಯ ಮಂಡಳಿ ತಮ್ಮ ಪರ ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. ಆದರೆ ಭೂನ್ಯಾಯ ಮಂಡಳಿ ಈ ಹಿಂದೆ ನೀಡಿದ ತೀರ್ಮಾನವನ್ನು ಸ್ಥಿರೀಕರಿಸಿ ಪ್ರತಿವಾದಿಯರು ವಿವಾದಿತ ಜಾಗದಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯ ಹಕ್ಕಿಲ್ಲದಿರುವುದರಿಂದ ಅವರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಿ ನನಗೆ ಗೇಣಿ ಹಕ್ಕನ್ನು ನೀಡಿ ಆದೇಶ ನೀಡಬೇಕೆಂದು ಕೋರುತ್ತೇನೆ. ಭೂನ್ಯಾಯ ಮಂಡಳಿಯ ಸ್ಥಳ ತನಿಖೆ ಸಮಯದಲ್ಲಿ ಪ್ರತಿವಾದಿಯರು ತಮ್ಮ ಪರ ಕೆಲವು ಜನಗಳನ್ನು ಕರೆದುಕೊಂಡು ಬಂದು ಅಧ್ಯಕ್ಷರ ಕ್ಷಮ ಸುಳ್ಳು ಸಾಕ್ಷಿಯನ್ನು ಹೇಳಿರುತ್ತಾರೆ. ನಮ್ಮ ಪರವಾಗಿ ತಮ್ಮ ಹೇಳಿಕೆಯನ್ನು ತೆಗೆದುಕೊಂಡು
ಪೇಜ್ ನಂಬರ್ 16 ಸೆಕೆಂಡ್ ಭೂಮಾಲೀಕರಾದ ಭೂಮಾಲೀಕ
ಹರೀಶಾಚಾರ್ಯರು ದಿನಾಂಕ 8/7 ಹರಿಕಳಾದ ಆರ್ಕೆ ಅವರಿಂದ ವಿಚಾರಣೆಯಿಂದ ಹೇಳಿಕೆಯನ್ನು ಮಾಡಲಾಗಿ ತನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ಉತ್ತರಿಸಿ ವಿವಾದಿತ ಜಮೀನು ಅಲಂಕಾರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 14 ಒಂದೇ ಸದ್ಯ ಜಮೀನು ಭೂತ ಸ್ಥಾನದ ಕುರುಹು ಇದೆ, ಈಗ ಬಿದ್ದು ಹೋಗಿದೆ, ಹಿಂದೆ ಇತ್ತು. ಈ ಜಮೀನು ಪಟ್ಟೆ ಮುಡಿಪುನಾರ ದೈವ ಅವರ ಆಡಳಿತಗಾರರ ವೆಂಕಟರಮಣಾಚಾರ್ಯ ಅವರ ಹೆಸರಲ್ಲಿದೆ. ಪಟ್ಟ ಪುಸ್ತಕದ ಪ್ರತಿ ನ್ಯಾಯಾಲಯ ಹಾಜರುಪಡಿಸಿದೆ. ವೆಂಕಟರಮಣಾಚಾರ್ಯರು ತಮ್ಮ ತಂದೆಯರು ಪ್ರಸ್ತುತ ಅವರು ಮತರಾಗಿದ್ದಾರೆ. ವಿವಾದಿತ ಜಮೀನು ಸಂಬಂಧಿಸಿದಂತೆ ಭೂತಸ್ಥಾನ ಭಂಡಾರ ನಮ್ಮ ಮನೆಯಲ್ಲಿದೆ. ವಿವಾದಿತ ಜಮೀನಲ್ಲಿ ವರ್ಷಕ್ಕೊಮ್ಮೆ ನೇಮೋತ್ಸವ ನಡೆಯುತ್ತಿದ್ದು ಭಂಡಾರ ನಮ್ಮ ಮನೆಯಿಂದಲೇ ಹೊರಡುತ್ತದೆ. ಈ ವಿವಾದ ಜಮೀನು ದೈವಕ್ಕೆ ಸೇರಿದ ಜಮೀನು. ಈ ವಿವಾದ ಜಮೀನಲ್ಲಿ ಕೃಷಿ ಇಲ್ಲ. ಈ
ವಿವಾದಿತ ಜಮೀನಲ್ಲಿ ಕೃಷಿ ಇಲ್ಲ. ಈ
ಮಂಡಲಕ್ಕೆ ಭೂಮಾಲೀಕರಿಂದ ಒಪ್ಪಿಗೆ ನೀಡಿದ ಲಿಂಗಮ್ಮ ಹೆಂಗಸು ಅವರಿಗೆ ಜಮೀನು ಹಕ್ಕಿಲ್ಲ. ಈ ವಿವಾದ ಜಮೀನು ದೈವದ ಹೆಸರಲ್ಲಿ ಮೀಸಲಿರಿಸಬೇಕು. ಅರ್ಜಿದಾರಿಯ ಗೇಣಿ ನೆಲೆಯಲ್ಲಿ ಮಂಜೂರು ಮಾಡಬಾರದಾಗಿ ಕೋರಿಕೆ. ಸಾಕ್ಷಿದಾರ ಕೊರಗಪ್ಪ ಗೌಡರ ಮಗ ಮೋನಪ್ಪ ಗೌಡ ಮತ್ತು ರಾಮನಗೌಡರ ಮಗ ಚಿನ್ನಪ್ಪ ಗೌಡ ಇವರುಗಳಿಗೆ ಈ ವಿವಾದ ಜಮೀನಿಗೆ ಬಗ್ಗೆ ಅಥವಾ ದೈವದ ಬಗ್ಗೆ ಯಾವುದೇ ತಿಳಿಯುವಿಕೆ ಇಲ್ಲ. ವಿವಾದ ಭೂಮಿ
ಪೇಜ್ ನಂಬರ್ 18 ಬನ್ನಿ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಮೊದಲು ಇವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮ್ ಪೋರ್ಷನ್
ಏನಿದೆ
ಅಲ್ಲ, ಇವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪೋರ್ಷನ್ ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಈ ಜಮೀನು ಸುತ್ತ ಅಗಲು ಇಲ್ಲ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ವಾಟ್ ಈಸ್ ಹರೀಶಾಚಾರ್ಯ ದಿನಾಂಕ 19/11 ವಕೀಲರಾದ NJK ರವರು ಭೂಮಾಲೀಕ ಹರೀಶಾಚಾರ್ಯ ಪಾಠಶಾಲೆ ಮಾಡಿದಂತೆ ಪಾಠಶಾಲೆಗೆ ಉತ್ತರಿಸಿತು. ಅಲಂಕಾರ ಗ್ರಾಮದಲ್ಲಿ ವೆಂಕಪ್ಪ ಗೌಡರು ಎಷ್ಟು ವರ್ಷದಿಂದ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 64 ವೆಂಕಪ್ಪ ಗೌಡರು ಸ್ವಾಧೀನದಿಲ್ಲ. ಅವರ ಕುಟುಂಬದ ಸದಸ್ಯರು ಎಷ್ಟು ವರ್ಷದಿಂದ ಇದ್ದಾರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಮುಡಿಪುನಾರು ದೈವ ನಮ್ಮ 63ರಲ್ಲಿದೆ. ದೈವಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಸುಮಾರು 1 ಎಕರೆ.
ಮುಡಿಪುನಾರು ದೈವ ಗ್ರಾಮದ ಜನರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ಊರಿನವರು ಸೇರಿ ದೈವದ ನೇಮ ಮಾಡಬಹುದು.
ಎಸ್, ಊರಿನವರು ಸೇರಿ ಮಾಡಿದಂತಾದ್ರೆ ಇವರು ಒಬ್ಬರೇ ಓನರ್ ಆಗಿ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. ಈ ಜಮೀನಿನ ಸುತ್ತ ಅಗಲು ಇಲ್ಲ. ಈ ಜಾಗದಿಂದ ತಮಗೆ ಒಂದು ಜಾಗ, ಈ ಜಮೀನು ಅಗಲು ಇಲ್ಲ. ಈ ಜಾಗದಿಂದ ತಮ್ಮ ಜಾಗಕ್ಕೆ 1 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿದೆ. RTC ಪಟ್ಟೆ ದಾಖಲೆ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ. ತೀರ್ವೆ ನಾನೇ ಕಟ್ಟಿದ್ದೇನೆ. ದಾಖಲೆ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ. ದಾಖಲೆ ಹಾಜರು ಮಾಡಿರೋ ಬಗ್ಗೆ ನನಗೆ ನೆನಪಿಲ್ಲ. ಸ್ಥಳ ತನಿಖೆ ಟ್ರಿಬ್ಯುನಲ್ನವರು ಮಾಡಿದ್ದಾರೆ. ಸ್ಥಳ ತನಿಖೆಯಲ್ಲಿ ಕೃಷಿಗಳ ಬಗ್ಗೆ ವಿವರ ಬರೆದಿಲ್ಲ.
Come to page number 18, the last paragraph that is relevant.
ಪ್ರಕರಣದ ಎಲ್ಲ ಅಂಶಗಳನ್ನ ಭೂಮನ್ಯ ಪರಂಬಾರಿಸಿ 4/9/2003 ಹಿಂದಿನ ಭೂ ನ್ಯಾಯಮಂಡಳಿ ಅಧ್ಯಕ್ಷ ಮತ್ತೆಲ್ಲ ಸದಸ್ಯರು ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಕಡತದಲ್ಲಿ ಲಭ್ಯ ಇರುವ ಸ್ಥಳ ತನಿಖೆ ವರದಿಯನ್ನು ಪರಿಗಣಿಸಲಾಗಿದೆ. ತಜ್ಞ ಸ್ಥಳ ತನಿಖೆ ವರದಿಯಲ್ಲಿ 63/4 1 ಎಕರೆ ಜಮೀನು ಇದ್ದು, ಇದರಲ್ಲಿ 1 ಎಕರೆ ಜಮೀನು ಕೃತಾವಳಿಗಳಿದ್ದು 20 ಸೆನ್ಸ್ ಎಕರೆ ಸ್ಥಳದಲ್ಲಿ ಮುಡಿಪನಗರ ಭೂತದ ಗುಡಿ, ನಾಗಮನ ಕಟ್ಟೆ ಹೇರಳವಾಗಿ ಬೆಳೆದು ನಿಂತಿರುವ ಕಾಡು ಮರಗಳು ಇರುತ್ತವೆ. ಅಂದರೆ 20 ಎಕರೆ ಜಾಗ ಕೃತಾವಳಿ ಇಲ್ಲ ಜಾಗ. ಆದರೆ 81ರಲ್ಲಿ ಇಲ್ಲಿ ವಾರ್ಷಿಕ ಜಾತ್ರೆ ನಡೆಯುತ್ತಿತ್ತು. ಭೂ ನ್ಯಾಯಮಂಡಳಿ ತೀರ್ಮಾನದ ನಂತರ ನಿಂತಿದ್ದು ಈ ಜಾತ್ರೆಗೆ ನಡೆದ ಕಾರಣ ಊರಿನ ಜನಗಳ ಅಸಮಾಧಾನ ವಾತಾವರಣ ಕಂಡು ಬರುತ್ತಿದೆ ಎಂದು ಸ್ಥಳ ತನಿಖೆ ಸಮಯದಲ್ಲಿ. ಸೊ ಇಟ್ ಈಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ನೌ, ಇಟ್ ಈಸ್ ನಾಟ್ ದಿ ಹೀಸ್ ಕ್ಲೈಮಿಂಗ್ ದ ಓನರ್ಶಿಪ್. ಅಲ್ಲಿ ಭೂತಾರಾಧನೆ ನಡೀತಾ ಇತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಯಾರ್ದು ಟ್ರಿಬ್ಯುನಲ್ ಈಸ್ ಕ್ಲೈಮಿಂಗ್ ದಟ್ ಈಸ್ ದ ಓನರ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್. ನಾವು ಒರಿಜಿನಲ್ ಓನರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕುಕ್ಕಪ್ಪ ಗೌಡ. ಐ ಹ್ಯಾವ್ ಕ್ಲೈಮ್ಡ್ ಅಂಡರ್ ಕುಕ್ಕಪ್ಪ ಗೌಡ. ಈಗ ಇವರಿಗೆ 20 ಸೆನ್ಸ್ ಇಡಬೇಕಿದ್ರೆ ಒಂದು ಜಾಗದಲ್ಲಿ ಈಗ ನನಗೆ
ಭೂ ನ್ಯಾಯಮಂಡಳಿಯ ಸದಸ್ಯರೇ ಹೋಗಿ ತನಿಖೆ ಮಾಡಿದಾಗ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಫೌಂಡ್ ಔಟ್ ಇಸ್ 1 ಎಕರಲ್ಲಿ ಕೃಷಿ ಇದೆ, 20 ಸೆಂಟ್ಸ್ ಅಲ್ಲಿ ಕೃಷಿ ಇಲ್ಲ. ಅಲ್ಲಿ ಭೂತಾರಾಧನೆಗೆ ಬೇಕಾದಂತಹ ಏನೇನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಇದೆ ಅದೆಲ್ಲ ಇದೆ, ಪ್ಲಸ್ ಕಾಡು ಮರಗಳು ಬೆಳೆದಿದೆ. ಆಮೇಲೆ ಜನಗಳನ್ನ ವಿಚಾರಿಸಲಾಗಿ ಮುಂಚೆ ಊರಿನವರೆಲ್ಲ ಸೇರಿ ಜಾತ್ರೆ ಮಾಡ್ತಾ ಇದ್ರು. ಇವಾಗ ಫಾರ್ ವಾಟ್ ಎವರ್ ರೀಸನ್ಸ್ ಅದು ನಿಂತೋಗಿದೆ. ದಿಸ್ ಹಸ್ ಕಮ್ ಔಟ್. You have no reason to differ, sir. You have got 1 acre, be happy, 20 cents after all. I think that's very reasonable.
My submission lordship ಈಗ
submission ಇದೆ.
ಈಗ ನಮ್ಮ ಸೌತ್ ಕೇಂದ್ರದಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಭೂತಾರಾಧನೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬ್ರಾಹ್ಮಣರು ಭೂತಾರಾಧನೆ ಮಾಡುದಿಲ್ಲ. ದೇ ಕಾಂಟ್ ಬಿ ಓನರ್ಸ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ.
ಅವರಿಗೆ ರೈಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್, ಬ್ರಾಹ್ಮಣರಿಗೆ ರೈಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ, he is claiming he is the owner of the land.
It is not recognized.
He is owner of the land.
The impugned order does not recognize his rights.
Yes, when impugned order does not recognize him as a owner, the very claim by him is as a owner is
okay.
Fraud, your lordship.
Yes, next.
Next, your lordship. 20 ಸ್ಥಳದಲ್ಲಿ ಈಗ ಒಂದು ಪಾರ್ಟ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್ 1 ಎಕರೆ 20 ಸೆನ್ಸ್ ಅಲ್ಲಿ ಕೃತಾವಳಿ ಇದೆ ಅಂತ ಕೃತಾವಳಿ ಇದೆ, ಕೃಷಿ ಇದೆ ಅಂತ ಅಂದ್ಮೇಲೆ ಅದರಲ್ಲಿ ಒಂದು ಪಾರ್ಟ್ ಆಫ್ ದ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಒಂದು ಗುಡಿ ಇದೆ, ಒಂದು ಭೂತಸ್ಥಾನ ಇದೆ ಅಂತ ಆದ್ಮೇಲೆ ಇಟ್ ಇಸ್ ನಾಟ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಬಿ ಎ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಊರಿನವ್ರ ಜಾಗನೇ ಆಗ್ಬೇಕಾಗಿಲ್ಲ, ನಮ್ಮ ಜಾಗದಲ್ಲಿ ಇರುತ್ತೆ. ಇಟ್ ಇಸ್ ಇನ್ ಸೌತ್ ಕೇಂದ್ರದಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ದನಿ ಒಕ್ಕಲು ಇದು ಬಂದಾಗ ಅದರ ಜೊತೆಗೆ ಭೂತಸ್ಥಾನನು ಬಂದದ್ದು ಇದೆ, ಭೂತಸ್ಥಾನ ಹೋಗಿದ್ದು ಇದೆ. ಆ ತರನೇ ಇದು ಆಗಿರುವಂತದ್ದು ಇದನ್ನು. ಅಂಡ್ ಇಟ್ ಇಸ್ ನಾಟ್ ದಿ ಎವ್ರಿಬಡೀಸ್ ಪ್ರಾಪರ್ಟಿ, ಇಟ್ಸ್ ನಾಟ್ ದ ಪಬ್ಲಿಕ್ ಪ್ರಾಪರ್ಟಿ.
Yes, sir. I recorded that. Yes. Next. I noted it. Anything else?
No. Now my submission only this much, your lordship. ಈ ಅಭಿಪ್ರಾಯ your lordship ಕೇಳ್ಬೇಕಿದ್ರೆ ಇವರು ಊರಿನವರ ಅಭಿಪ್ರಾಯ ಕೇಳ್ಕೊಂಡು ಟೆನೆನ್ಸಿ ತೀರ್ಮಾನ ಮಾಡೋದು.
Yes. Yes. Next.
Whether there is a right of tenancy is existing with the owner or not, when the date of the land was vested with the government, that's the issue, your lordship.
Yes.
ಇವರು ಓನರ್ ಊರಿನವರೆಲ್ಲ ಕರ್ಸ್ಬಿಟ್ಟು ಇಲ್ಲಿ ನಾವು ಮಾಡ್ತಾ ಇದೀವೋ ನೀವು ಮಾಡ್ತಾ ಇದೀವೋ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಊರಿನವರಿಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಅದು ಊರಿನವ್ರು ಏನು ಕ್ಲೈಮ್ ಮಾಡಿದಲ್ಲ ಅದರಲ್ಲಿ. That's all my submission, your lordship.
Yes, Bunny. Agreed by the order passed in so and so. Dated so and so. By second respondent, wide annexure A to the writ petition. Wide annexure A to the writ petition.
Yeah, your lordship.
A to the writ petition. Come on. The petitioners therein have preferred this writ petition. Full stop. Next para. The father alva.
Father.
The father of the petitioners.
Encroachment Gowda.
Claimed occupancy rights in respect of 1 acre 20 cents of land in survey number 64/3. Alva?
Yes, your lordship.
64/3 of Alankaru village.
Alankaru.
Alankaru, double M. Alankaru village, Puttur Hubli. Full stop. The land tribunal has granted occupancy rights in respect of only 1 acre of land. And in respect of remaining 20 guntas of land, the same has been reserved for
ಕೃಷಿಯೇತರ ಸಾಗುವಳಿ ಇಲ್ಲದ ಜಮೀನು.
bhutaradhane by general public. By general public. Full stop. The case of the petitioners is that occupancy rights should have been granted in their favor, even with regard to the said 20 cents of land, in addition to 1 acre of land which has been granted. Full stop. Next para. The records reveal that who was the owner of the land, sir?
Kukkappa Gowda and Lingappa Inks, your lordship.
Where is it said?
Annexure B earlier. Tenancy was claimed under Kukkappa Gowda and Lingamma.
Yen bantile? Last sentence. The records reveal that one Kukkappa Gowda was the owner of the property, and petitioner claims tenancy under the same tenancy under him. Petitioner was a father of petitioners. Father of petitioners was a tenant under the said
Kukkappa.
Kukkappa. In respect of certain land in survey number 64/3. Certain land in 64/3. Grant of the application model, the form numbers, yadrally section yadu. Grant of tenancy rates.
Tenancy rates are granted in favor of.
Section yadu, which is the relevant section, government. Grant of tenancy rights.
48, your lordship. What?
Land Reforms Act ಅಲ್ಲಿ ಯಾವುದು? Constitution of Tribunal is 48. ಅವ್ರು ಹೇಳಿದ್ರು ನೀವು ಹೇಳಿದ್ರೆ ವೆರಿಫಿಕೇಶನ್ ಇಲ್ಲ, ಯಾತ್ರದ್ದು ಇಲ್ಲ.
Forty 45, your lordship. 45A1.
45.
Grant of land in 27.
Yes, ಏನ್ ಬಂತೇಳಿ?
ನೋಡೋಣ.
64/3. 64/3. Full stop. It also reveals. It also reveals. Full stop. Next. The impugned order states that the land tribunal members personally visited the spot and found out that 1 acre of land was under cultivation and 20 guntas of land and in 20 guntas of land and in 20 guntas of land Bhutaradhana was being done and there was no cultivation. Full stop. Further, based on the documents produced before the tribunal and the evidence letting, the tribunal has concluded that the father of the petitioner was cultivating 1 acre of land in survey number 64/3. Full stop. In the course of arguments, the petitioner does not dispute the fact that in 20 cents of land, guntas anta helidre cents anta ಮಾಡ್ಕೊಳ್ಳಿ. In 20 cents of land, does not dispute the fact that 20 cents of land in 20 cents of land was used for Bhutaradhana purposes. But he contends it was being done by the family of the petitioners exclusively and the said area also belonged to them. Full stop. Next para. Admittedly, the land was not owned by the father of the petitioner, but was owned by one Kukkappa Gowda. And the father of the petitioner was only a tenant. Full stop. It is established that only 1 acre of land was being cultivated, and 20 guntas of land was used for Bhutaradhana. And as per the evidence let in, the tribunal has come to the conclusion that the said Bhutaradhana was done by the general public. Full stop. Next para. Section 45 of Karnataka Land Reforms Act. 45 clause 1 of Karnataka Land Reforms Act reads as under 45 clause 1 recordment. Full stop. Next. Section 2 clause 10 reads as under. Next, section 2 clause 11 reads as under. Next, section 2 clause 34 reads as under. Next part. Combined reading of the aforementioned provisions of Karnataka Land Reforms Act mandates tenants to be registered as occupants of land only when he was cultivating the same personally. Full stop. In the instant case, admittedly, only 1 acre of land was being cultivated by the father of the petitioners personally. Full stop. There was no cultivation in respect of 20 guntas of land. Full stop. On the evidence latin, the tribunal has come to the conclusion Bhutaradhane in respect of 20 guntas of land was being done, is being done by the general public. Full stop. There is no reason for this court to differ with the conclusion arrived at by the tribunal in this regard. Full stop. Further, as already observed, the father of the petitioner was not cultivating the said 20 guntas of land. And he is not entitled to grant of occupancy rights regarding the same. Full stop. Next para. For the aforementioned reasons, I do not see any infirmity in the impugned order, and the writ petition is accordingly dismissed. Yes, sir. See, definition of section 45, then definition of tenant, then definition of to cultivate, then definition of to cultivate personally. Yes. Krishna Dagidiga. ಇದು ಇವರು BDN ಅವ್ರು ಬಂದ್ರ ಎಸ್ 230 ಮೀಟರ್ ತಗೊಳ್ಳಿ 230. Yes, sir.
Your lordships wanted to see from the BDA as to whether they have done their plan sanction in accordance with law. And BDA has now filed an affidavit, my lord, that everything has been done in accordance with law.
Yes. Access to them is provided for.
My lord?
Access to them is provided for.
Yeah, it is. In fact, the Lokaita holds that they have been provided 35 feet wide road, while the regulations require only a 30 feet road.
Yes. Affidavit kodi BDA.
We have filed statement of objection.
The statement of objection is in violation of the endorsement issued. The endorsement put in investments put here. ಅದು ನಾವು ವ್ಯಕ್ತಿಗತವಾಗಿ objections This is filed in support of the developer. This is filed endorsement issued to the developer. Endorsement issued to the
ತೋರ್ಸಿ ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರ ಕಾಪಿ ಕೊಡಿ, ಇದೇನೋ ಪುಟ್ಟಪ್ಪ ಆಗಿಲ್ಲ ಅನ್ಸುತ್ತೆ.
Thirtieth of September ಹಾಕಿದೆ. ನಿಮ್ದಿದೆ ಅಲ್ಲಲ್ಲ ಅವರು
Video.
memorandum. 30th of September.
ಕಾಪಿ ಇಲ್ವಾ ನೋಡಿ.
Indian report. Indian report. ಮುಂದೆನೆ ಅಲ್ಲ ಇಲ್ಲಿದೆ. ಇದನ್ನ ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀವಿ ರಿಪೋರ್ಟ್. ಇದು contrary as well as the objections which were endorsement issued by the BDA commissioner.
ಓದಿರ ಸರ್ ಇದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನೋಡಿದ್ದೀರಾ?
Yes. The objections filed now are contrary to the objections filed by them before this honorable court in the previous state petition. I invite my lord's attention to page 16 of the documents which I produced on 16/10/2024. 16/10/2024. List of documents are produced consolidating all the annexes.
ಎಷ್ಟು ಬೇಕು ಸರ್?
Page number 16, man. 16.
Because the matter already decided by this honorable court as submitted to my lord and confirmed by the Supreme Court also. In the previous writ petition, what they have said,
Para number?
my lord may take
Just to
clarify,
the BDA line.
this is, sorry, loci.
This is by local. Not BDA.
I'm sorry, loci.
See, sir, it is like this. You have a piece of land.
My lord?
You have a piece of land
Yes.
which is surrounded by the land belonging to respondent number 3. Now, your grievance is you don't have proper access to your land.
No, my grievance is
Let
not.
me complete, sir.
Yes.
Please hear me. Correct me if I am wrong. Your grievance is you don't have proper access to your land. Number 1. Number 2, that access to your land has to be granted in terms of the master plan.
In terms of master plan. Yes, master.
In terms of the master plan, which has not been done. These are the 2 grievances that you have got. Right? And according to you, when you say in terms of the master plan, it is as per the map produced by you. That
Yes.
plus
Plus symbol.
mark
Yes, plan.
plan produced by you. Now, PDA by exercising its discretion provides you an access to your property in a different manner altogether. But sufficient access is produced to you. I mean, is given to you, number 1.
Yeah.
The only question remains for consideration is whether the action of BDA is in accordance with law or not.
Or not.
Okay, in not providing you an access in the plus thing.
Please.
For that, BDA has answered. Now that master plan stands revised, they have passed necessary orders, taking into consideration how your property is situated and the property of respondent number 3 is situated. They have given you an L-shaped access. L-shaped access to your property instead of plus-shaped access. Okay, that is the contention of the BDA. So unless you show that action of the BDA is
Yes.
illegal, you have no case.
I'll point out.
Yes.
I'll point.
And if I may
Right.
just add 1 minute before my learned friend begin. In the writ petition, the only ground on which the entire action of the BDA is sought to be challenged is that there is an order that has been passed by the Lokayukta saying that you must give that plus access. On that, my lord, that was the order, my lord, that was passed on 16th of March 2018. I'm sorry, my lord, that was the Lokayukta's
Sir, that you
order
cannot
dated
rely upon.
28/7/2011.
See,
That's
you-
over.
You derive your right. Lokayukta does not confer you any rights.
No.
Lokayukta only states is an agency to see to it that BDA acts in accordance with law.
Correct.
Okay. To enforce your rights, you approach this court. Now, you will have to say that as per the regulations of BDA, as per the master plan of BDA, you have a right to have a plus access to your property. Okay. If BDA has passed contra order, you have to establish how that particular order is in violation of law. The onus is on you.
If I may say, my lord, without fear of contradiction, in the writ petition, there is nothing to say that I have a right to the plus by virtue of regulation number so and so, or in accordance with clause number so and so of the RMP, that RMP clause number so and so has been violated and nothing. Only ground, my lord, is the Lokayukta passed an order on 28/7/2011. Therefore, I have a right. Now, to that, my lord, the complete answer is the subsequent order passed by the Lokayukta, where they said, no, this plus was not part of the order of the Lokayukta.
So that's irrelevant actually.
Even if irrelevant, absolutely.
Yes. May I please, my lord?
Yes,
I take my lord, my question, my submission to my lord is the resolution is passed by the BDA itself. Based on the orders passed by the Lokaयुಕ್ta and by this honorable court and also Supreme Court.
show it, sir.
I just take my lord's attention to page 37. That
Same-
is in the same book.
1610, 20.
For convenience sake, I have separated them and given this. Page 37, my lord.
Hmm.
Resolution number 133/2019. Dated 17/1/2020 and 18/1/2020.
Page 37.
Page
17/1/2020, 18/1/2020.
Yes.
Krishna's Vishya Sankhya.
I take my lord's attention to last portion. Before that, of course, I'll take it later on. But what they have said in page 40 is, this is signed by Commissioner BDA and other members. ಚರ್ಚೆಯ ನಂತರ ಪ್ರಾಧಿಕಾರದ ಸಮಿತಿ ಸಭೆಯು ಪ್ರಸ್ತಾಪಿತ ಅಭಿವೃದ್ಧಿ ಯೋಜನೆಯ ದಿನಾಂಕ 16/3/18 ನೀಡಿರುವಂತಹ ಅನುಮೋದನೆಯು ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯ ಆದೇಶ, ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ಹಾಗೂ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ನೀಡುವಂತಹ ತೀರ್ಪಿಗೆ ವಿರುದ್ಧವಾಗಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ದಿನಾಂಕ 16/3/2018 ಸಭೆಯ ನಿರ್ಣಯವನ್ನು ರದ್ದುಗೊಳಿಸಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಗೆ ದೂರುದಾರರಾದಂತಹ ಶ್ರೀ ವೀರಣ್ಣನವರ ಜಮೀನು ಒಳಗೊಂಡಂತೆ ಅಳವಡಿಸಲಾದಂತಹ 18 ಮೀಟರ್ ಅಗಲದ ರಸ್ತೆ,
ಜಾಲದ ನಕ್ಷೆ
18 ಮೀಟರ್ ರಸ್ತೆ ಜಾಲದ ನಕ್ಷೆಯನ್ನು ನೀಡಿದ್ದು, ಸದರಿ ರಸ್ತೆ ಜಾಲದ ನಕ್ಷೆಯನ್ನು ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯಲ್ಲಿ ಒಪ್ಪಿಕೊಂಡಿದ್ದು, ಅದರಂತೆ ಅರ್ಜಿದಾರರಿಂದ ಪರಿಷ್ಕೃತ ಅಭಿವೃದ್ಧಿ ನಕ್ಷೆಯನ್ನು ಪಡೆಯಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. RMP 2031 ಅಂತಿಮಗೊಳಿಸುವಾಗ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತ ಕಚೇರಿಯಲ್ಲಿ ಒಪ್ಪಿಕೊಂಡ ರಸ್ತೆ ಜಾಲವನ್ನು ಅಳವಡಿಸಿಕೊಳ್ಳಲು ತೀರ್ಮಾನಿಸಲಾಯಿತು. That is one aspect.
This is not an order, sir. This is not a law.
Madam?
This is not an order. This is not a law.
No, I'll
See,
tell you.
no, I'm just telling it to
Yes,
you,
ma'am.
that's all. Yes,
This is one aspect of the matter. So this resolution is passed by the BDA only, on the basis, according to them, not only their own report, but on the judgment of the Honorable High Court and the Supreme Court, as my lord perceived.
sir, this was the resolution passed by BDA.
BDA only,
Yes,
yes. Then I take my lord's attention to page 39,
139, sir. Hello,
13.
Page 30.
39, ಹಿಂದಿನ page.
Yes, sir.
ಈ ಮಧ್ಯೆ it is paragraph 1, second one. ಈ ಮಧ್ಯೆ RMP 2031 ಕರಡಿನಲ್ಲಿ ಸದರಿ ಪ್ರದೇಶದ ರಸ್ತೆ ಜಾಲವನ್ನು 18 ಮೀಟರ್ ಬದಲಿಗೆ 12 ಮೀಟರ್ ಅಗಲಕ್ಕೆ ವಿಸ್ತರಿಸಿ ಅನುಮೋದನೆ ಆಗಿರುವುದನ್ನು ಪ್ರಶ್ನಿಸಿ ಲೋಕಾಯುಕ್ತಕ್ಕೆ ಶ್ರೀ ವೀರಣ್ಣನವರು ನೀಡಿದಂತಹ ದೂರಿನ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರಿಂದ ದಿನಾಂಕ 8/1/18 ಕೆಳಕಂಡಂತೆ ಆದೇಶ ನೀಡಿರುತ್ತಾರೆ. It is too premature for me at this stage to give any direction to Bangalore Development Authority as to how the plan submitted by the developer has to be approved. It is for the Bangalore Development Authority, keeping in mind its regulation, to approve the plan. Since the order directs that the BDA is required to keep in mind linkage facilities to surrounding areas, it is needless to point out that the said direction is required to be kept in mind by the BDA
while approving the layout plan. Further, it is also necessary to place on record that the said direction was given by then Honorable Lokayukta as back as 28/7/2011. It is not in dispute that the BD has now prepared draft revised master plan of 2031 by calling for objections from the persons who are affected.
ಮುಂದೆ ಓದಿ ಸರ್, next para.
ಇಲ್ಲ, ಮುಂದೇನು ಓದು. Therefore, it is open to Bangalore Development Authority in the light of the subsequent event that has taken place to take appropriate decision in accordance with law while approving the layout plan submitted by the developer. It is well settled principle that while approving any layout plan, BDA is required to exercise its powers under Section 32 of the BDA Act. It is needless to point out that the BDA has to keep in mind the latest revised master plan and the relevant regulations which were approved or framed in the interest of general public, and more particularly at the stage of BDA approving the development plan for the developer bar owner. The complainant may put forward his objections, if any, and assist the BDA to take appropriate decision, keeping in mind the building regulations, revised master plan, and the interest of general public. It is not my interest, but general public. Then,
Next sentence is important.
Huh?
Next sentence is very important. In the same order. RMP 2031 ಅನ್ನು ಅಂತಿಮ ಅನುಮೋದನೆಗೆ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು ಇನ್ನು ಅನುಮೋದನೆ ಆಗಿರುವುದಿಲ್ಲ, and the fact of the matter is that the government has now dropped 2031. Therefore 2031 RMP is no longer, my lord, a document to be reckoned in law. So we are now simply governed by the same RMP 2015.
on the basis of this, time and again, the BDA has given endorsement to the third respondent herein, which I may invite my lord's attention to those endorsements wherein they have asked to give. His complaint is that what is submitted by him are not sanctioned. For that endorsements, 3 times or 4 times they have given endorsement to the developer, and I take my lord's attention to page 62. This is addressed to Sri Ashwin Pai Ravaru, Township Promoters. He has referred to all the orders and also the directions. Yes. Page, I'll take my, instead of reading the whole of it, my lord, I'll take my lord's attention to page 66. ಮೇಲೆ ವಿವರಿಸಿರುವ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಗೊಂದಲವನ್ನು ನಿವಾರಿಸಲು ಸದರಿ ಸನ್ನಿವೇಶದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದಂತಹ ಪ್ರತಿಯಿಂದ ಕೈಗೊಳ್ಳಬಹುದಾದಂತಹ ಕ್ರಮ ಕುರಿತು ಕಾನೂನು ಅಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯ ಕೊಡಲಾಗಿ ಕಾನೂನು ಅಧಿಕಾರಿಗಳು ಈ ಕೆಳಕಂಡಂತೆ ಅಭಿಪ್ರಾಯಿಸಿರುತ್ತಾರೆ. On perusal of the records, it is seen that there was a dispute raised in pursuance of grievance complaint of one Mr. Viranna in the matter of approving the development plan claimed by Messrs. Abhishek promoters before the Lokayukta. Honorable Lokayukta has finally closed the said grievance complaint, observing that BDA by demolishing the compound wall has already provided linkage connection to the area of the complainant, and BDA has already now prepared draft revised master plan 2031, and in such circumstances, while approving the layout, BDA has to keep in mind that there exists linkage facility to the surrounding areas. Thereby, how it has to be achieved and the plan has to be approved is a matter to be decided at the discretion of the planning authority of BDA. Therefore, BDA has to pursue and verify as to whether the plan submitted by the applicant, Messrs. Abhishek promoters, satisfy the guidelines laid by the Honorable Lokayukta 2011 as such, and there is nothing to be done by legal section in the present matter. This is what is said. Now, I take my lord attention to the endorsement issued time and again to Mr. Ashwin Pai. My lord, first one, my lord finds it on 4/8, dated 4/8/2022 on page 67. Page 71, last paragraph. Because the discussion is all through about the writ petition and the SLP and the order of the, or direction of the report of under 12(1) of the Lokaयुक्त Act. Kindly see page 71, last paragraph. ಮೇಲೆ ವಿವರಿಸಿರುವ ಎಲ್ಲ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಗೊಂದಲವನ್ನು ನಿವಾರಿಸಲು ಸದರಿನ ಸನ್ನಿವೇಶದಲ್ಲಿ ಪ್ರಾಧಿಕಾರದ ವತಿಯಿಂದ ಕೈಗೊಳ್ಳಬಹುದಂತಹ ಕ್ರಮದ ಕುರಿತು ಪ್ರಾಧಿಕಾರದ ಕಾನೂನು ಅಧಿಕಾರಿಗಳು ಉಲ್ಲೇಖ 14ರಂತೆ ದಿನಾಂಕ 24/22ರಂದು ಕಾನೂನು ಅಭಿಪ್ರಾಯ ನೀಡಲಾಗಿದ್ದು, ಸದರಿ ಅಭಿಪ್ರಾಯವು ಇತ್ತೀಚಿನ ಕಾನೂನು ವಿಭಾಗದ ಅಭಿಪ್ರಾಯವಾಗಿರುವುದರಿಂದ ಈಗಾಗಲೇ ಉಲ್ಲೇಖ 13ರ ಕಚೇರಿ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಲಾಗಿರುವ ಅಂಶವನ್ನು ಮತ್ತೊಮ್ಮೆ ಪುನರುಚ್ಚರಿಸುತ್ತಾ ಅದರಂತೆ ರಸ್ತೆ ಜಾಲವನ್ನು ಅಳವಡಿಸಿರುವ ಪರಿಷ್ಕೃತ ವಸತಿಯೇತರ (ವಾಣಿಜ್ಯ) ಉದ್ದೇಶದ ಅಭಿವೃದ್ಧಿ ನಕ್ಷೆಯನ್ನು ದಿನಾಂಕ 28/7/11ರಲ್ಲಿ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರವರ ಆದೇಶದಲ್ಲಿ ನಿರ್ದೇಶಿಸಿರುವಂತೆ ನಿಯಮಾನುಸಾರ ತಯಾರಿಸಿ ಸಲ್ಲಿಸಲು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. The second endorsement again, my lord finds it on page 73, dated.
The BDA himself submitted.
Yes, BDA submits a report, my lord, on 24/1/2024 recently. My lord, on page 73.
Yes, sir.
Of course, whole description is there, but I take my lord's attention to page 82.
Yes,
Last
sir.
paragraph, 82, 82. Last paragraph. ಅರ್ಜಿದಾರರಿಗೆ ಈ ಕಚೇರಿಯ ದಿನಾಂಕ 17/2/21, 22/6/22, 6/8/22 ಈ ಕಚೇರಿ ಪತ್ರಗಳಲ್ಲಿ ದಿನಾಂಕ 17/1/20, 18/1/20ರ ಪ್ರಾಧಿಕಾರದ ನಗರ ಯೋಜನಾ ಸಮಿತಿ ಸಭೆಯ ಠರಾವು ಸಂಖ್ಯೆ 133/2019 ಅನುಸಾರ ರಸ್ತೆ ಜಾಲವನ್ನು ಅಳವಡಿಸಿರುವ ಪರಿಷ್ಕೃತ ವಸತಿಯೇತರ (ವಾಣಿಜ್ಯ) ಉದ್ದೇಶದ ಅಭಿವೃದ್ಧಿ ಯೋಜನೆ ನಕ್ಷೆಯನ್ನು ದಿನಾಂಕ 28/7/2011ರ ಮಾನ್ಯ ಲೋಕಾಯುಕ್ತರವರ ಆದೇಶದಲ್ಲಿ ನಿರ್ದೇಶಿಸುವಂತೆ ನಿಯಮಾನುಸಾರ ತಯಾರಿಸಿ ಸಲ್ಲಿಸಲು ತಿಳಿಸಿದೆ. ಡೆವಲಪರ್ ಅಡಕ ಸಂಖ್ಯೆ 26, 27, 28 ಅರ್ಜಿದಾರರು ಇಲ್ಲಿಯವರೆಗೆ ರಸ್ತೆ ಜಾಲ ಅಳವಡಿಸುವಂತಹ ಪರಿಷ್ಕೃತ ವಸತಿಯೇತರ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆಯನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಪ್ರಸ್ತುತ ಜಮೀನುಗಳಲ್ಲಿ ವಸತಿಯೇತರ ಅಭಿವೃದ್ಧಿ ಯೋಜನಾ ನಕ್ಷೆಯನ್ನು ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದಿಸಲು ಆಗುವುದಿಲ್ಲ. The complaint of the developer was that his plan is not approved. But time and again, endorsements are issued for every representation given.
Yes,
by.
what is the final decision, sir?
My lord?
What is the final decision?
The final decision, they must submit the report according to 133.
No, decision taken by BDA.
Resolution.
No, final decision taken by BDA, sir.
Now, my lord, the final decision taken by BDA is the one dated 5/3/2024.
ನಾನೇ ಹೇಳ್ತೇನೆ.
ಇಲ್ಲ, ಸಾರಿ, ಹೇಳಿ ಇಲ್ಲ ನಾನು ಇದು ಏನಾಗಿದೆ ಇಲ್ಲಿ ಇದು ಇಟ್ಬಿಟ್ರೆ ಕಾಣಿಸೋದೇ ಇಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ನಿಂತ್ಕೊಂಡೆ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ.
No.
And considering my lord, my disability, I'm little short, I can't.
Oh, sir.
Sorry, I did not mean
ಇದು
it.
ಇಟ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಕಾಣಿಸೋದೇ ಇಲ್ಲ.
In fact, at that screen, I don't know why they.
ಏನು ಇಷ್ಟಿದ್ದಾರೆ,
It's not required.
ಕೂತ್ಕೊಂಡ್ರೆ ಏನು ಕಾಣೋದೇ ಇಲ್ಲ ನನಗೆ.
Even that is a waste.
ಎಕ್ಸಾಕ್ಟ್ಲಿ, ಇದು ಯಾಕೆ ಇಟ್ಟಿದ್ದಾರೆ, ಏನು ಇಟ್ಟಿದ್ದಾರೆ, ಎಷ್ಟು 1, 2, 3 ಎಲ್ಲ ಇಟ್ಟು
No, I didn't mean to interrupt you. I'm sorry.
Never. Don't casually.
No.
Humor in the court.
Yes.
No, I understand. The minimum courtesy I have to extend. my lord.
Yes, sir. No, just I said humor in the court.
I know. I appreciate.
The objection I submitted, the objection filed with the Lokayuta before this honorable court in the previous writ petition. I'll just take my lord's attention to that statement. Yes, my lord finally said
Same police 16 page.
on page 16, my lord.
Page?
16.
Objection statement.
Policy. So, objections filed for the writ petition by the Lokayuta. May I take my lord's attention to paragraph 8 onwards. On page 17.
Yes, sir.
Regarding para 10D, it is submitted that it is not correct to allege that the directions to remove the compound was given by these plan, the city level plans, city level plans, as also the district planning plans. In the background of the planning ideology, the institution had asked the BDA to prepare and furnish sketches for development of the Jakpur plantation area based on the district plans. It is admitted that the sketches prepared have been discussed with planners of the BDA and the complainant, Varsri and Virana, and modification in the area plans have been suggested in the larger interest of the planned development of the area. It is not correct to allege that the modified plan was suggested for adoption as proposed by the complainant. The plans evolved within bracket sketches prepared are only planning solutions worked out based on the existing sital situation and the district plans approved by the government. Approved by
So
the
what is the approved plan now, sir? The current approved plan by BDA for the layout?
2015 is the plan, my lord. No, however, it is for the BDA to place it before the court. I have stated that now 2031 master plans,
Sir, let me put it this way, sir, just to cut short, just to save some time, that's all. Still, if you want to argue, I will hear you. See, your case is access to your property is not granted in accordance with law. Number one. Number two, we can say the layout plan that has been approved for Jakpur plantation area is not done in accordance with law. This is the only two contentions that you can have. Anything else?
yes,
These are the only two contentions you can have.
layout as such is not yet approved.
Okay, we can drop. For a moment, you think
What I
only.
respectfully submit is,
Sir, these are the only two things that you can have, sir. Access to your property is not granted in accordance with law.
no, the master plan of 1995, my lord, provides a 60 feet width road to my land. 1990.
Sir, that's what I'm
Yes,
telling you. See, your case is access to your property is not granted in accordance with law.
yes,
Number one.
according to 1995.
Number two, the road adjoining your property are not maintained in accordance with law by the BDA. Correct? With regard to the entire layout, speaking from the layout point of view, because why roads? It's not just your property. The roads are all interconnected roads.
It is for the
Okay,
benefit
there has
of-
to be flow of traffic.
It is for the benefit of the general public,
General
not
public.
only mine.
Okay, these are the only two runs that you can have. For that, reading of internal communications will not come to your rescue, sir. Okay, because finally what we have to look into is the final plan that has been approved by the BDA is in accordance with law or not. That is what has to be looked into. Now, the Lokayukta and all comes to your rescue only to the extent of demolishing the compound wall, which has been done, number one.
Unauthorized really.
Yeah. Which has been done, and then providing access to your property. Okay, now, in accordance with law or not, we remove that access wall now, that is not in dispute now. Access to your property has been provided in accordance with law or not. It depends on, see, it is not your case that road is not being constructed in violation of the plan sanctioned by the BDA.
As on today, nothing has been done.
Anyway, we can make that observation. Road will be formed in accordance with what the BDA has
Of course,
proposed.
my lord. And we have
That will
relinquished,
be part of the order.
and we have relinquished the road area,
Okay,
my lord, in front of
whatever it
BDA.
is. You are required to establish that the present approved plan by the BDA is in violation of the master plan.
Not a whisper.
Okay, that you are required to establish, sir.
That is what I am trying to do it, my lord. before
Sir,
the court.
for that, no need to get into Lokayukta proceedings.
No, it started from there, my lord.
It's
Therefore,
okay. See,
What happened, my lord?
sir,
in 19
listen, when it comes to, sir, when it comes to these aspects, see, when we speak of rule of law, okay, law has to be based on reason. It is the function of the legislature. Implementation is the function of the executive. Only interpretation is given to us. Whether it is in accordance with law or not is given to us.
Otherwise, the matter.
Whether the policy is erroneous or not. Okay, unless it's, I mean, policy can be this or that. That is left to the legislature and the delegated legislation to the executive. Now, for that, people have to be sensible who exercise their franchise. We cannot encroach upon the territory of executive, sir. In this case, legislature does not come in, the executive. Now, from judicial activism, the pendulum is swinging back towards judicial control. I mean, restraint. Godaita.
On the basis of the rules framed by the.
I'll tell you, it's shameful, but it's a fact. ಯಾವ ಲೆವೆಲ್ಗೆ ಜುಡಿಷಿಯಲ್ ಕಂಟ್ರೋಲ್ ಬರ್ತದೆ ಅಂದ್ರೆ for some post, class 2 officer and a high court judge are eligible. That is the amount of
Now we'll.
no. I'm telling you, in life, what is happening in the country today? You want, see, complete redressal by encroaching upon the purview of the executive can't be done by the high court, sir, by the judiciary. We can only look into whether
Violations of the laws and.
that's it. Any law has been violated or not.
In the instant case, my endeavor.
Whether that delegated legislation, the plan, it can be A, it can be B. A is better than B. Even if we feel so, we cannot substitute our wisdom with that of the wisdom of the executive in this particular case.
Whether executive have done or doing according to law is the question. In the instant case, it is not, is my.
So whatever the resolution, internal communications that might have been passed with the BDA, unless the final decision taken by the BDA, that is approving the plan, is in violation of the law, the statute, we can't interfere. Show me how, what is the first, show me what is the final approval of BDA and how that is in violation of law.
5/3/2024, page 45.
He is arguing, sir. Let him say. Really, sir.
According to me,
Sir, whatever you say,
yes,
maximum we can sympathize with you. Okay.
yes, my lord.
See, it must speak to common sense.
Yes, first,
That the road has to be wide enough, the connecting road to that particular extension from the main road, from the international airport road, okay, has to be wide enough. May speak to common sense, but we cannot substitute our wisdom with the wisdom of BDA. If the BDA feels in accordance with law, only 10 feet road is sufficient. We need to have cars with ground clearance to clear the ditches also, so that they can go to the side while passing in opposite direction. We can't help it, sir.
we are seeking the help of the court, my lord, in doing.
It's unfortunate, but it's true. Show me the law,
Yes,
how this court can interfere. See, one thing, let me make it clear. We cannot substitute our wisdom with the wisdom of BDA. Okay, I'm not going to interfere. Number one. If you are able to show me that the order passed by BDA is in violation of the statute, is in violation of the approved master plan, I will definitely interfere. But if the master plan itself is changed under section 14A,
straight away, if I want to say,
under section 14A or whatever under the Town and Country Planning Act, again, then you are duty bound to show that it is in violation of the statute. Failing which, we can't help you. The question is, you have been provided access. Now, that access, show me the plan, sir. What is the plan approved by BDA? The final thing under challenge.
ನಾವು ಯಾವ್ದು ಪ್ಲಾನ್ ನಾವು ಏನು ಕ್ವೆಶ್ಚನ್ ಮಾಡಿಲ್ಲ ರೀ. ಯಾಕೆ ನಾವು ಹೇಳಿದ್ದು 1995 ಪ್ಲಾನ್ ಪ್ರಕಾರ 60 feet ರೋಡ್ ಕೊಟ್ಟಿದ್ವಿ. Suddenly under the influence they cancelled it. Again now they say they have submitted one plan saying that 60 feet road will be provided before the Lokayukta, which was signed by the VD officers, not Lokayukta. This is what I mean to say. When the VD officers, development officers, and
What is Annexure F, sir?
Yes, my lord. That is their own resolution. I am not coming in the way of all that I am requesting is to implement that. That's all. Beyond that, nothing. F is, my lord, the resolution that is not resolution. Yes. My lord, there was another resolution 70 of 2018 that was cancelled by them in this.
No, you are sought for quashing of Annexure F, no, sir.
Yes, yes, my lord.
Yes.
Yes.
That is inquest number 41.
How is it?
45,
What is 41 then?
45,
45.
45 is it?
Annexure F.
They want to rescind from their own resolution that is under challenge, my lord, before this court. I may take my lord's attention to page 54, paragraph 4 and 5.
What happened after 5-3? What is it? 7-3. Young election.
Statement of objections to the petition.
Sir, RMP 2015 prakara, does it violate it or not? No, RMP 2015, does it safeguard your interest or not, sir? RMP 2015, does it safeguards your interest or not?
No, my lord. That is the reason why, my lord, all these proceedings last about more than a decade and a half.
Do you have RMP 2015 with you? Can you produce it?
ಇಲ್ಲ ನಾನು ಕೊಟ್ಟಿಲ್ಲ BD ಏನು ಮತ್ತೆ ಇಲ್ಲಿ ಕೊಡಪ್ಪ ಫಸ್ಟ್ ನಾನು ನೋಡಿದ್ರೆ ಏನ್ ಸರ್
ಅಲ್ಲ, RMP 2015.
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ, ಗ್ರೌಂಡೇ ಇಲ್ಲ.
That's okay, sir, we can examine it. See, you can come to page number 54, clause 3.
Yes,
ಇದೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಅಡಿಯಲ್ಲಿ ಈಗ ಚಾಲ್ತಿಯಲ್ಲಿರುವಂತ ಅನುಮೋದಿತ ಮಹಾಯೋಜನೆ RMP 15.
ಅಲ್ಲ, RMP 2015 ಇದೆಯನ್ರಿ ನಿಮ್ಮ ಹತ್ರ?
ಇದು ಕ್ವೆಶ್ಚನ್ ಅರೈಸ್ ಆಗಿಲ್ಲ, ಸೊ
ಏನೂರು ಕೊಡ್ಬೇಕು ನಮ್ಮ ಹತ್ರ ಇದೆ, ಅಲ್ಲಿ ಕೊಡ್ತೇನೆ, ಆದ್ರೆ ಎಲ್ರಿಗೂ.
No, sir, what I am thinking is, see, RMP 2015, Jakkur plantation area, they might not have envisaged development at all. See, when was RMP 2015 passed?
2007.
2007. ನಿಮಗೆ ಜಕ್ಕೂರ್ ಎದುರುಗಡೆ ಕನ್ವರ್ಟೆಡ್ ಸೈಟು 500 ರೂಪಾಯಿ ಬೆಲೆ ಇತ್ತು ಅವಾಗ ಚದರಡಿ.
In 1995 itself, 60 feet road is shown in the map. In the revised master plan, 1995, 60 feet width road was shown to access to my land. And in 2015, that road was removed.
ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು ಅವರು.
Therefore, the complaint rose before the Lokayukta and all these proceedings.
Correct. But the point is, they're at liberty to do so. BDA has the liberty to do so, number one. Number two, what I'm looking at is, see, because this 2015 RMP came in 2007. Okay. 2007, nothing much was there beyond Hebald flyover.
Correct.
Okay. The rate probably was around 500 rupees per square feet in and around Jakkur airport.
ಅವಾಗಲೇ ಶುರುವಾಗಿದ್ರೆ ಏರ್ಪೋರ್ಟ್ ರೋಡ್ ಅಂತ.
Correct. ಅವಾಗ see, it was around 500 rupees per square feet converted land ನಾನು ಹೇಳ್ತಾ ಇರೋದು. Now it is 10,000, 15,000, it's like that, in that particular range. That is the way Bangalore has grown. Okay. They could not have envisaged a bigger road at that particular point of time in these areas. Now, if you can show somehow that access to the main road in any extension has to be of this road width with such and such a difference. And it is not being present over here. So, and then again, there are two things, sir. One is access to your property.
That is one aspect of it.
Then access to the extension itself. That's why I said it so. If your ground is only regarding access to your property, probably you don't have a case.
ಪೆಟಿಷನ್ ಇರೋದೇ ಎಷ್ಟು ಸ್ವಾಮಿ?
Access to your own property, they have left around 9.5
Yes, 35
meters road.
feet, 35 feet.
These plans, either
95, 2005 or 231 and all that. It is not prepared on my instance or somebody's instance. It is according to the plans, town planning.
Yes, RMP 2015 ನ violate ಆಗುತ್ತಾ sir? Violate ಆಗಲ್ಲ.
ಅಲ್ಲ 31 actually ಅದರಲ್ಲಿ incorporate ಮಾಡಿ ಅಂತ ಕೊಟ್ಟು. ಆದ್ರೆ 31 is withdrawn now by the government.
What can be done, sir?
Therefore, that should be implemented in 2015.
That
Previous
we
one.
cannot give a direction, sir. It is left to the discretion of the government.
I'm not seeking for any direction like that, but only to try, find out that very illegality is committed by removing the road which was there already in 1995 itself, long ago. And that 1995 plan is again a public plan, my lord, prepared by the concerned.
Yes, sir. Anything else, sir?
State, my lord.
Anything else?
Yes, ma'am.
Yes.
Kindly see the order of this Honorable High Court itself in the previous writ petition,
Yes, sir.
which is the
Page number, sir.
kindly see, my lord, page 31.
Of the.
Page 31 of?
The 16/10/2004 ಅಲ್ಲಿ ಕೊಟ್ಟಿರೋದ್ರಲ್ಲಿ
ಹ್ಮ್.
page 20. Page 31 ರೀ. So 8 ನಿಂದನೇ ತಗೋ.
31 of?
Or 30, my lord may say, paragraph 8.
Hmm.
Having heard of the learned counsel for the parties and on perusal of the complaint lodged by the fifth respondent, it is seen that the grievance of the fifth respondent is that since the officials of the BD and the Deputy Commissioner Bangalore Urban District did not consider the complaint lodged by him, he approached the Lokayukta to give protection to him and his property and to implement the provisions of law. Lokayukta has secured reports from the BDA as well as Deputy Commissioner, and a spot inspection was also conducted in order to find out whether the compound constructed by the petitioner was without permission and thereby prevented the ingress and egress to the property of the fifth respondent and other general public. Having found that the entire area is encroached for the construction of the compound in violation of the rules as there was, there is no other area available for the ingress and egress, not only to the property of the fifth respondent, but also to general public. The Lokayukta has felt that while granting the plan to the petitioner developer, the developer was required to leave a road according to the revised comprehensive development plan 2015, and therefore.
Sir, that has been done now, sir, by way of imputed order. Please read para 9, sir.
ಅದು ಕೊಟ್ಟಿಲ್ಲ ಈಗ 15 ಅಲ್ಲಿ ಆ ರೋಡ್ ಇದನ್ನು ತೋರಿಸಲಿಲ್ಲ ಅವರು. Therefore, the directions have been issued. In the circumstances, we are of the view that the nature of the direction issued by the Lokayukta cannot be treated as a decree, and the same has to be implemented in its true spirit. As per section 12(1) of the Act, the direction can be issued to carry out and implement the provisions of law to rectify the mistake, if any, committed by the officials of the BDA and the Deputy Commissioner. It is also that ensure that the grievance of the fifth respondent is properly considered by the authorities and for taking action against the petitioner in accordance with the law by following the procedure contemplated either under the Karnataka Municipal Corporation Act or under the Bangalore Development Authority Act or under any other statutory provisions which are enforceable in accordance with law. This is the order of this Honorable Court.
Yes, sir.
When report of 12(1) was questioned before this Honorable Court. And this order of this Honorable Court is accepted by the Supreme Court while dismissing the SSP, which my lord finds it on the next page itself.
Fine, sir.
On page 33.
Now show me how the impugned order is violative of this order.
It is violative because the 133 resolution which is passed by the BDA, what is the reason given by them to say now they want to rescind from it? That is the illegality. Because there must be some reason. Logic and reason is the crucial points.
Yes.
In the change. Change should be for better,
Yes,
not
sir.
for worse.
Yes,
Now,
sir.
in the instant case, while they say they want to rescind from this resolution passed by them, 133, what is the reason given? No reason. Without assigning any reason, whether the authorities like this could say, well, I do it and I change it. I do it, I cancel it. This is the what is a violation of law.
That is page number 40. right?
45.
Just a minute.
That is what is impugned, my lord, in the writ petition.
Not 45, my lord.
40,
The resolution,
of the-
according to you,
45, sir.
is 40,
Of the writ petition.
45 of the writ petition.
45 of the.
Yeah, that is what is challenged.
That is what is telling. They say ಹಿಂಪಡೆಯಲು
Yes, sir.
ಹಿಂಪಡೆಯೋದಕ್ಕೆ ಏನು ಹೇಳಿದ್ದಾರೆ ಅದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
Yes, sir.
Because that will adversely affect the interest of the petitioner. In substance, I may say, without assigning any reason, acceptable reason is second. Any reason, they say, I want to withdraw the resolution already passed by me. Therefore, under these circumstances, we have questioned before this honorable court. Before that, we have also filed another writ petition directing them to implement this resolution. That is also pending before my lord. It is connected with this writ petition.
That becomes irrelevant.
Huh?
That becomes irrelevant.
Relevant or irrelevant, we have filed it to say,
No, now it becomes irrelevant.
yes, considering this writ petition if present,
Yes,
it may become infructuous. That's
Yes.
all I could say. Therefore, in the writ petition also, the same plans, everything is produced before the honorable court. And we have requested this honorable court to pass that
yes, other matters will not reach, you can take the date.
resolution. My lord,
You people need not wait. You can take the date from the court officer later. Date or whatever weeks. ಆಮೇಲೆ ಕೇಳಿ ಈಗಲ್ಲ. You need not wait ಅಂತ ಹೇಳಿದೆ. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕು ಅಲ್ಲೂ ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡೋ will be passed. Yes.
ಯಾವುದು?
End of the list ಒಂದು ತಗೊಂತೀನಿ ಅಷ್ಟೇ.
One submission, my lords, in serial number 63.
Srikanth mentioned it to the court officer after the court.
No,
rises.
well, my lords, your lordships indicated that it should be posted in, my lords, for hearing on IA. My lords, it is not listed, it's in B group, my lords, your lords may indicate that be listed in.
Doesn't matter,
Anyway.
let it be listed.
My lord, serial number.
ಅದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಆಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಅಪ್ಪ.
Please, my lords, I would.
Wait ಅನ್ನೋದು ಕೇಳಿದೆ ರೀ. Not to interrupt the.
I'm sorry, my lords, your lords are indicating, my lord, that's the reason I made a mention, my lord.
Mention it to court officer, it will be
Please,
done.
my lords, please.
Yes, continue sir.
Yes.
ಹೇಳಿ sir.
ಆಯ್ತು, ಎಲ್ಲಾದ್ರೂ ಹೇಳ್ತಾರೆ ಸಾಹೇಬ್. The other writ petition which I refer to, my lord, is
ಕೊಡಿ ಇನ್ನೊಂದು writ petition ಕೊಡಿ.
ಏನದು?
to consider the request made by the father of the petition through so and so legal notice 20, by resolution number 133 of 19 dated so and so. No, this, they want to cancel it. It is their resolution which I am requesting to implement.
Yes sir.
No, they intend to cancel this resolution,
That's what he's looking at now.
which is about 4 years old. Now, what is the reason assigned
but
for
it's
doing
from,
so,
this is of
as I submitted to
2024.
my
Yes sir,
lord?
got it.
No reason.
ಇದೇ ಹೇಳ್ತಾರೆ. ಮತ್ತೆ?
Of course, in. And this, we have produced that plan now produced before the honorable court, both in this writ petition and also in the connected writ petition. My lord finds that this road which is shown already in this plan is approved by the BDA only, not by Lokayukta. And this is submitted before the honorable Lokayukta also, and which is also referred to in the report of 12-1 of the Lokayukta. Under these circumstances, what is the justification now for the BDA to say, I'll rescind from that 133 and implement some other plan? And secondly, when an order was passed, they themselves have given time and again that submit according to this 133 resolution. The 4 endorsement, I believe, I have produced and I read out 3 out of them. Under these circumstances, there is total illegality on the part of the BDA, and therefore we are before my lord. Therefore, I only request to see that 133 resolution passed by the BDA be implemented. We are not requesting that the court to pass any order except saying that there is a resolution passed by you, please implement it.
Yes.
Beyond that, I may say nothing more and nothing less in these 2 writ petitions. Grateful.
For further hearing at 4 o'clock tomorrow, sir. I'll dictate orders tomorrow.
I,
Third.
please, read first.
For further hearing. 4 PM ಅಂತ ಹಾಕಿ.
Your Lordship, kind permission, my lord.
Yes, sir.
77, my lord.
ಇದನ್ನು ಇಟ್ಬಿಡಿ court office.
77 ಅಲ್ಲಿ
ಅದನ್ನ ಇದೇನು ಬರ್ಕೊಂಡಿಲ್ಲ. ಇದನ್ನೇ ಹೇಳಿ ಸರ್.
77, my lord. 77 ಒಂದಲ್ಲಿ ನಾನು ವೆಕೇಟಿ ಹಾಕಿದ್ದೀನಿ, ಬಟ್ ಇದು ಫೈಲ್ ಲೇರಿಂಗ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ದೇರ್ ಇಸ್ ಅರ್ಜೆನ್ಸಿ ಇನ್ ದಿ ಮ್ಯಾಟರ್.
ತಗೊಳ್ರಿ ಯಾವ್ದಾದ್ರು IAS ಇದೆ.
ಅಲ್ಲ 7ನೇ ತಾರೀಕು
ಸರ್ ಯಾವ್ದಾದ್ರು IAS ಇದೆ ಅದು ಹಿಯರಿಂಗ್ ಆನ್ ಇಂಟರ್ಲಾಕ್ಯುಟರಿ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಕೊಡಿ. ದಟ್ ಸ್ಯಾಟಿಸ್ಫೈಸ್ ಯು.
ಅಲ್ಲ 7ನೇ ತಾರೀಕು ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿ. ನಾಳೆ ಇಲ್ಲ ಬೇಡ. ಅಲ್ಲ 7th 8th ಆಗ್ಬೋದು, ಬಟ್ ಆರ್ಡರ್ಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಬರ್ಲಿ.
ಆಯ್ತು, ಇಂಟರ್ಲಾಕ್ಯುಟರಿ ಅಪ್ಲಿಕೇಶನ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹಾಕಿ ಅಷ್ಟೇ.
77.1.
ಯಾರಿಗೆ ಏನ್ ಬೇಕು ಕೊಟ್ಬಿಡಿ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಕರ್ರಿ.
8ನೇ ತಾರೀಕು.
My lords, in this matter,
Hmm.
my lords, annexure A, I have challenged annexure A, my lords. The notice issued by the Upa Tahsildar. My lords, ಏನಾದ್ರು
ನಿಮ್ಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪಿಯರ್ ಆಗಿ 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 ಈ ಕಡೆ ನಿಂತ್ಕೊಂತೀರಿ, ಈ ಕಡೆ ಬನ್ನಿ.
ಜಾಗ ಬಿಡಿ.
He appears for respondent always. He goes and stands there even when appearing for petition.
Sorry, my lords. Tahsildar notice ಕೊಟ್ಟಿದ್ದಾರೆ. ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಕಡಂಗನ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿದೀನಿ ಅಂತ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ವಿತೌಟ್ ಹಿಯರಿಂಗ್ ಮೀ, ಮೈ ಲಾರ್ಡ್ಸ್. ವಿತೌಟ್ ಗಿವಿಂಗ್ ಅನ್ ಅಪರ್ಚುನಿಟಿ ಆಫ್ ಹಿಯರಿಂಗ್.
ಎಲ್ಲಿದ್ದಾರೆ ನೋಟಿಸ್?
ಮೈ ಲಾರ್ಡ್ಸ್, ಅಟ್ annexure A, my lords. On 16/10/2024, my lords, they have issued notice. And my lords, date for fixed, my lords, is 22nd. Without giving me an opportunity for reply also, my lords. ಕಡಂಕ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡಿದೀವಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. The survey number shown in the notice also is different. My survey numbers are, my lords,
Yeah, after all, it's a notice. Go and explain.
my lords, ಈಗ ಅವರು ಮೊನ್ನೆ 14th ಬಂದಿದ್ರು JCB ತಗೊಂಡು ನಾವು ಗಲಾಟೆ ಮಾಡಿದ್ದಕ್ಕೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತು, go and explain.
Yes, my
ಯಾವತ್ತು?
till, my lord, 22nd, tomorrow itself, my lords. For interim order, my lords, not to dispose.
Interim orders. ಬರ್ಕೊಳ್ಳಿ.
My lords, not to dispose.
ಬರ್ಕೊಳ್ಳಿ, I'm going to dispose it off. AJ accepts notice for respondents because 1 week ಜಾಸ್ತಿ ಟೈಮ್ ಕೊಡಿ.
Can be taken as a.
1 week ಜಾಸ್ತಿ ಟೈಮ್ ಕೊಡ್ರೆ.
Yes.
The case of the petitioner is that he is the owner of ಅಲ್ಲ, ಈ case of the petitioner ಬೇಡ ಹೊಡೆದಾಕಿ. ನಿಮ್ದೆಲ್ಲ ತಪ್ಪು ಕನ್ನಡ ಬೇರೆ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿಸಿದೀರ.
ಅದೇ ಇಲ್ಲಿ ತಿಳುವಳಿಕೆ notice.
ಶುದ್ಧ ಕ್ರಯಕ್ಕೆ ಅಂದ್ರೆ ಶುದ್ಧ ಪ್ರಾಯಕ್ಕೆ ಅಂತ.
My lords, in the hurry, my lords, yesterday morning I got a case, my lord, and I filed today. Sorry, my lords.
ಪಹಣಿಗೆ ಸಹನೆ.
Sorry.
ಯಾರು ಕೊಟ್ಟಿರೋದು ತಿಳುವಳಿಕೆ ನೋಟಿಸ್?
My lords, Upa Tahsildar, my lords, has no power at all, my lords, to issue the notice.
ಯಾವ ಸೆಕ್ಷನ್ ಕೆಳಗಡೆ ಕೊಟ್ಟಿರೋದು?
Section ಏನು ಇದ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
Section not mentioned.
Not mentioned.
ಆಯ್ತು, ಬನ್ನಿ.
Explanation ಇಲ್ಲ, ಏನು ಇಲ್ಲ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ
AG accepts notice for respondents. Agreed by the notice dated so and so, bearing number so and so, issued by second respondent, in brackets wide annexure A to the writ petition, bracket close. The petitioner has preferred the writ petition. Full stop. The next, for the impugned notice has been issued to the petitioner on the ground that he has encroached 5.75 acres of land.
No, my lords, that is survey. ಅವ್ರು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅವ್ರದ್ದು ಕಂಪ್ಲೇಂಟ್ ಅಷ್ಟೇ ಅದು.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಏನ್ ಬಂತ ಹೇಳಿ? The impute notice has been issued to the petitioner on the ground that he has encroached 5.75 acres of land in survey number
238/67.
238/67 of category village. Full stop. Next para.
My lords.
Allah continue ಮಾಡಿ. Full stop. It is further submitted that the petitioner has to provide all the necessary documents by 11 AM on 22nd 10/2024. 22nd 10/2024, failing which the illegal encroachment would be removed. Full stop. Next, Allah continue ಮಾಡಿ. Full stop. It is submitted that the said notice has been issued without jurisdiction and that petitioner has not encroached the lands as alleged. Petitioners have not encroached the land as alleged. Full stop. It is also submitted that if adequate time is granted, petitioner would provide the necessary documents to show that he has not that they have not encroached any property as alleged in the notice, and also that respondent number 2 does not have the necessary powers to issue such notice. Full stop. Next para. Per contra, the learned AGA upon instructions submits that there has been an encroachment as alleged, and he further submits that any proceedings to be initiated against the petitioner will be done so by the authorized person in accordance with law. And the impute notice has been issued only to find out the truth of the matter.
Please treat it as a.
And to initiate the necessary inquiry required. Full stop. Next para. Under the circumstances, I am of the opinion that interest of justice would be met if petitioner is granted adequate time to file his reply to the impute notice, and a direction is issued to the respondent to consider the reply of the petitioner in accordance with law and pass appropriate orders thereafter. Full stop. Hence the following order. Petitioner is granted time till 2 weeks.
Please.
2 weeks between date kodi. Fifth, 5/11/2024 to issue necessary reply to the impute notice at annexure A to the writ petition. Full stop. Petitioner is permitted to take up all necessary contentions, including the jurisdiction of respondent number 2 to issue such notice. Next para. Respondent number 2 / authorities concerned will consider the reply of the petitioner and the documents produced along with it in accordance with law and pass appropriate orders thereafter only in accordance with law, and take action only thereafter. Full stop. Next para. Till a decision is taken by the competent authority in respect of the alleged encroachment made by the petitioner, no coercive steps will be taken against the petitioner. Writ petition disposed of accordingly.
My lord, small correction, my lords. That is not 5 acres, 75 guntas, my lords. What happened is, adjacent to that, my lords, there is a kadanga. That is encroached, my lords. Not 5
ಅವ್ರು
acres.
ಹೇಳಿರೋದನ್ನ ಹೇಳಿದಿನಪ್ಪ.
ಸದರಿ ಜಾಗದಲ್ಲಿ ಒತ್ತುವರಿ ಅಂತ ಆಗಿದೆ.
ಆಯ್ತು.
My lord, ಸದರಿ ಜಾಗದಲ್ಲಿ ಒತ್ತುವರಿ ಗ್ರಾಮ
ಅವ್ರು ಹೇಳಿರೋದನ್ನ ಹೇಳಿದೀನಿ, ನೀವು
Yes, my
ತಗೊಂಡೋಗ್
lord.
ಕೊಡಿ. After all,
Yes, my lords.
you are safe.
I'll do that.
Yes, disposed of.
Macho.
In the last matter,
My lords.
230 matter, interim order may be extended.
ಆಯ್ತು. ಇದು ಪ್ರೀವಿಯಸ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಅದೇ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅಂತ ಆಯ್ತಲ್ಲ, ಅದರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ if any is extended till next date of hearing.
My lord,
Obliged.
order may be uploaded today, my lord.
Yes, it will be done.
Kind leave, my lord.
Macho.
ನಾಳೆ ಆಗುತ್ತೆ ಮೋಸ್ಟ್ಲಿ.
Serial number
Yes,
73, my lord.
There is abuse of process of law by the petitioners, my lord. They have approached this court also and they have obtained stay before the DC court also, my lord. So I want to protest
Not a
notice of Tuesday, Wednesday preliminary hearing.
ನಾಡದ್ದು ಮತ್ತೆ ವೆಡ್ನೆಸ್ಡೇ
Preliminary hearing ಅಲ್ಲಿ sir. ಇದು B group ಅಲ್ಲಿ ಇದೆ.
ಆಯ್ತು ಅದನ್ನ ಹಾಕ್ಸಿ ಅದು
73. Obliged.
Much. Petition.
Hello, court officer? Ma'am? Disconnect ಮಾಡ್ತೀನಿ. ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ. ಆಗಲ್ಲ ಬಿಡಿ. ಕೋರ್ಟ್ ಆಫೀಸರ್? ಇಲ್ಲ ಇಲ್ಲಿ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ ಕೇಳಿಸಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್? ಶ್ರೀನಿವಾಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಕೇಳಿ ಮ್ಯಾಮ್.
ಹೇಳಿ ಲಕ್ಷ್ಮಿ ಮೇಡಮ್.
ಹಾ, ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 32 ಇನ್ ದ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ.
ಲಿಸ್ಟ್ 2 ನಲ್ಲ?
ಹಾ, ಕರೀಲಿಲ್ವಾ ಸರ್ ಅದು?
ಹಾ?
ಕರೀಲಿಲ್ವಾ ಅದು?
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ?
ಇದು ಲಿಸ್ಟ್ 2 ಸರ್, ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಂತ ಇತ್ತಲ್ಲ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ ಮೇಡಮ್, ನೀವು ಕನ್ಫ್ಯೂಸ್ ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ? MI ಅರುಣ್ ಸಾಹೇಬ್ರ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದು.
ಹೌದು ಹೌದು, ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಂತ ಇತ್ತಲ್ಲ ಸರ್, ನೋ ಅಡ್ಜರ್ಮೆಂಟ್.
ಕಾಲ್ ಮಾಡಲ್ಲ, ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಹಾಗೆ ಇರುತ್ತೆ. ಅದರಿಂದ ನಾವು ಒಂದ್ 10, 15, 20 ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಗೆ ನಾವು ತಗೊಂತೀವಿ ಡೈಲಿ. ಆದ್ರೆ ಅದನ್ನ ರೆಗ್ಯುಲರ್ ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ನಾವು ಕಾಲ್ ಮಾಡಲ್ಲ, ಹಾಗೆ ಇರುತ್ತೆ. ನೀವು ರೆಡಿ ಆಗ್ಲಿ, ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೋಬಾರ್ದು ಅಂತ ದಾಖಲೆ.
ಓಕೆ, ಅದ್ರಲ್ಲಿ ಇಂಟರಿಮ್ ಸ್ಟೇ ಇತ್ತು ಸರ್, ಅದಕ್ಕೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿರುತ್ತೆ.
ಮಾಡಂಗಿಲ್ಲ, ಅದು ಕೋರ್ಟ್ ರೀಚ್ ಆಗಲ್ಲ, ಜಸ್ಟ್
ಓಕೆ,
ವಾರ್ನಿಂಗ್ ಅಷ್ಟೇ ಅದು.
ಸರಿ ಸರ್.
ಓಕೆ
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.